Keynote speaker today, Professor Louis de Coker. Professor de Coker holds a chair in law at the La Trobe Law School in Australia, where he is the coordinator and program leader of the La Trobe Law Track team. He's also a senior financial crime policy consultant to Consultative Group to Assist the Poor and an extraordinary professor in the Department of Commercial and Labor Law of the University of the Western Cape. He has held visiting positions at several institutions, including the Institute of Advanced Legal Studies of the University of London, George Washington University, Deakin University in Australia, and the University of Florida. He has advised on a range of laws and regulations in many countries, including Jordan, Kyrgyzstan, Namibia, South Africa, Uganda, and Vietnam. His research on integrity laws and their impact on financial inclusion has been cited in publications of a number of international bodies, including the World Bank, IMF, the Financial Action Task Force, and the Basel Committee on Banking Supervision. The title of his address is COVID-19, Digital Financial Services and Digital Identity, Implications for the Future. We are honored to have Professor de Coker as our keynote speaker today. Over to you, Professor de Coker.
Professor Kasim, thank you so much for that generous introduction. Professor Chitimira, thank you for the invitation. Ladies and gentlemen, I am honored to be with you this morning. The topic that I wish to introduce for purposes of this keynote is one that links in, I believe, a variety of different ways with the topics both discussed yesterday, but also some that are slated for very interesting papers to be delivered today. Now, before I proceed, I just want to ask whether you can see my slides at the moment.
Yes, we can see them. Thank you.
Perfect. Thank you so much. Then I'll move on. This kind of brief remarks that I'll make in the next 20 minutes are aimed at weaving a narrative around identity, but also reflecting on anonymity linked to e-commerce and COVID, and then to commercial law scholarship, which at first glance may be topics that may not seem perfectly aligned, especially for a conference on commercial law. But technology, and especially COVID, being key topics for this conference, have really woven all of them together in a way that I think will require many commercial law scholars to consider implications also for their broader scholarship and engagement with the themes that they address, also in a number of the papers that you will be listening to today. Now, as a starting point, my point of departure is the Anti-Money Laundering and Combating of Financing of Terror, kind of abbreviated to AML-CFT, standards of the Financial Action Task Force. Now, that's the global intergovernmental task force that sets the standards that all countries globally must ensure that their laws require and embody, and creates obligations for banks, financial institutions in general, and non-bank financial institutions in relation to compliance. Now, just to make it easy in this presentation, I'm not going to refer to financial institutions and designated non-financial institutions. I'm just going to refer to banks, but do bear in mind that this has a much broader footprint than only banks. Now, these standards, we've engaged in South Africa for more than 2 decades now. And it's given rise to very specific problems in developing countries. South Africa led the research in the 2000s in a variety of ways, weaving together multidisciplinary research pointing to unintended consequences of these standards, especially on financial inclusion, and was able to generate the research that convinced FATF that especially their rigid identity verification rules actually could have a negative impact on financial inclusion, which in turn undermines its own integrity, financial integrity objectives. In 2012, therefore, they adopted a risk-based approach that allows for the simplification of identity proofing, making it easier for people to prove who they are, but that only applies where risks are assessed in terms of a formal risk assessment as lower. But despite this, in 2021, barriers still remain for those without means to prove their official identity. We have, for example, close on 1 billion people globally who do not have access to documents verifying official identity, or may not even have an official identity assigned. An official identity in this context is a bureaucratic identity. It is how you are known to and by the state. Now, that causes friction in terms of the use of digital financial services, which has been the focal point of broadening financial inclusion in Africa and in developing countries globally, because they need not only means to allow people to identify themselves online, digitally, electronically, but because we're working with groups of people that also face geographic barriers, accessing specific branches of institutions, we also need the possibility of remote account opening. Now that spawned something called eKYC. KYC there is standing for Know Your Customer, and this refers to electronic Know Your Customer policies and also the need for digital identity. But COVID increased that need since early last year, because suddenly there were also very important health reasons why people needed to be able to verify their identities without having contact with other persons. This is not a new problem, and many of you will be familiar with this cartoon. It made the drawer of the cartoon, Peter Steiner, more than $250,000 in royalties. On the internet, one dog tells the other quite excitedly, nobody knows you're a dog. And that is the problem. If we are engaging with one another using digital means, how do we make sure that the person on the other side is actually who we think they are? And because we're not certain about that, we've seen the rise in romance scams and all of the other scams that we are so familiar with. Now, eKYC does not have specific meaning, but it generally refers to some form of identity verification model where some part or aspect of it is electronic or digital, and meaning it's not done in person. So Malawi and Tanzania provides us with very good early examples where they allowed a person who wanted to enroll in a mobile money product to verify themselves by having a photograph taken of their identity document and having that photograph sent. Now, to ensure that the photograph is actually of that person, it had to be taken by an agent that was assigned. So it had integrity, but it meant that someone didn't need to go to a bank branch to show a document. India kind of escalated eKYC to a whole different level. Now, India, like most developing countries, 10 years ago, lacked a comprehensive national identity system. If I say 10 years ago, let's say mid-2000s, because in 2009, it established the Unique Identification Authority of India, and then launched its Aadhaar, National Biometric Identification System, in 2010, which has been spectacularly successful. In that time, they've enrolled more than 1.3 billion people and provided them with unique identities. They also allowed eKYC in 2016. Now, this is a photograph I took in a little village just outside Mumbai. The white device is a finger scanning device. If a person approaches a bank agent who's issued with this mobile phone-like device, that's actually a bank branch in your pocket, and asks to open an account, they could provide their name, let's say Louis de Coca. I would have my fingerprint scanned on that little white scanner. It pings against the national identity database, and if it comes back with a tick, yes, that fingerprint is linked to the name Louis de Coca, then I can again give my consent, and the account opening form is then filled automatically by the government identity authority in a couple of seconds. And all of that information comes verified. The bank does not need to ask anything more. So this brought significant compliance relief for the bank. They could very speedily and very cheaply open up many more accounts, but they did hit legal snags. The gentleman that you see there is a retired judge, Puttaswamy. He brought two important cases. In the first one in 2017, he challenged the Aadhaar system, but on the basis that it breached certain constitutional rights, allowing the Supreme Court in a very comprehensive judgment to recognize the constitutional right of privacy, and under the Indian Constitution, requiring a new data privacy law to be drafted that the Aadhaar system has to comply with. And then in a follow-up case, he challenged eKYC for commercial usage because there were not appropriate controls built in, and that was also upheld by the Supreme Court. So this whole system came to a screeching halt. The government intervened with a temporary ordinance. They restored access to eKYC, but with better controls, and then they introduced proper legislation to stabilize it. So this is now available, but it's only one of the forms that can be used so that users are given a choice. Now, eKYC morphed into digital ID, but it's still different. And FATF issued its digital ID guidance in 2020, just at the start of the pandemic. Now, digital ID is a bit different. Digital ID requires a digital ID system, which is an electronic system to assert and prove your official identity online, or you can also use it when you engage with a person in person, but it is provided by the system. It can be created by the government and be government-led, or it can be created and approved by government, but led by a private sector institution. It does two things. Firstly, it addresses identity proofing, which responds to the question, who are you, by collecting information about you and then verifying that that is your information, and then issuing you with binding credentials that you can use. And you use them for authentication. Now, authentication, we're familiar with the PIN number that you use to access your account through an ATM. That's an authenticator. This digital ID provides both the identity proofing plus that link with an authenticator that is something that you can use, either PIN or perhaps your handset, or even biometrics, as in India. Now, digital ID can be developed to provide different levels of assurance. A very low level, for instance, if we use the American levels, level 1, that would not be suitable in general for financial services, level 2, that provides a fairly high confidence, and level 3, which provides a very high level of confidence, but that has to be done in person. And there are certain requirements to be met to ensure that the level requirements are complied with. Now, FATF also introduced this type of decision tree that may help to explain how the process fits together. And this is from an institutional perspective. If we start on my left with A, the country may actually authorize, like India did, eKYC for usage to open accounts. If that is the case, then that's easy. Then there's a yes, and it takes us down to the white bar. You can use that for CDD purposes if you're a financial institution. But if that is not done, then you move to B, and the question is, well, if the government didn't provide that, did they provide some framework saying, we will be prepared for AML, CFT, and identification purposes to accept any solution that is certified as appropriate by this certifying body? If they did that, then the question is, have they certified that? If yes, what you then need to do is check, does the level of assurance of that system meet the specific product requirement that I have? If I'm working with a lower risk product, I may require less. If it's a higher risk product, I may need a higher level of assurance. The institution has to do that matching. If that's not available, then the institution is on its own. It will have to assess that digital identity solution by itself and then match it to the product before it can use it. But that's high risk and very unlikely that institutions will do that without government assurance. And obviously, if you don't want to do that, then it means don't touch the digital identity. Now, what FATF has done was to say that these forms of identification, if done well, may actually present even a lower risk than a face-to-face transaction that relies on humans and possible human error in spotting a fake or a forged document. So if you do it well, you can actually use it also very well. Now that brings us to the pandemic. The pandemic required the digital ID, but digital IDs require infrastructure that most countries did not have. So as a result of the urgency, countries had to do different things. Now, one of the urgent needs was for countries to provide assistance to people affected by the pandemic. Many of them did not have accounts. So a number of countries had to set up massive account opening processes where people can enroll without in-person contact. So we found a far bigger reliance on eKYC. We found a far bigger allowance or a kind of relaxation of requirements. Brazil, for example, allowed delayed verification for 6 months. Ghana allowed mobile phone registration to serve as a bank's KYC. If you went through SIM card, like RICA, South Africa RICA SIM card registration, you can have a bank account. The UK allowed selfies and videos to be sent in, but often balanced by closer scrutiny and closer monitoring. A very exciting time, actually, last year to form a foundation to make countries and societies more resilient. And that brings me to my observations, and I'll conclude on them. Firstly, the pandemic really helped or forced governments and institutions to embrace simplified identity proofing to support inclusions. But obviously, this also introduced new risks to be navigated. And if you accepted something that's less secure, it might result in more fraud. We've seen a huge rise in synthetic identity fraud. A synthetic identity is an identity that's created in data. It's not a real person. But by opening up a Facebook account and social media accounts, you create the impression for systems that that person actually exists as a real person. So that's a synthetic identity. Cybersecurity risks are obvious, but it also creates other risks, digital inclusion barriers, especially for women that are often not able to access digital technology to the same extent as many men in the same society. Connectivity, because many societies are still not fully connected to the internet to make use of all of these instruments. And then, of course, for all of us, far bigger privacy and surveillance risks. Now, this, colleagues, means in this space, there's a lot of room for collaborative interdisciplinary research. AML-CFT, which is kind of at the heart of what I'm discussing here, when it started to develop 30 years ago, legal academics didn't know what to do with it. It was viewed as non-commercial by the commercial lawyers, but also as non-criminal by the criminal lawyers. The commercial lawyers said it's got to do with crime, nothing to do with us. The criminal lawyers said, yeah, look, this is all about compliance. This is not really for us. And as a result, this has been a neglected area. Also with blurred borders, the first book that's been brought out in South Africa in 1999, when I published it, Butterworth Lexis, who's still publishing it, is still publishing it as an accounting publication, although it's called Money Laundering Law in South Africa. It's legal, but even they couldn't navigate the barriers. Those are the barriers that we need to break down. Now, apart from that, we also need to consider the broader implications of these technological developments around identity. For instance, identification of parties to a commercial relationship is crucial to the contract. It's important that commercial lawyers also understand and grapple with the emerging forms of identification and the implications, while they, for example, also grappling with the implications of smart contracts. And linked in the space, also the importance of the understanding of legal risk. To understand the legal risk, you actually need to understand some of the technology around something like digital identity. But this is an exciting journey, and there are many of us on it, and I, for one, reach out to all of you and say, if this is something that interests you, my door is open. And I really appreciate the opportunity. I've been listening in yesterday. I'll be listening in today too, within my time zone, because I find it fascinating to see and hear what is at the forefronts of your minds as the people at the cutting edge of commercial law scholarship in South Africa. Ladies and gentlemen, it's been a real pleasure. Thank you.
Thank you very much, Professor Uganda, for your insightful and significant presentation. Thank you too for highlighting to us the importance and relevance of digital identities and why we need digital identities. I found it very interesting, some of the points that you made, and I think we do need to explore quite a lot of them further in this country. Are there any questions for Professor Uganda or any comments? I see Kaja Fanika has said she always learns from you, Professor Uganda, when you speak and you give out very interesting information.
You are exceptionally kind. Perhaps if there are no questions. Professor Kasim, ladies and gentlemen, as I say, it's an exciting journey. It's new. The technology isn't something that we understand readily, but as lawyers, we are challenged because to work often, and I often find it's not myself working in multidisciplinary teams because we work with subject matter that we will not master. It's not ours to master. We understand our own field, but we can combine and work with others who understand their field well, and we can co-produce very important and useful information for others, and especially for lawyers and for legal development and law reform, that is important. So from that perspective, I just want to close again with an invitation. My door is open to any one of you who would wish to explore that further. Thank you so much for the opportunity, and good luck to everyone delivering papers today.
Thank you very much, Professor, and thank you for your generous offer with your open door policy. It really is appreciated.
Thank you so much, Professor Kassim.
Thank you very much, Prof. Kassim, and thank you also to Prof. Dikuka for a wonderful keynote address. We are now going to move on to session 6, that is going to be chaired by Mr. Torerai from the NWU, and the session will be on COVID-19, financial markets, and financial crime. Over to you, Mr. Torerai.
Thank you, Mr. Mahau, and good day to everyone. Colleagues, you are welcome. This session has 4 presenters, and I have noticed that all of them are logged in. I want to believe that we have a smooth sailing session. Each one of them will have 15 minutes to present their paper. I would love it if they can even utilize less of that time. We are going to start with Dr. Tongoi from Charles Sturt University in Australia. He is presenting on the following topic: post-pandemic implications of crime, abuse, and money laundering on mobile financial services, a regulatory perspective. Over to you, Dr. Tongoi.
Thank you very much. I trust that you can hear me. Just a quick sound check. Can you hear me?
You are very audible. You can go ahead.
Thank you. Thank you. I'll just get my screen to share. And let me know if you can see my slides.
Indeed, we can see them, sir.
Fantastic. Thank you. All right, so before I begin, I'd like to thank the organizers of the conference, Professor Howard Chitimira and the rest of the team, for giving me the opportunity to come and present. I also want to take the opportunity to acknowledge the keynote speakers. I want to make a very special mention of the speaker who's just gone before me, Professor Louis de Coker and Professor Jean Duplessis, who spoke yesterday. I make special mention of them because these two have been instrumental in my journey in the academic world, and I just want to say a big thank you to them as I begin. I'd also like to commend all those who have spent the time to present before me. We've learned quite a bit from the papers that were presented yesterday, and thank you so much. Now, my presentation is entitled Post-Pandemic Implications of Criminal Abuse and Money Laundering on Mobile Financial Services, a Regulatory Perspective. I'll just get my slides to quickly respond. Fantastic. So this presentation and the paper upon which it is based is made in the context of a global pandemic that has ravaged the world. And we've had quite a bit about the global pandemic yesterday and today, so I'll not spend too much time on discussing that. But as a result of the pandemic, and in order to minimize physical contact, we found that global standard setting bodies, and by extension, the different regulators and governments around the world, have encouraged the use of contactless payments. And the reason was to serve the dual purpose of minimizing the threat of the virus, but also in promoting financial inclusion. So what this does is that it brings digital financial services into focus. And what is digital financial services? These are those methods which are used electronically to store and transfer funds, or to make and receive payments, or to generally access the broad range of financial services that we probably are familiar with today. Now, mobile financial services are a part of digital financial services. They are, in fact, a subset of digital financial services, and they refer to the use of a mobile phone to access financial services and to execute financial transactions. So they've taken on a very significant place in the era of the pandemic. And my paper focuses on the aspect of MFS that relates to mobile payments, which may become subject to increased criminal abuse and money laundering on account of the current environment that we find ourselves in. Mobile payments, as I envisage them in my paper, allow for real-time transfer of funds from enabled mobile money accounts that may be located anywhere that a subscriber chooses to be. They're characterized by speed, convenience, and anonymity, and they're effected in real time. A subscriber gains access to the service when it goes through a registration process that often requires compliance with KYC procedures and adequate CDD procedures as well. With such access, the freedom to transfer funds is only curtailed by limits imposed on daily transactions and perhaps monthly totals that the different regulators will impose from time to time. Arguably, this serves to limit the money laundering risk that we see, or it's likely in this context. So it is these features that I've just mentioned that make the system attractive, both to legitimate users and illegitimate users. The typical mobile money transaction allows for funds to be loaded onto a mobile wallet and to be transacted at will. The process is very capable of facilitating placement, layering, and integration in what we now know as the very common money laundering process. And so organized crime groups are able to exploit these features. They do this through gaining access to SIM cards, which primarily serve as the link to the service. They also use money mules, especially in a pandemic environment, where you find poorer subscribers who may not be so averse to earning extra money by allowing the use of their mobile wallets. It's the affordances of the ecosystem that make it vulnerable to criminal abuse and misuse. And recent examples from Kenya and Uganda would attest to this. In Kenya, we had a situation where an agent who was associated with a terrorist act a couple of years ago had access to 47 different accounts that he had opened with the use of 2 mobile handsets. In Uganda, we had a situation where an organized crime group had access to 2,000 accounts and was able to siphon off close to $3.2 million. So the main risk factors in the MFS context are associated with anonymity, elusiveness, rapidity, and poor oversight. And I'll look at these very quickly each by themselves. Anonymity has to do with accessing the service in the absence of adequate registration or identification processes. It could also be on account of defective ID or compromised documentation that's been given in the onboarding process. It may also be associated with the ease with which funds are able to move through the system without raising any eyebrows, because disclosure of the purpose for the transfers is not a requirement. Elusiveness has to do with access to the service by multiple persons through a common device. It may happen where you've got a registered user that is an entity and not a natural person, and where the device ownership is low, and sometimes the device is used by multiple people to effect transactions. There's certainly great difficulty in attributing all the transactions to the registered subscriber in that particular context. Rapidity, on the other hand, refers to the speed with which funds traverse the mobile payments ecosystem. When you've got real-time payments, funds are available to the recipient literally as soon as they've been sent by the sender. The recipient is then able to transact his funds at will, and he can send them from one place to any location that he chooses. Poor oversight relates to the difficulty of regulating the various participants in the ecosystem. These participants may all be from different industries and backgrounds, and the sheer size and diversity of the agent network would illustrate this difficulty particularly. The practical aspects of overseeing the different players has also been affected by the current pandemic situations, with what we have as the work from home directives and the general broad shift in focus to fighting the pandemic at the expense, a lot of times, of other competing objectives. And so as a result of the new focus, we find that various regulators in the different countries where mobile payments has taken shape have made changes to encourage the access to and use of mobile payments to make it a preferred method of transaction. And so what they've done is that they've increased daily transaction limits, and they've done this significantly. They've suspended transactional accounts on different occasions. In some cases, they've even made customer onboarding processes easier, and they've simplified the account opening regulations. And some countries have even gone as far as making these changes permanent, even though they were intentionally used during the pandemic and the early days of last year and beginning of this year. The likely effect of this—
You have 5 minutes, Dr. Tongwe.
Okay, thank you. The likely effect of this is that new subscribers are able to access the service with greater ease and are likely to be able to transact larger amounts with greater frequency. Now, in the aftermath of the global pandemic, we find that it's the FTF, it's the Financial Action Task Force, it's a bit of a mouthful, that is mandated to provide and set the standards in the fight against money laundering and terrorism financing. And it does this through the recommendations that they make and they seek to reinforce around the world. And in recognizing that role that contactless payments may play in reducing the spread of the risk, what FATF has done, it has somewhat cautiously encouraged the use of these payments. But it notes that there are threats and vulnerabilities which represent emerging risk in the money laundering and terrorist financing realm. It has also encouraged the use of simplified measures to facilitate the delivery of government benefits, many of which are channeled through mobile payments. They've encouraged responsible digital customer onboarding and the delivery of digital financial services. And what is also very interesting is the encouragement to explore digital identity to aid in the delivery of financial transactions during the pandemic. And all this is in the context of a risk-based approach, which allows simplified due diligence measures to be deployed where they find that there's a low money laundering or terrorism financing risk. And that's where the problem lies. The increased monetary thresholds and transactional limits arguably increase the attractiveness of the payment system for illegitimate use, especially by organized crime groups. Relaxed KYC and simplified CDD measures make it even more attractive, particularly in the context of contactless onboarding and the possible use of compromised identification documents. This could seriously hamper the integrity of the onboarding process and provide a gateway for launderers to access the service if it's not properly managed. The increased thresholds in the context also of the absence of limits on the number of accounts that individuals hold also serves to circumvent the very limits that are imposed to control how much money can be transacted. That is a problem. My paper therefore highlights some of the challenges that arise in implementing the global standards and focuses on the perception of risk and how it affects the response of different entities in making their customer engagement decisions. The encouragement to relax KYC and CDD measures may not be very appealing to these entities, especially where there are huge penalties for compliance breaches. These penalties could also result in financial loss or reputational loss. There's also the challenge of differentiating between the money laundering risk and the terrorism financing risk in the MFS context. This is particularly because the numerical value and the directional flow of funds is not necessarily the same at all times. That it may constitute, what may constitute a low risk from the money laundering perspective may in fact be high risk in the terrorism financing perspective. It could also be that the entities avoid the risk altogether and continue to apply what we call the enhanced measures, which could result in some exclusion and defeat the whole purpose of inclusion that it was intended for. My paper, therefore, proposes potential areas of adjustment, particularly in relation to customer registration and identification processes.
A minute, Doc.
Okay, I'm just winding up. It also addresses the transaction limits and the need to seal the gap that may arise from individuals who have multiple accounts. And then it addresses the position of agents who are very uniquely placed to facilitate the process of money laundering. And it really advances the idea that there needs to be a robust system of compliance to monitor these agents, to ensure that each of them is screened, they've got appropriate training, and they've got the capacity to meet the compliance requirements, and ensure that there's strong sanction where there is non-compliance by these agents. And finally, I address the independence of the financial intelligence units, which obviously play a significant role in the whole process of regulating mobile financial services. Thank you. I welcome any questions. I hope I've used my time efficiently.
Thank you, Doc. Colleagues, you are free to post your questions in the chat. We'll read them at the end of the session so that each presenter is able to attend to the raised questions. We are moving straight away to our second presenter in this session, a doctor in the making. That's Ms. Ncube. He is looking at the topic, the significance of the regulation of cryptocurrencies during the COVID-19 pandemic in South Africa. It's your time, sir.
Thank you very much, Mr. Trerai, for the kind words and the welcome. I would like to thank you, everyone who's listening to me at this moment. I'll be presenting on the significance of the regulation of cryptocurrencies amidst the COVID-19 pandemic in South Africa. Please kindly allow me to share my screen. Right. I don't know if my screen is visible. Right. I'll be presenting on the significance of the regulation of cryptocurrencies amid the COVID-19 pandemic in South Africa. As Mr. Trerai already introduced myself, I am Menedisi Ncube, an LLD candidate at Northwest-Universiteit, South Africa. The structure of my presentation will be the following. I will give a brief introductory remarks, wherein a definition of some key terms will also be given. I'll also try and trace the establishment or the genesis of cryptocurrencies globally and how it came to permeate the South African financial markets. And I'll also try to give a brief discussion on the status quo of cryptocurrencies in South Africa, if there is regulation around cryptocurrencies or not, or what really is happening on the ground. I'll also evaluate the benefits of the regulation of cryptocurrency, if ever there is any, with specific reference to South Africa. Lastly, I'll then give a few recommendations and conclude in that regard. Colleagues, this is work in progress. I'm still in the write-up stage of this paper, and so any contributions and questions towards making it a better paper are very much welcome. I'll go straight to defining some of the key terms of cryptocurrency. Cryptocurrency is widely known as a form of digital or virtual currency in which transactions are verified and the records here too maintained by a decentralized system using cryptography rather than a centralized authority. So by decentralization, This means that instead of the traditional central banks that we have in most countries, just like the South African Reserve Bank for South Africa, which regulates all monetary or any currency transactions that happens, cryptocurrencies currently are not under the auspices of the South African Reserve Bank. Digital currency is also any currency, money, or any money-like asset that is primarily managed, stored, or exchanged on digital computer systems, especially over the internet. And then cryptography refers to the study of mathematical techniques for securing digital information systems and to distribute computations against adversarial attacks. Allow me to move on to my next slide, which talks to the genesis of cryptocurrency. Virtual currencies were first established around 1983 by David Chaum, who invested a cryptographic system called eCash. And then in 1995, he developed another system, DigiCash, that used cryptography to make economic transactions confidential. And then in 1998, cryptocurrency was then established, the term cryptocurrency. It was again in this 1998 when a new payment method that used a cryptographic system whose main characteristic was decentralized started taking shape. And then in 2009, that's when the famous or the widely used or widely mentioned type of cryptocurrency, Bitcoin, was established. Then thereafter, other cryptocurrencies like Litecoin, Ethereum, Bitcoin Cash, classic ETC, Zcash came into the field. And then currently, Bitcoin is considered the leading cryptocurrency by value and volume globally. Bitcoin has been widely adopted by merchants, even within South Africa, as a mode of payment. This includes PayFast, which is a prominent South African payment platform, which has integrated Bitcoin into the checkout process of over 30,000 of its clients. This refers to online merchants which are currently using this platform. Additionally, the popular and widely used online store Takealot accepts Bitcoins for payment via this integration with PayFast. Daily crypto asset trading values globally and in South Africa have increased. This has come in after COVID-19. And in South Africa currently, asset trading values in cryptocurrencies are exceedingly approaching approximately $145 million in value. And then what is the status quo of cryptocurrency in South Africa? How is South Africa regulating cryptocurrencies? This is what this slide or this part of the presentation seeks to answer and shed light into. The National Payment Systems, a department under the South African Reserve Bank position paper on virtual currencies, defined a virtual currency in 2014 as a digital representation of value that can be digitally traded and functions as a medium of exchange, a unit of account, and or store of value, but does not have legal tender status. From this, it is clear that in South Africa currently, cryptocurrencies do not have the characteristic of being legal tender. The South African Reserve Bank has not officially recognized these digital forms of currencies as legal tender in South Africa. But does this stop its use in South Africa? No. So since 2014, efforts rather have been there by the Intergovernmental FinTech Working Group, the National Treasury of South Africa, the Financial Sector Conduct Authority, South African Reserve Bank, and other stated agencies to provide laws for regulating cryptocurrencies in South Africa. But it appears, though, that the South African Reserve Bank and some of these mentioned role players have taken a wait-and-see approach when it comes to regulating Bitcoin. this wait and see approach, this presentation would like to follow the argument that it has been motivated by the fact that a lot of technological advancements need to be in place before such a step is taken for the regulation of cryptocurrencies. But then the increase in use is rather forcing something to be done towards the regulation of this cryptocurrency, because there has been recently an AfriCrypt hack of nearly 45 billion rand in worth of Bitcoins. So now I would like to go on to the discussion, which rather wants to motivate why it is rather a better stance to regulate Bitcoin and other cryptocurrencies than not to, as the lack of regulation does not deter people investing in this type of investment schemes. So using cryptocurrencies for illegitimate activities like money laundering, terrorist financing, and tax evasion are some of the results of a lack of a regulatory framework for this lack of regulation of cryptocurrencies in South Africa. So this as a challenge could be one of the ways or one of the motivators to say regulation is important, because lack of regulation will not curb money laundering activities in South Africa and tax evasion. And the other problem with not regulating cryptocurrencies is that, remember, cryptocurrencies are decentralized, and so there are no records of who is the supplier of this cryptocurrency, and who is the beneficiary. So this anonymity of payments and payment service providers is a challenge, which may also exacerbate illegitimate activities of money laundering, terrorist financing, tax evasion, and so forth. And the lack of regulation of cryptocurrencies also affects the price stability, which may lead to financial instability. Remember, our traditional currency, the South African rand, is regulated by the South African Reserve Bank. And so the South African Reserve Bank has the authority and is obligated by the South African Reserve Bank Act to protect the value of the rand. So this lack of regulation of cryptocurrencies gives a lot of leeway and free play for cryptocurrencies in the financial markets of South Africa. And also, lack of regulation gives fertile ground for the circumvention of exchange control regulations. And also, consumers are left at risk. Consumer risk emanates from the increased chances of fraudulent activities, which is also promoted by the lack of understanding and trust of cryptocurrencies in South Africa. And I will also touch on this part of the lack of understanding when I go to my recommendations and conclusions. But some of the notable benefits of cryptocurrencies are that they provide less transaction costs, and transactions can be done at any time from anywhere, and there is less needs for being mobile, going to the bank as one would when it comes to the traditional forms of currency. And amid the challenges posed by COVID-19, the use of cryptocurrency seems to have increased globally. This presentation is of the view that this status quo has been a result of the general global trend towards the use of remote means of investments and fintech services. Additionally, the mining of cryptocurrency refers to the process of gaining cryptocurrencies by solving cryptographic equations with the use of higher power computers. So this mining, which is done in cryptocurrencies, works well under the era of COVID-19, where there is constrained movement in a bid to try and curb the spread of the virus. So the mining, which adds value to Bitcoins, does not require people to move around. So during this era of COVID-19, cryptocurrencies have used this as an advantage to grow this investment or money-making scheme. The last part of this presentation, work in progress, is the recommendations and conclusions. But I would like to pose this question. Is the government of South Africa and the relevant authorities dreading the inevitable? This question seeks to answer the question if really there is a need to regulate cryptocurrencies in South Africa at this moment. And the answer that this presentation seeks to drive at this point is that yes, it ought to be regulated, or else the government and relevant authorities are dreading the inevitable. This comes from the wide reception of cryptocurrencies in South Africa, and hence the lack of regulation could cause more harm than good when it comes to the challenges which I have been explaining in my previous slide of one, leaving consumers exposed, two, leaving a fertile ground for money laundering and other terrorist financing illicit practices, and trying to regulate exchange control mechanisms and preventing people from evading tax. So as part of the recommendations, this paper seeks to recommend a call for accelerated efforts by the government of South Africa and relevant stakeholders in enacting and implementing legislation that regulates cryptocurrency in South Africa. However, it must also be borne in mind that such implementation of these laws will not just come without any burden or challenges on the government of South Africa and relevant authorities. This goes to say that this implementation of laws will require a lot of considerations and mechanisms to be put in place to implement know your client, just like our traditional banking system where know your client mechanisms have to be in place. Ascertain the applicability of consumer protection mechanisms like deposit insurance schemes. Currently in South Africa, there is no deposit insurance scheme. And I think a large number of scholars are addressing this issue to try and recommend that there be a deposit insurance schemes for the traditional banking system. So now when it comes to cryptocurrency, these are some of the factors which must be taken into consideration. Are we going to have now a deposit insurance scheme for those consumers or financial clients who seek to invest rather in cryptocurrencies? Although this study does not seem to take the route of any comparative analysis, there are a few recommendations or lessons which the presentation looked at from other developed countries, which anyway are leading in well-established financial systems. Countries like the USA have taken a positive stance towards cryptocurrencies, Bitcoin, with several government agencies working towards preventing or reducing such use of cryptocurrencies for illegal transactions. Canada also maintains a generally friendly environment for Bitcoin and other cryptocurrencies, while also ensuring that cryptocurrency is not used for money laundering. The same applies with Australia. And then the second recommendation that is given by this presentation is to try and create more financial education or financial literacy programs in South Africa, so that financial clients who seek to use cryptocurrency are aware of what they're getting themselves into. This will better position them to make well-informed decisions into whether this is the type of investments they would want to venture into or not. Thank you.
Thank you, Mr. Ncube. Colleagues, continue to populate the chat box with your questions and comments. We'll read them at the end of the session. We are moving straight to our third presenter. This time it's Dr. Navira from the Center for Monetary and Financial Research. He is presenting on the topic, asymmetric information problem in the South African property market. Asymmetric information problem in the South African property market. Over to you, Dr. Navira. Remove your slides. Dr. Navira.
Can you hear me now?
I can hear you, sir.
Okay. I hope you can see my my screen.
Indeed. You can proceed.
I'm having problems hearing you now.
Okay, but we can see your screen and we can hear you quite clearly.
Sorry?
We can hear you, you can proceed.
Okay, so let me just continue. I enjoyed listening to Professor Dikoka's presentation, basically because really what he was describing there was an asymmetrical information problem which was being resolved. As you know, when there's an asymmetrical information problem, one party knows more about a matter than the other party. So hence there's an asymmetrical information problem. So between a financial institution and an applicant, the applicant knows more about himself than the institution does. So the solution is to try and disclose information. My presentation will follow this outline. I will have an introduction, look at a brief historical review of the asymmetrical information problem, look at evaluation and analysis, and then concluding remarks. This is the form that my paper follows, but I have broken it up a bit so that I can be within the 15 minutes that has been allocated to me. Information is critical for decision-making in any economic transaction. This is because one party usually has more knowledge than the other. So therefore, the purpose of this presentation is to analyze whether a foreign property buyer purchasing a property in his own personal name is adequately protected in a market that requires specialists to understand and interpret. For you to be able to follow what I'm talking about, let me just put you into context. A foreign buyer, upon entering the South African property market, is confronted with an offer to purchase, which has standard clauses. When he finds a property which he likes, he completes this offer to purchase. He goes back to the seller for his signature. However, for the purchaser, this is only the beginning of his journey. There is a host of issues, such as the full purchase price. Where is it coming from? Is it from abroad, or is he blending with local finance? Is he married in community of property or out of community? Does he have an anti-nwu-pukke agreement? Does he have a South African marriage, or does he have a foreign marriage? If foreign, where was he domiciled at the time of the marriage? Is his wife in the country so that she may assist him? If not, she will have to sign certain documents before a notary public. Should you then fail, or if the buyer fails to provide such documentation, then he is regarded as being in breach of contract. To be released from these obligations, the buyer must pay an amount called rawa coup. Therefore, the question to be addressed is whether the buyer in dealing with these specialists should be subject to caveat emptor. As you know, caveat emptor says, let the buyer beware. Shortcomings in the literature on information asymmetry and the concept of market power and caveat emptor as it relates to players in the property market motivated this research. Looking at a brief historical review of the asymmetrical information problem, the asymmetrical information problem was first identified by Ekalov, and he won the Nobel Peace Prize in Economics for his efforts. He observed in
Are you still with us, Dr. Nagda? It looks like you could maybe have fallen victim to the challenges we are facing, probably load shedding or something.
sell at the same price as good cars, since the buyer is unable to distinguish between the two. Only the seller knows the true quality. Therefore, under the circumstances, a good vehicle will most likely not sell at its proper value. And therefore, it can be expected that in the market, the poor quality vehicles will increase because you can get a higher price for a bad vehicle. But in this aspect, not everyone agrees information exists. They point to the great advances in technology, the internet, and say that all knowledge is now available to everyone at the push of a button. They further posit that soon the market will evolve to a stage where both buyers and sellers may have equal knowledge. This is all true. However, to get the right answers, you must ask the right questions. How does a layman know which questions to ask? This leaves us back at the beginning with an asymmetrical information problem. So therefore, a layman's, okay, now let's look at what are the conditions precedent. These were first identified or developed by DeVos et al. In 2011. A layman's market develops when a buyer is unable to accurately evaluate the value of the good or service before the sale. 2, sellers lack trustworthy means of revealing the true quality of a good or service. For instance, how does a lawyer signal that he is of a good quality to a potential client? Buyers and sellers, thirdly, buyers and sellers are using different assessment criteria. The buyer in particular is using utility, how he is going to enjoy the property that he's going to purchase. Now, fourthly, when the seller can sell a low quality product or service at the high price of a high quality product or service, then motivation exists for a layman's market to develop. So I used this as my methodology to identify the weaknesses in the South African property market. Okay, now I reduced this into an equation. Since the layman's problem is adequately defined, it can be applied to South African property market. We express this in the form of an equation. So what we have here is an equation. We have AI equals AI, that is asymmetrical information, is a function of trust, reputation, adverse selection, Rawa coup, moral hazard, and monitoring costs. All these relate to those issues that I spoke about. Adverse selection happens before you enter into the contract, in the sense that you choose the wrong person to deal with. Moral hazard happens after you have entered into the contract, in the sense that the party you are contracting with changes and does not perform according to the contract. And then there's monitoring costs. How do you monitor that the person that you've appointed to represent you, the estate agent, the lawyer, is acting in your best interest, or is acting appropriately, or is attending to your issues as you would like them to be attended to? So AI is the independent variable, and then the others are the dependent, which explain asymmetrical information. Now, I then looked at how each aspect in the market, I looked at law, real estate, marriages, etc., how they relate to asymmetrical information. Now, there are several ways in which the law may play the role of asymmetrical information. Ignorance of the law emanating from language barriers, inability to comprehend the legal system, one-sided ignorance of the law, ignorance due to inadequate publication or distribution of rules of law and procedures, or even the quality of the attorney or the estate agent who may be incompetent is a form of adverse selection. Taking this further, we are looking at this discussion in the context of the law of contract. Now, for a contract, a valid contract, to come into existence, there must be consensus ad idem, that is complete agreement, an agreement on all intricacies of the contract. There must be no false representation. A false representation by the other party is known as misrepresentation. And then there's contractual capacity as it pertains to spouse as asymmetrical information. The buyer goes in, he does not know all about these issues regarding marriage. Persons married in community of property have limited contractual capacity. Persons married out of community of property have full contractual capacity. But the game changer is whether you are married under South African law or foreign marriage. So foreign marriage is particularly problematic. And the poor buyer is not aware of all these intricacies. And then looking at the real estate, although a foreign buyer buying a property in South Africa may have come across related matters in his own country, he may not be adequately prepared for the intricacies of the South African market. Since the estate agent is the foreign buyer's first port of call, he is an ideal person to disclose or not disclose once he is aware of the buyer's foreign status.
5 minutes, Dr. Navira.
Sorry, 5 minutes?
Yes.
Okay. So the caveat emptor doctrine, due to globalization and technical advances and the speed of travel, buyers can purchase property anywhere in the world. Such transactions require specialists to navigate the requirements. But there is this caveat emptor, that is the seller or his agents are under no obligation to disclose material facts. I also looked at market abuse as asymmetrical information, and then I evaluated using those precedents, and I said, well, a buyer unable to accurately evaluate the value of a good or service before the sale. However, misrepresentation by silence constitutes non-disclosure. This is what is called predatory, or what is similar to predatory lending, which is frowned upon. And then I also looked at lack of trustworthy means of revealing the quality of a good or service, that is, how good is the estate agent or the lawyer. Once again, they're not compelled to disclose information to the buyer because of this caveat emptor. And South African law imposes no duty of disclosure on the contracting parties, although some exceptions exist. Thirdly, typically buyers assess the product based on their maximization of utility, oblivious to other impediments attendant upon designation as a foreign buyer. And then finally, when the seller can dispose of a low quality product at the price of a high quality product or service, incentives exist for a lemons market to emerge. In this particular scenario, a possible motivator for a seller is the nwu-pukke clause. You go into the agreement, it doesn't reach fruition, and you have to pay a price to come out of the contract or to be released from your obligations. Therefore, in conclusion, this study set out to answer the question of whether the buyer in the market with specialists should be subject to caveat emptor. This study, therefore, finds that there is a lemons problem in the South African property market on the caveat emptor rule. Therefore, South Africa should consider adopting the caveat vendito rule and discard caveat emptor in the South African property market. Adoption would require that the seller and his agents disclose full information that may prevent the transaction from reaching fruition. Moreover, consideration should be given to having the specific requirements for a foreign buyer being made conditions precedent in a contract, especially when there is a nwu-pukke clause or a penalty clause. In particular, this is not new or strange, but that in an offer to purchase and a mortgage bond, that is inserted in there as a conditions precedent. Further study points to an examination or documentation of the number of cases that reach the courts to fully understand the gravity of the matter. To conclude further, I looked at the introduction, gave you a brief historical review of asymmetric information problem. I gave an evaluation and analysis of the problem, and then I gave you the concluding remarks. Caveat vendito to replace caveat emptor. Thank you very much.
Thank you so much, Dr. Navira, for the presentation. Really appreciate it. We are moving straight to our fourth presenter for the session. This is Dr. Nyaude. She is from the University of Pretoria. The topic says suggestions for reform of the bank resolution framework in Zimbabwe. The floor is yours, Dr. Nyaude.
Thank you, Chair. Can you hear me?
Yes, we can hear you clearly.
I think he's still sharing. Dr. Navira is still sharing, so I cannot share.
Dr. Navira, can you stop sharing your screen? Go ahead, Dr. Nyaude.
Thank you. Can you see it?
Yes.
Okay. Good morning, colleagues. Thank you for the opportunity to share my research with you. My topic is suggestions for reform of the bank resolution framework in Zimbabwe. My research seeks to determine whether Zimbabwe's bank resolution regime requires to be strengthened, and if so, to recommend reforms that will align the bank resolution regime in Zimbabwe with the international best practice. I'll provide a brief background on banks and why they require a special approach when they become insolvent or are likely to become insolvent. followed by a brief discussion of the Financial Stability Board's key attributes of effective resolution regimes as international best practice benchmark for orderly resolution regimes. And then I'll finally make recommendations that, in my view, will improve Zimbabwe's bank resolution framework. So as a background, banks are core players in the financial system as the intermediaries between savers and users of capital. In addition, banks provide critical services to consumers, small and medium-sized enterprise businesses, large corporate entities, and governments who rely on them to conduct their daily business. And then banks are well known for performing three essential functions that make them special in comparison to other financial institutions. That is, they issue transaction accounts, which entail that they hold liabilities that are payable on demand and that are readily transferable to third parties. They are the backup source of liquidity to other financial institutions, and they're also the transmission belt for monetary policy. So unlike other players in the financial system, banks are vulnerable to loss of public confidence and to liquidity risk, which is the risk that a bank will not have sufficient cash to meet short-term obligations. And then any information that a bank may be encountering financial distress may cause a bank run when all depositors go and withdraw their deposits at the same time, resulting in devastating liquidity drainage. And depending on the size and interconnectedness of a bank, its failure can contaminate other financial institutions and lead to a large-scale financial system collapse. So the 2008 global financial crisis demonstrated the importance of special resolution regimes for banks and the need to balance the interest of shareholders, creditors, depositors, and to promote financial stability. And it was particularly the haphazard ad hoc bailouts of financial institutions that directed the regulators against the too big to fail financial institutions and the moral hazard and drain on public funds occasioned by these bailouts. So the post-regulatory paradigm is intent on orderly resolution, which is a special arrangement for the winding up and restructuring of a failing bank by virtue of powers that go beyond the general powers of normal insolvency law that applies to companies. So the powers will exist within insolvency legislation or by adaptation of insolvency processes, but take the form of a special administrative powers to be exercised by the authorities without or alongside normal insolvency proceedings. So the COVID-19 pandemic represents the biggest test of the global financial system since the global financial crisis. The COVID-19 shock put the global system under considerable strain, and the financial system faces the dual challenge, which is to sustain the flow of financing to the real economy and to also preserve financial resilience. So in that context, I'll provide a brief overview of the key attributes, especially in the context of bank resolution. And then because Zimbabwe doesn't have a large presence of foreign financial institutions, I will not address the cross-border aspects of resolution. So key attribute 1 deals with the scope and provides that every country's resolution framework should cover any financial institution that could be systemically significant or critical if it fails. Key attribute 2 deals with the resolution authority and provides that there must be a designated resolution authority responsible for exercising resolution powers, and the objectives that resolution authority must pursue include they must pursue financial stability, ensure continuity of systemically important financial services, payment and clearing and settlement functions. They should protect depositors, insurance policy holders and investors, and avoid unnecessary destruction of value and loss to creditors. Then key attribute 3 deals with resolution triggers and resolution powers, and provides that resolution should be triggered when a bank is no longer viable or likely to be no longer viable and has no reasonable prospects of doing so. So the reason for that is that there must be timely and early entry into resolution before a bank is balance sheet insolvent or before all the equity has been wiped out. And then key attribute 3 also provides for a wide range of powers that the resolution authority must have, which includes the powers to remove and replace senior management and directors. They must have the power to appoint an administrator to take control of and to manage the failing bank. And they must have the power to carry out a bail-in within resolution. So that is recapitalizing of the failing bank or capitalizing a new bank. And then they must also have the power to override the shareholders' rights. So the requirements for shareholder approval for particular transactions, for a merger, an acquisition, or for sale of the substantial business operations. So those are some of the powers. And then key attribute 4 deals with set-off netting and collateralization and segregation of client assets. The resolution authority should have the power to stay the exercise of early termination rights that may be triggered by entry into resolution or in connection with the use of the resolution powers. Then key attribute 5 deals with the safeguards that must be in place during resolution. So they should the resolution process should respect creditor hierarchy in insolvency. There should also be a flexibility to depart from the equal treatment of creditors if such deviation is necessary to contain the impact of a bank's failure. And then the creditors should also have the right to should not receive compensation at a minimum. So should they not receive at a minimum what they would have received in liquidation under applicable insolvency law, they must have the right to receive the minimum. So the no creditor worse off than in liquidation principle must apply. And then another safeguard requires that the directors and officers of the bank in resolution should be protected from lawsuits by shareholders and creditors for action taken when complying with the decisions of the resolution authority. Then key attribute 6 deals with resolution funding. Jurisdictions should have statutory mechanisms or other arrangements in place that do not rely on public ownership or bail out funds for resolving firms. So they should have a privately funded deposit insurance system or other government-based funding that the government can provide and later recover from the banking industry. And then key attribute 10 deals with resolvability assessments. Resolution authorities are expected to regularly undertake resolvability assessments to test the viability of their resolution strategies and their credibility. Then lastly, key attribute 11 deals with recovery and resolution planning. So recovery plans are done by the banks themselves, and they set out a plan of what the bank will do should they encounter a crisis. And then resolution plans are drafted by the resolution authority, and they set out what they will do should a bank encounter financial distress. So after the directors hand over the bank to the resolution authority, that's when a resolution plan will be implemented. So each institution involved has their own plan. And then I now come to Zimbabwe.
You have 4 minutes, Dr. Nyori.
Yes, thank you. So for Zimbabwe is a developing country with a fragile economy and has had many challenges, including that of failing banks. However, Zimbabwe has been proactive in acknowledging the need for a more comprehensive resolution framework to deal with failing banks. So I'll highlight some of the problem areas within the current problem bank dispensation in Zimbabwe. So according to my slide, you can see the current framework includes curatorship under Section 53 to Section 56 of the Banks Act. and then the problem bank provisions in section 52A and B and C in the Banking Act. So some of the areas that are a problem is key attribute 2. So the RBZ, which is the Reserve Bank of Zimbabwe, the central bank, is the resolution authority, and it has the objectives to enhance financial stability, to protect and enhance public confidence in the banking system, and to protect depositors and to protect public funds. So in that instance, it is compliant. However, it does not list continuation of critical functions of a failing bank as a resolution objective. So it does not specifically provide for the RBZ. So it doesn't provide continuation of critical functions as a specific objective, which I recommend that it must be there, because otherwise the resolution authority will focus on just resolution, but not the safety of depositors by maintaining the critical functions of the bank. And then it doesn't provide for the RBZ and the staff to be protected against liability for actions or omissions whilst executing their resolution powers in good faith. That must also be provided for. And then with the resolution powers, one particularly problematic area is that when the Reserve Bank triggers a resolution, it has to get the problem bank notice that it serves to the bank to be put into resolution confirmed by the court. It must be confirmed by a judge in a high court. And I believe that this process unnecessarily delays the resolution process. It is meant to be an administrative process that has nothing to do with the courts. So I believe that in my view, if the court process is removed, it will make sure that resolution goes smoothly. And lastly, some of the issues that I mentioned, it doesn't provide for creditor hierarchy in insolvency. So the current safeguards in place are not sufficient. It doesn't provide for the no creditor worse off than in liquidation rule. There is no provision for how the Depositor Protection Corporation will work with the Reserve Bank in terms of resolution funding. So those two organizations, the Act doesn't provide for how they will work together for resolution funding. There are no resolvability assessments currently in place to test their strategies, both the banks themselves and the resolution authority. And then also lastly, the resolution regime does not provide for banks to have recovery plans of their own in place to try and rescue themselves. And it doesn't provide for resolution plans to be drafted by the banks, by the resolution authority to implement when a bank encounters failure. So my recommendation there as well is that there must be recovery plans and resolution plans done at least within 3 months of the bank being granted a license. Thank you.
Thank you so much, Dr. Nyode, for the insightful presentation. We are going to move straight to questions. Then the presenters would answer. We'll start with Dr. Tongoi. There's a question that says, what can be done to eradicate money laundering in mobile money transfer transactions? That's the first question in the chat. I'll also pose a question to say, how should the regulatory frameworks be attuned in order to adequately combat criminal abuse and money laundering in mobile money financial services? If you can answer, Dr. Tongoi.
Okay, thank you for the questions. I'll address the question on eradication first. And I take the view that eradication is perhaps more of an aspirational goal, primarily because eradication would assume that there's no longer any money laundering going on in the mobile money transactions. Now, even though we look at the mobile money transactions as being vulnerable to money laundering, that particular channel is not as problematic as the others, perhaps because it's still fairly new and the nefarious characters, the criminals, are still beginning to study it and trying to keep a step ahead of law enforcement. But in my view, the things that need to be addressed are the things that provide an attraction for the criminals. So when you look at mobile money transactions, you look at anonymity, the fact that a criminal can go in there and have his money move without necessarily worrying about whether or not law enforcement will be able to flag those sums, or the fact that he can actually gain access to the accounts. And so from a money laundering perspective, if we did target the whole placement and the layering process in the minds of the money launderers, perhaps we could then begin to strengthen the things that give them the perception of anonymity. So when we've got transaction limits, for example, that tell us how much a person can transact in a day, but we don't limit the number of accounts that a person can have. It means we're merely creating a rule and circumventing that rule altogether. So perhaps the starting point would be to close those gaps, identify those areas where money launderers would thrive, begin to address the perception that money can move without necessarily being identified or flagged as being problematic. So the idea that we should be able to disclose the purpose of our movements. When you look at other forms of funds transfer, disclosure of the purpose of the movement of the funds is key. When you look at the banking sector, for example, it's unlikely that you'd find a bank today that would allow you to transfer funds without disclosing the purpose. It's an area that still needs to be developed with mobile money transactions. From a regulatory perspective, how do we strengthen this? I think it's important to look at the different players in the industry. And one of the bigger weaknesses, in my view, is the agent network. And agents are drawn from very many different backgrounds. It's a bit problematic to actually regulate the agents. So in some industries, you'll find agents can be drawn from pharmaceutical industries, banks, anyone who's got some sort of a business. So how do we ensure that we've got suitable controls so that the agents are properly trained and accountable? And a lot of the examples that we've seen where money launderers have succeeded in different parts of the world, there's been heavy involvement of an agent. And so we need to look at that and see whether we can strengthen that particular process. Make the movement of funds traceable, increase traceability so it loses the attraction for money launderers. And I still think eradication may not be a short-term goal, but it could be something that we could achieve in the long term with a bit more focus on regulation. The idea that regulators need to understand the process, they need to understand the transaction right from start to end. They need to understand that each stage of the transaction is vulnerable to the money laundering process. And so then think about how best to address those vulnerabilities at each stage. Make it more difficult for your money launderers to perceive that as a channel which will give them ease to move their money. And I hope that answers the question. It's just my take and opening up the discussion in that particular space. I don't suggest in any way that I have all the answers, but certainly what I see as gaps need to be addressed.
Thank you so much, Dr.
Thank you. I hope I've answered the question. Yeah.
I hope you did. I hope you did. We are moving on to Mr. Ncube. You have a couple of questions and comments here. The first one comes from Dr. Navira, who says, are cryptocurrencies money or simply assets like gold coins or houses? By their nature, cryptocurrencies are volatile in respect to the value. It's a question. Then the other one comes from Dr. Kanamugire. The use of cryptocurrency can attract criminal activities such as money laundering. What can be done to avoid money laundering in the use of cryptocurrency? Is there any country which has accepted cryptocurrency as a legal tender? I would want to acknowledge that perhaps the last part of the question is partly answered by the comments and other questions raised here. For instance, Prof. Klopas says it might be worthwhile to look at what is going on in Venezuela. I have read at some stage that they have recently introduced a cryptocurrency as a formally recognized currency, which apparently caused a number of issues. Then Dr. Navera also came in and says, I think Ecuador made it legal tender with disastrous consequences for its bonds. That's President Bekele. Then Prof. Tikuka says the e-naira has also been off to a rocky start, but these are early days. They will mostly likely become an intrinsic part of our financial frameworks in some form. Basically, it says cryptocurrencies becoming legal tender in some jurisdictions. But I think you can attend to the questions that have not been addressed here. Over to you.
Thank you very much, Mr. Turai, Chair. And thank you so much, colleagues, for the questions, comments, and valuable contributions. Firstly, I would love to answer Dr. Navira's question. I stand to be corrected, but in my studying and general reading on this topic, I stand to believe that cryptocurrency is a form of asset. This stems from our traditional definition of what a currency is. Cryptocurrencies, you find that they are not, centrally controlled, or there are no banks involved. I would love to believe that they are assets. And also, if you look at other countries who are also trying to frame regulatory frameworks for cryptocurrencies like Canada and Australia, they are considering them under assets which are subject to taxation. So although I stand to be corrected, I am inclined to believe that they are assets. And then the next question from Dr. Kanamagire, which asks if the reception of cryptocurrencies won't create a fertile ground for money laundering practices. My answer to this would be definitely. Most practices of money laundering seem to happen predominantly in countries or jurisdictions wherein there is no regulation or poor regulation of financial systems. So regulation thereof of cryptocurrencies, I believe, will be one of the best options or solutions to curb money laundering and other illicit practices related to money laundering. And you will remember that when we regulate currency or any other asset in financial markets, this regulation seeks to trace who is the client, who is the provider of such a service, in this instance, this cryptocurrency, who, as an example, is behind this Bitcoin, and how are the transactions going on. We can trace who is who, how the transactions go on. So it goes back to my first point of departure in my answer to say, money laundering strives more where there is no regulation at all, or where there is poor regulation. And the last part of the question is, which country has accepted the use of cryptocurrencies as legal tender? Recently, if it's not last month, I think El Salvador accepted Bitcoin as legal tender. So that is one jurisdiction which has to date accepted cryptocurrency as legal tender. Other jurisdictions are still framing regulatory frameworks for that transition into allowing cryptocurrencies as being formal legal tender. Thank you.
Thank you, Mr. Nwe, for the answers. There are comments further in the chat, but I think in the interest of time, we are going to move straight to the next session. I'm going to hand over to my colleague, Lisa. I think you can take over from here.
Good morning, colleagues. Good morning, colleagues. Can you hear me?
Yes, we can hear you, Ms. Jana.
Thank you. I hope everyone is enjoying the insightful presentations that have been coming through. We are now going to move on to Ms. S. Govinsame from the University of KwaZulu-Natal. Her topic reads as follows: part of the learning journey is the end result, analysis of digital financial education platforms as a tool to achieve financial literacy. Ms. Govinsame, I hand over the floor to you.
Thank you, Chair. Just share my screen. Is everyone able to see the start of the presentation?
Yes, it's visible.
Yes.
Thank you. So thank you, Chair, and thank you for the opportunity to present at the conference. So my presentation is titled "Part of the Learning Journey is the End Result," and it's an analysis of digital financial education platforms as a tool to achieve financial literacy. In order to provide context for the presentation, a few definitions will be discussed, the first one being financial literacy. One of the striking aspects discerned from academic literature is that the term financial literacy has been variably defined. Hyung, Parker, and Hyung invoked a conceptual definition of the term and crystallized the characteristics of financial literacy as a specific form of knowledge, coupled with the ability or skill to apply that knowledge, which results in good financial behavior. I think what is important about this definition is that it provides a holistic, scaffolded view of financial literacy. Similar to financial literacy, digital financial literacy is a multi-dimensional concept. Digital financial literacy straddles the concepts of digital literacy and financial literacy, but it has its unique aspects due to the nature of the products and the risks involved. And the last term that we're going to spend some time discussing is that of edutainment. It's a concept that emerged in the 1980s and is defined as entertainment that is designed to be educational. So some examples of passive forms of edutainment would include fictional books with educational themes, movies or TV shows with entertaining characters that teach viewers, as well as fictional radio shows and podcasts that are designed to educate listeners. The focus of my research is on interactive edutainment methods, and these include video games designed to educate players, quizzes that provide goals and rewards as users progress through each level, software that allows users to compete against each other in learning exercises, and educational websites with interactive elements, such as clickable images and animations. In summarizing the context of the presentation, the following quote is useful. Everyone has the ability to build a financial ark to survive and flourish in the future, but you must invest time in your financial education to build an ark with a solid foundation. This quote is by Robert Kiyosaki, who's the founder of a Rich Dad Company, which is a private financial education company. The quote is particularly relevant in our current context in that those who had invested time and received the benefit of access to financial education tools had a pre-existing arc to survive the economic consequences of COVID-19, while those with a limited financial education attempted to survive the COVID-19 flood with merely a life jacket. And the point of view of my research is that financial literacy is a 21st century fundamental right that is universally required and needed in the current economic climate. However, traditional resource material and programs may only satisfy the knowledge stage of financial literacy, and other pedagogical techniques may be required to achieve. Yes.
You have 5 minutes.
Thank you. And that other pedagogical techniques would be required in order to satisfy the knowledge stage of financial literacy. So the target audience that I'm focusing on are Gen Zs, and these are individuals that are born between 1995 to 2010, and they make up 46% of South Africa's population, and therefore should be seen as a target group. There's no denying that the pandemic has posed financial education challenges, and these challenges may be mitigated through the use of digital financial education platforms. My research is cognizant of the confines of the existing reality of Gen Zs and aims to work within this framework to harness influential factors in order to improve financial literacy through interactive edutainment. Some of the influential factors are the mobile phone penetration, which is roughly at 50% in Africa, but is growing at the fastest global pace at over 6% annually. Gen Zs are already regarded as digital natives, as they have never known a world without the internet. That context has provided or produced a hyper-cognitive generation that is very comfortable with collecting and cross-referencing various sources of information and integrating virtual and real-world experience. Another influential factor is current internet usage. So Gen Zs spend about 4 hours and 11 minutes per day on their mobile phones, and 38% of Gen Zs have received financial advice from TikTok, reporting that they are likely to return to the platform to get financial advice. However, the quality of the advice and education provided on some of these platforms do not come from credible sources. Therefore, this presents an opportunity for financial literacy improvement campaigns to leverage these platforms to provide reliable, accessible, and dependable financial education. Another key element is the desire for self-improvement. So Gen Zs are raised in quite disruptive decades, and they have been taught that real and significant change is entirely possible. And they look to fix the exist and find new solutions to existing problems. Their desire for self-improvement fosters and mitigates continuous engagement, and this should be harnessed as a catalyst to improve financial literacy. To this end, it's actually noteworthy that hashtag personal finance videos are garnering billions of views on TikTok every day. And the last influential factor would be Vygotsky's zone of proximal development. Vygotsky articulates that the zone of proximal development is the distance between the actual development level of the person and the level of potential development, as determined through problem solving under adult guidance or in collaboration with more capable peers. So according to Vygotsky, one of the major forces in learning is social interaction, and elements of social learning can actually take place using digital education platforms for instruction. The interactive edutainment would serve as a more capable peer, and the person is left in as much freedom to explore and expend effort in the process. Vygotsky's zone of proximal development fits very neatly within the framework of gamification of financial literacy. It provides a simple yet effective explanatory framework to build Gen Z's confidence in their financial literacy as they undertake problem-based learning.
Ms. Govinsamy, You have a
Yes.
minute to round up, please. Thank you.
Okay. So let me move on to interactive edutainment. It really offers a digital nudge in an effort to reduce cognitive load and sustain user engagement. The interactive and reactive nature of the edutainment enables people to learn about complex topics by allowing them to repeatedly make mistakes and learn from them. Hence, a person experiments in the virtual world without any costly or dangerous consequences. Therefore, when the individual is faced with the problem in the real world, they will be more confident to apply the knowledge learned. I just want to give you an example of a form of edutainment.
Thank
So financial literacy is an enabler of financial inclusion. Therefore, the introduction and expansion of a multifaceted financial literacy campaign should be encouraged. The complementary use of purposefully crafted digital financial education platforms may prove to be an inclusive and integrated means to improve financial literacy across genders and across various socioeconomic backgrounds. I thank you.
Ms. Govinsamy, thank you for the
Yes.
presentation. It looks as if I've cut short your time. You actually have 4 more minutes to go. Would you like to just round up at a more collected pace?
Okay.
Thank you.
All right, so let's look at the COVID-19 pandemic and the challenges that were faced by the financial education industry. So like I said before, there's no denying that the pandemic has posed financial education challenges. However, I think it's important that we understand that digital tools can support the effective delivery of financial education and also assist policymakers in South Africa to address the specific needs of the target audience through a tailored approach. So here, what's important is that the word support is emphasized because digital tools should not be seen as a substitute for other methods and programs aimed at improving financial literacy. Rather, a cohesive and multi-pronged approach to financial education is needed in order to introduce and reinforce core financial literacy competencies and cause the intended behavior change. I think what's important is also understanding one's audience. You cannot teach financial literacy the same as you teach it to a 5-year-old as you would to a 65-year-old. And so understanding your target audience is important. And my particular research focuses on Gen Zs. The report by TransUnion is actually quite helpful in being able to identify what are the specific needs of the target audience. We can see that Gen Zs are engaging in credit transactions that focus on bank personal loans, home loans, store credit, and vehicle loans. And therefore, the literacy on these particular topics should be dispensed with and used. It's also very evident that there's the impact of containment measures implemented in response to COVID-19 have strengthened the need to provide effective financial literacy training via digital means. And there is an overwhelming need to give priority to responding to our public health emergency and also strengthening other safety nets that we require in South Africa. And so there is a likelihood that there would be a reduced amount of funding that is available for other public investments, such as in-person financial literacy education campaigns. And therefore, we can discern that the crisis has accelerated existing trends of more and more people using online tools to learn. The shift to digital learning also comes with specific challenges, such as a lack of necessary digital structure. However, there are other advantages as well, such as reaching a wider target audience that may not necessarily be reached through traditional delivery because of geography or personal schedules. There's also a reduced cost.
Ms. Govinsamy, if you can just please round up now. Thank you.
Thank you. Reduced cost in personal or in-person traditional delivery of financial education. And I think the most important thing about using interactive edutainment is that it will allow for easier data collection. So processes can be easily monitored and reviewed and amended if necessary in order to make sure that the education and the lived reality of the target group is congruent with each other so that the behavior change can be executed more seamlessly. Thank you.
Thank you, Ms. Govinsamy, for the insightful presentation on digital financial education platforms as a tool to achieve financial literacy. We now move on to the next speaker, who is Ms. Sharon Munezi, an LLD candidate with the Northwest University. Her topic is an overview of digital financial education towards the promotion of financial inclusion during the COVID-19 pandemic in Zimbabwe. Ms. Munezi, I'll give the floor to you.
Thank you very much, Chair. Good day to you all, colleagues. My topic reads, an overview of digital financial education towards the promotion of financial inclusion during the COVID-19 pandemic in Zimbabwe. So my presentation is structured as follows. I'll offer the introductory remarks at the beginning, and then to make sure that we all set off at the same pace, I'm going to define the key terms, then discuss digital financial services and the promotion of financial inclusion in Zimbabwe as is to date. Then I'll also discuss the impact of the COVID-19 pandemic on financial inclusion and digital financial literacy. And then to conclude, I will give recommendations on how to address the challenges and the problems that would have been noted during the presentation. Colleagues, this is a work in progress, so any comments and contributions are very much welcome to enhance the output of this paper. So this paper aims at discussing the promotion of financial inclusion during the COVID-19 pandemic in Zimbabwe, and to examine the importance of digital financial education in the promotion of financial inclusion in Zimbabwe. I also aim at analyzing measures that can be implemented to achieve digital financial literacy in Zimbabwe. I also outline the challenges of digital financial education in Zimbabwe. And lastly, I'll recommend measures that can be used to curb the challenges that I would have noted. So to start off, I will define financial inclusion. I adopted this definition from a paper that was written by Professor Chitimira and Mr. Ncube. Financial inclusion is defined as initiatives to avail and make accessible affordable financial services such as payments, deposit, withdrawals, transactions, savings, and credit to the poor and financially disadvantaged communities in Zimbabwe in an accountable and sustainable way. Digital financial literacy refers to the knowledge, skills, confidence, and competences to safely use digitally delivered financial products and services to make informed financial decisions. Then digital financial education in turn refers to the process of providing people with knowledge, skills, and exposure through access to relevant objective information and training to enable them to make informed financial decisions and take actions appropriate to their circumstances. Digital financial services and the promotion of financial inclusion during the COVID pandemic. Several digital financial services have been implemented by banks and mobile network operators to promote financial inclusion in Zimbabwe. These are mobile money, mobile banking, and internet banking. The outbreak of the COVID-19 saw an increase in the use of digital financial services due to the fear that the physical exchange of notes and coins may spread the virus even more. So more innovations such as the tap and go also became more popular than before. Lockdowns and travel bans that were implemented as a measure to curb the spread and contain the spread of the virus made digital financial services a necessity as more transactions and remittances were conducted digitally. Although there is no research statistics regarding the effects of the COVID-19 on financial inclusion in Zimbabwe, the lockdown measures that were implemented affected SMEs and cash flow for the self-employed, since some of the measures that were implemented was the closure of small business enterprises. So by so doing, there was reduced cash flow, and also the self-employed could not generate money as much as they used to prior to the spread of the COVID-19 pandemic. Moving on, I'm now looking at the benefits and advantages of digital financial literacy during the COVID-19 pandemic in Zimbabwe. Digitalization improves access to financial services and financial solutions, such as digital credit and fintech platforms. For example, the peer-to-peer origination platforms for small business lending and online marketplace lending. Digital investment advice through online platforms and robo-advice, making financial planning and advice more accessible to the low-income individuals. Another benefit of digital financial literacy is the reduction of compliance costs, and digital financial literacy also limits contact during the transacting process and in turn alleviates the spread of the COVID-19 virus. Moving on, digital financial education, the paper now looks at how best can digital financial education be imparted to the population in Zimbabwe. So I'm just going to list some of the measures that can be useful and that can be implemented to make sure that the population of Zimbabwe is digitally financial literate. So one of the measures is undertaking broad-based financial literacy campaigns through digital platforms, the use of videos, infographics, and short films based on digital financial literacy content. Also improving the accessibility and flexibility of digital financial services. Here, it refers to how best the digital financial education can be imparted to people without actually causing more complications and actually deterring people from accessing digital financial knowledge. The incorporation of religious convictions in digital financial services content. Here I'm using an Islamic fintech example. For example, the Islamic fintech companies in Malaysia and Turkey are providing technology based on solutions to improve access to Sharia compliant financial products or services. So this refers to how best the policymakers can incorporate digital financial knowledge with religious convictions so that many people can get educated on digital financial services through religious platforms. And the challenges that have been experienced in Zimbabwe or that are anticipated to ensue during the impartation of digital financial education in Zimbabwe. There is lack of mobile phones and connectivity, lack of digital infrastructure, financial illiteracy, exposure to digital financial services, may lead to over-indebtedness, especially in the young people. Here I'm referring to some of the spending habits, especially in the young people, because some of the researches that have been conducted actually show that people spend less when they are using paper money as compared to when transacting through e-money or mobile money or some other means of money where a person is not actually holding hard cash. And then there's also a lack of experience and confidence. Some of the people are too reserved. They're not willing to learn and to actually accommodate new ideas and a new way of living. There's also a fear of scams and concerns relating to cybersecurity. Some people are not comfortable with sharing their data or their information on the internet. So that way now people become reserved and they are not willing to join platforms that actually encourage digital financial education or actually improve the levels of digital financial literacy in Zimbabwe.
Ms. Sharon Munezi, you have 5 minutes.
Thank you very much, Chair. So at this point, I would like to conclude my presentation by recommending some of the measures that can be implemented by Zimbabwean policymakers or the government to ensure that digital financial education reaches many people, or if possible, every person in Zimbabwe. Firstly, there is need to provide an enabling and proportionate legal regulatory framework for digital financial education and financial inclusion. There's also need to enact data protection policies that will ensure that the people's information is safe on the internet, and also to establish responsible digital financial practices to protect consumers. This refers to monitoring who and how financial information can be posted or can actually be departed to the people in a way that does not compromise consumer rights, and to also strengthen digital and financial literacy awarenesses. That's increasing awareness programs that actually teach people about financial, specifically digital financial education, to facilitate customer identification for digital financial services. This point, I'm not going to really stress so much about it because the previous presenters have been presenting on the KYC and the customer due diligence policy. So I will not stretch so much about it because this has been done already. And then expand the digital financial services infrastructure. And also the policymakers should implement effective and appropriate consumer protection to ensure fair treatment and financial safety online. Then lastly, there is a need to regulate data and connectivity costs to ensure accessibility. Thank you very much for your time and for listening. I'll be welcome to take all suggestions and questions. Thank you.
Thank you, Ms. Munezi. We will now move on to the next speaker, and that will be Ms. KMW Olowabi from Kwara State University, and her topic reads, Integrating Corporate Social Responsibility via Alternative Dispute Resolution to Remedy Disputes in the Field of CSR. Ms. Olowabi, the floor is yours. Is Ms. Olowabi here? Ms. Olowabi, can you hear me?
Yes. Good morning.
Good morning, Ms. Olowabi. We can hear you. You can take over.
Okay. Just 1 minute. I don't know. I'm trying to share my slide. So let's see how I can go about it. 1 second, please. Okay. don't know. Unfortunately, I can't, I don't know. I can't share my file. So let's see how it goes. I'm going to present in a paper titled Integrating Corporate Social Responsibility, CSR, Fair Alternative.
Sorry, Miss, can you please try to share again?
Sorry?
Can you please retry now? Try to share again.
Okay, I'll try.
Miss Olwabi, I think if you are struggling, you can go ahead and present.
Okay, I'm sorry about that. I apologize for that. My paper is titled Integrating Corporate Social Responsibility, CSR, Fair Alternative Dispute Resolution, ADR, to remedy dispute in the field of CSR, which is corporate social responsibility. Until recently, profit making was a major target and so-called goal, driven every large and medium-scale businesses in the past. Maximizing profit was at the heart of every action taken or initiated by these business organizations. Today, corporate organizations have realized it's not all about profit maximization. Rather, every organization must be socially responsible to its immediate community through initiative called Corporate Social Responsibility, CSR. The CSR concept therefore charges businesses and corporate organizations to enhance value on 3 dimensions, that is profits, people, and planet. So the people and planet, the sustainability of every organization depend on the question whether it is financially secured or able to eliminate its negative environmental impact in conformity with the societal expectation. Hence, mechanisms should be designed to solve disputes related to all kinds of CSR-related issues, that is, human rights, labor, environmental related concern. The paper intends to consider the benefit of CSR on the Nigerian society, to also examine the several dispute resolution mechanisms, if any, in Nigeria that have been put in place on the wide range of level of CSR dispute. The paper will contribute to the current literature on the CSR, and we propose a model company-based mechanism that can aspire to solve dispute via ADR and in a CSR conscious way. So corporate social responsibility means responsibility and an obligation imposed on corporate organization toward its host communities where its business of operation takes place. It's a means through which a corporate business organization can give back through an impactful welfare projects and development for benefit of its immediate community. Surprisingly, countries including Nigeria practice CSR with specific target to meet the needs of the community. And CSR can operate in different dimensions. For instance, some organizations direct their CSR project interest on education development through sponsorship, donation, maintenance of school facility and equipment, while others display interests in projects such as rural electrification, establishment of health care facility, job opportunity, and provision of drinkable water as their CSR focus. So the most essential ingredients in the concept of CSR is that any organization, be it business, corporate, or company, must must show a desire to connect to people in its immediate community and their environment by way of goodwill and to be answerable to their social need. So CSR therefore encourage and emphasize on the importance of reposing responsible behavior on the corporate organizations and social obligation towards society and the environment without compromising the needs of unborn generation. So it's interesting to note that all manners of marketing and strategies, business communication tools are appearing and are few as form of CSR because of the style in which such events are being conducted lately. So it may not be an easy task to differentiate sales and marketing tricks and CSR concept. It might not be read and to mean the same thing. They are two different concepts. However, in recent time, corporate and business organizations have either knowingly or unknowingly misidentified their marketing and sales strategy as their CSR focus. So this can be seen from the advert of reality shows and even sports shows, which appears as the trading ways for any organization to showcase their CSR to the society. So CSR initiative in Nigeria, the practice of CSR within the corporate of business domain is not strange, and as such, it is well pronounced in Nigeria. Historically, CSR in Nigeria can be traceable to the arrival of the multinational companies operation in the countries. So at that time, the maximization of profit was the major drive of this multinational company without any sign of concern to improve on the economy and the welfare of the host community, who are the victim of the aftermath resulting from their operations. So regrettably, lack of proper guidelines by the Nigerian government to lead the operation of the multinational companies cause its host community internal disasters, lose on their livelihood. Of course, people and the community environment were greatly affected by the spillage of oil, dumping of toxic waste materials in the rivers, flaring of gas resulting from the company operations. So Nigerian governments, both at the federal level and the state level, interfere, but this could not yield positive solution. Possibly lack of transparency and absence of sense of accountability among public officers could be the major setback for the Nigerian government. So corruption is also at the top of the GS in the nation, is not left out to be blamed. So just later, the agitation from the host community eventually barred the CSR concept in Nigeria with the imposition of obligation on every organization and businesses to give back positively to the society. So for instance, Dangote of companies, MTN, Cambridge, Nigerian PLC, Zenith Bank Limits PLC, United Bank of Africa, Glo, Unilever Nigerian PLC, and PC Cousin are well-known companies who are all in one way or the other involved in CSR program with the aim of improving on the welfare of the communities in which they operate. So for instance, PSC Cousin Foundation focus are in the area of education, healthcare, drinkable water, good maintenance, and so on. So SM sustainability and the best practice of this component. So arguably, this PC Cousin PSC Limited active involvement in the CSR program over the years in Nigeria helped the company to hold its ground against its main competitor, and it further encouraged the rise in its shares between 2005 to 2010 by 4 to 5 points. So it can be confidently established that CSR is the way forward in any business activity that intend to maintain leadership position and be relevant in the industry. So this further encouraged the PC Cousin PLC to deepen its commitment to giving back to this community, to improve on the ethical standard in the industry. So several companies have already found considerable success with the concept of CSR. Dispute and conflicts are inevitable between the stakeholders, host community, and the organization. So ADR mechanism may be suitable to resolve this dispute, because the relationship could be preserved and improved upon through this means. So the relevant questions are the prominence. The relevant questions are how can the relationship be, with corporate organization and its community be preserved or even improved using the ADR? That's the relevant question. So now, socially responsible management of any corporate organization require identifying individuals or community or stakeholder affected by business operation and should be encouraged and open to dialogue with them. ADR is an alternative mechanism to resolving dispute and conflict other than going through normal judicial process. So ADR process can give opportunity to the disputant party to resolve dispute or conflict, be quicker, with less costly. ADR also allow parties to maintain the cordial relationship between them through dialogue. So for example, example of ADR includes negotiation, mediation, conciliation, and arbitration, among others. So each ADR mechanism comes with its own approach in addressing dispute with a varying degree of formalities and the party level of control over the resolution. Hence, the ADR mechanism.
Ms. Olawabi, you have 5 minutes.
Okay. So hence, ADR mechanisms have a direct connection with CSR, that is a corporate social responsibility, to their primary purpose of preserving the relationship within the corporate organization and stakeholders and their host community. So with the use of negotiation or mediation or even the conciliation, the relationship could be preserved and improved because the problem is addressed and the position of the party ahead and resolved through mutual understanding. So this will have a possible positive effect on the parties and encourage their constructive side, saving the relationship, fostering trust. Then mutual respect and transparency will be increased. So they are possible, although this adoption of ADR in the on CSR disputes are with some challenges. So it remains to be seen whether the ADR, one of the challenges that it remains to be seen whether the ADR can succeed in resolving CSR disputes in a manner that gains the confidence in the affected society. The first challenge will be to adopt a set of procedures that guarantee the party a minimum standard of procedural fairness while affording the cost and delay of formal litigation. So in conclusion, the research aimed at providing an overview of an alternative conflict resolution procedure. It also summarized the state of art of CSR dispute mechanism and proposing a model of ADR on CSR related dispute and issues. It therefore recommends as follows: to implement ADR mechanism in any social responsible company. There's a need to establish a dispute management protocol, which should be simple procedure for the stakeholder to comprehend. So this will guide both the organization and the stakeholder community in the case of conflict. It also identifies the problem and allow dialogue to take place. So this reinforced trust, provides security and stability to the party. So two, it's also recommended that it is important to classify disputes or claims to determine what the best route of action is. So the clarification will be based on our 4 characteristics, that is issue, party, acceptance, and the solution. So it will provide a good guideline on how to systemize and increase the transparency and predict the predictability of dispute mechanism. So thank you for listening. I'll be open for the comment and observation. Thank you.
Thank you, Ms. Walabi. They actually have 2 minutes to round off, so we can maybe just use those 2 minutes to hear from others or from you, just those 2 minutes. Otherwise, we'll move on to the next speaker if there's any questions, but I think at the moment, it's best to move on. So Do you have anything, Ms. Owolabi?
No, I don't have anything to hide. Thank you. Thank you.
Oh, thank you. So we are going to move on to our next speaker, who will be Ms. P.T. Ngube with the University of Pretoria. Her topic reads the use of artificial intelligence to promote financial education for unbanked persons in South Africa during COVID-19 pandemic. Ms. Ngube, over to you.
Thank you so much. Good morning, colleagues, and thank you for taking time to listen to me today. Thank you also to the chair for the welcome. So my topic is the use of artificial intelligence to promote financial education for unbanked persons in South Africa during COVID-19 pandemic. The structure of the presentation is as follows. We'll have the introductory remarks, definitional aspects, overview, regulation of financial education for the unbanked persons in South Africa. And also we'll look into available financial education enforcement approaches that are available in South African financial institutions and the use of artificial intelligence or other technological approaches in order to promote financial education for the unbanked during COVID-19 in South African financial institutions. And lastly, we'll look at possible challenges of artificial intelligence in promoting financial education for the unbanked persons during COVID-19 in South African financial institutions. So, next slide. Colleagues, this is a work in progress. I'm at the very early stages of writing this article, so your comments are most welcome. So South Africa is characterized by a well-developed formal financial sector and has a population which, according to the World Bank, ranks very high in indebtedness. So during 2017 to now 2020, 76% of South Africans had borrowed money, which made them more indebted more than the population in any other nation. And in addition to these high levels of borrowing, South Africans also stand out in terms of poor repayments. And the National Credit Regulator reported in 2019, the annual report that set out that South Africa has also impaired records. This suggests that South Africa, like in any other part of the world, financial literacy skills are important yet underdeveloped among a large share of population. So this study aims to promote an overview of what is happening in South Africa in this field. It also aims to identify entry points to improve financial education as a stepping stone towards a greater financial soundness. Also, this study is by no means exhaustive. However, it can be seen as a starting point towards creating a more systematic overview of key actors, initiatives, and frameworks linked to financial education in South Africa. So the relevant provisions that I'm going to look at are the financial, in order to enhance financial education in South Africa, we look at the financial sector regulator, which includes the South African Reserve Bank, the National Credit Regulator, the Financial Sector Conduct Authority, and the Financial Intelligence Center. And also I'll look into the use and possible challenges of COVID on the unbanked people in South Africa, and also the possible use of artificial intelligence measures in South Africa in order to promote financial education for unbanked persons in South Africa during COVID-19. Definitional aspects. Artificial intelligence could be defined as a simulation of human intelligence processes by computer systems or other machines in order to learn or acquire certain information in reasoning and related rules, and or applying such rules to reach approximate or definition conclusions and corrections. So with artificial intelligence that I'm hoping to look at in this article are things like robotics, but I am going to give you or explain this further during the presentation. And then looking into the definition of financial education focuses on the ability to manage personal finance effectively, which acquires experience of making appropriate personal finance choices, such as savings, insurance, real estate, things like college payment, etc. And then, who are the unbanked persons in South Africa? So the definition of unbanked persons are people who do not have access to formal financial services like banking and savings. So the unbanked doesn't necessarily mean the poor, because the poor might have banking, might be banked, but it looks into people who do not have access into formal financial services. Next slide, please. Thank you. So now we'll be looking at the overview regulation of financial education for the unbanked persons in South Africa. So we have the South African Reserve Bank Act, and under the South African Reserve Bank Act, there is the South African Reserve Bank, and this bank is required by the Act to perform functions such as implementing rules and procedures to regulate and supervise payment, clearing, and settlement payments and other duties. This may be seen under Section 10 of the Reserve Bank Act. However, the South African Bank Act does not expressly provide for financial education, particularly for South African unbanked population. So why should the South African Reserve Bank Act expressly provide for why should the South African Reserve Bank Act expressly provide for financial education, particularly for the South African unbanked population? I have 3 reasons that I identified, and for a solid financial understanding, it will help people to actively minimize debt in order to free up disposable income over time. Because according to the trading economics, the South African debt in income ratio in 2020 was 77%, which is up from 72% in 2019. This indicates a steady rise in consumer debt. And also, the second one is to make sure that people are free up from disposable income to save and invest for short, medium, and long-term goals. Starting small with a creation of emergency funds, for example, this can minimize one's risk of future debt and help lead a long-term financial freedom. And also, this also helps in gaining confidence in your financial status as people. So those are reasons that I identified in ensuring that financial education is important. Is an important initiative to be done by the South African Reserve Bank. And then now we'll be looking into the national payment system, which is also regulated by the National Payment System Act, which makes provisions for the management, administration, operation, and supervision of payments and clearing and settlement systems in South Africa. The National Payment System Act provides means and systems for the unbanked to make and receive payments in South Africa. However, the Financial Sector Regulation Act also governs South Africa's national payment system. This means that the provision of services to the unbanked may be also governed by the financial sector conduct provisions. And then according to the Financial Sector Regulation Act, financial institutions are responsible for ensuring the efficiency and integrity of South Africa's financial markets. More importantly, the Financial Sector Regulation Act requires financial institutions to treat their customers fairly by providing financial education programs or activities that promote financial literacy and other appropriate for financial consumers. However, the Financial Sector Regulation Act definition of consumer or financial consumer does not include the unbanked population in South Africa. So now I'll be looking into available financial education enforcement approaches in South African financial institutions. As mentioned before, the FSCA is a financial sector regulator which is in charge of conducting financial services in South Africa. So it aims in enhancing the support and efficiency and integrity of financial markets and to protect financial consumers by promoting their fair treatment by financial institutions, as well as providing customer with financial education. So the FISCA and the South African Financial Insurance Association developed a learning resource for grade 10s to grade 12 teachers of the school subject, which is mathematical literacy. So the resource called Managing Your Money was made available electronically to 10,000 teachers. So this education was only offered to people or students who are in grade 10 to grade 12, but that take mathematical literacy as a subject. This excludes other students who do not take mathematical literacy as their subject. So it limits people from getting access into financial education. So there are also other educational trainings that have taken place, as in the Money in Action and education and training colleges, which have hosted different workshops and partnered with Department of Education with the aim to providing students with knowledge that is needed into this. I've been alerted that I'm left with 5 minutes, so I'll rush into my favorite part, the use of artificial intelligence and other technological approaches to promote financial education for the unbanked. I am a huge fan of artificial intelligence, so I might sound very biased about the use of artificial intelligence in our daily lives. So currently, artificial intelligence in finance is used to analyze thousands of data points from credit bureau sources to assess credit risk for consumer and small business loans applicants. And artificial intelligence and other parts of artificial intelligence, which is machine learning, are rapidly developing and are bringing political, economical, and social transformation in developing the South African economy. And artificial intelligence is likely to emerge as a game changer in people having access to financial facilities, especially the unbanked people. So the other thing is artificial intelligence is transforming the consumer financial services market, as well as consumers' interaction with the financial services ecosystem. This shift has been driven by many artificial intelligence algorithms, growing artificial intelligence investments, and increasing competition. So with the rise of mobile phones such as and the use of information and communication technologies, such artificial intelligence measures could be used to provide financial education to the unbanked. So this means that people can use mobile banking and electronic money in order to gain access to financial facilities. And then the implementation of financial intelligence in companies can bring a number of benefits. Firstly, the artificial intelligence system provides a faster response with results in higher consumer satisfaction, and also notably in Nigeria, there is the Nigeria's United Bank of Africa. This bank has a chatbot called Leo that helps customers with a number of transactions, such as transferring money, paying bills, paying airtime, and giving advice to customers. And also this Leo gets to chat with people on WhatsApp, Facebook, Messenger, and also those who have able projects. And the thing about artificial intelligence, it also has other things called robo-advisors, which are digital platforms that provide automated algorithms driven by financial planning service with virtually no human interaction. So as much as I am a huge fan of artificial intelligence, I wouldn't want it to independently run everything. So the use of human advisors, such as our financial advisors, and also the use of robo-advisors can coexist. Moving on to possible challenges of artificial intelligence measures in promoting financial education for unbanked persons during COVID-19 in South Africa. We're looking at the fact that artificial intelligence is also not perfect. It can easily be tampered with. So artificial intelligence during can result in accountability and vicarious liability, and and anti-money laundering and measures that could be manipulated and bias and shortcomings during financial fraud. And then it is recommended that the South African Reserve Bank and the other financial institutions must raise awareness about the use of mobile phones and information and communication technologies in providing financial education to the unbanked. And also the South African Reserve Bank may use robotics as artificial intelligence to provide financial education to the unbanked, particularly during COVID, where people did not have face-to-face interaction with their bankers. So South Africa should also abandon a very strict banking regulation and effect regulations that affect mobile money and electronic money services products and proper financial education for the unbanked majority, especially during COVID-19. So that is all from me, colleagues. Thank you so much.
Ms. Jana.
Thank you. We can now go on to the question and answer session. My apologies, I had a network disruption.
Thank you very much. I have there are some questions here that we have in the chat. I had asked mine to Ms. Govern-Sami, to Salina, and there are other questions which have been directed to the other colleagues. I think the participants can go ahead and answer the questions. Ms. Govern-Sami, you're the first presenter.
Thanks very much. I appreciate the opportunity, and thank you also for the questions. I think your comments that you've made in that, given the issues such as poor internet connectivity and the digital divide, as well as high data costs in South Africa, how can we ensure that no person is left behind and integrate poor and low income earners who live in informal settlements and rural areas into digital financial literacy campaigns? And I think it's a very important aspect, and something that I choose to research on as well, is not to create a framework that is theoretically competent but practically flawed. And in that regard, I think that it would need to have a joint stakeholder approach. So in as much as the COVID-19 pandemic has proved to be divisive in respect of certain communities, it has also drawn certain communities together. And the fintech community has really lent on each other in terms of expertise and time, as well as resources, in order to create platforms that are more readily suited to the online learning platform. And so one of the stakeholders that I can name, for example, is the Melinda and Bill Gates Foundation. They have a particular set of money that they've set aside to deal with digital financial literacy, using different type of digital financial education platforms. And they are willing to work with entrepreneurs, as well as established stakeholders like the bank, as well as our policymakers here in South Africa, as well as everywhere else on the African continent, to be able to understand that there's no way that we can say that we have a competent financial literacy campaign in South Africa if a large amount of our population is left behind. So to answer your question, it's going to take a collaborative approach from relevant stakeholders. It might need to be funded privately, but there are also endeavors, I know, in Brazil, where public funding in terms of GoFundMe pages have been set out and used in terms of community engagement and collaboration in order to be able to raise funds that are needed to create platforms and also create the avenues for those platforms to be used. So in terms of old smartphones, for example, that people no longer use get donated, and those then get reset and given to individuals who would be able to use those type of perhaps older phones, but use it for edutainment purposes. So I hope that answers your question.
Thank you very much, Selina. That addresses my question. Ms. Jana has indicated that she has connection problems on her side, so I'm assisting her. I see that there are no questions at this stage for Ms. Munezi, but I see a question from Dr. Sola and another from Prof. Kloppers directed to Ms. Olowabi. And then the first one from Dr. Sola, it's in fact two-pronged. He says, from your presentation, it seems that you are writing on the Nigerian situation. Don't you think that you need to add Nigeria to your title? And then the other one is, how do you integrate ADR with CSR in dispute resolution in Nigeria? Dispute between who and who? And then the other one for you, Ms. Olowabi, from Prof. Kloppers, he says, he also wanted to know what constitutes a CSR dispute. When would a CSR dispute give rise to judicial intervention? Yeah, those are the questions for you, Ms. Olowabi. Okay, I see that you have responded one of the questions to Dr. Sola. The other one from from Prof. Kloppers. Miss,
can you hear me?
Yes, we can hear you, ma'am.
Yes. Can you repeat the question again, please? Thank you.
Okay, thank
Hello.
you, Miss. Yes, Miss Olowabi. The question was from Prof. Kloppers. Yes, and he wanted to know what constitutes a CSR dispute and when would a CSR dispute give rise to judicial intervention?
Okay. Most of the common problems that usually create problems or conflicts or dispute between in CSR is between the host community, stakeholders, society, within which most of these organizations operate. For instance, the most common things that actually cause dispute between them is probably the mode of operation is affecting the society, especially where the operation takes place. Maybe let's take an example.
Miss Olowabi,
are you with me?
We have challenges in hearing you properly. Can you maybe perhaps type your response in the chat?
Oh, yes, okay, no problem.
And then there was no question for Ms. Ube as well. Yes, so in that regard, I think according to our program, we have lunch scheduled for 12:20 until 13:25. Just like we did yesterday, we are going to leave the systems on, but for colleagues who might want to save data and reconverge again after lunch, you are more than welcome to do so. Thank you very much. I see your comment, Prof. Kloppers. Indeed, it's quite nice that we have more colleagues researching on CSR. We had also some comments yesterday on CSI. So this is quite, the colleagues are really doing quite great work in terms of research. Thank you very much, colleagues. Let's meet again here at 13:25. Have a lovely lunch.
Coronavirus pandemic on the financial health of a specific group of people, as well as the mediating effect that financial literacy may have. According to these authors, intrinsic and extrinsic factors have an impact on financial health. Intrinsic factors refer to a person's numeracy skills and knowledge, while extrinsic factors are uncontrollable and include socioeconomic and political factors, as well as natural disasters and disease outbreaks that could lead to pandemics. Sound financial health is furthered by financial literacy and awareness, and would not only include knowledge of saving, investment, and financial planning, but would also include being prepared and aware of financial shocks that could happen in future. Now, in a publication in 2021 from the OECD, it was stated as follows: access to high quality information, advice, and guidance also plays an important role in helping those with lower levels of financial literacy to improve their financial acumen and work on their financial resilience. Financially resilient consumers are less likely to face hardship in the event of a downturn and more likely to be able to bounce back quickly when things start to improve. The OECD also stated that it is important that adequate financial education should take place in response to a pandemic. Financial resilience should be rebuilt and enhanced by informing, guiding, and educating people on financial matters in a timely manner. The latest policy instrument from the OECD on the topic of financial literacy highlighted that many people lack even basic financial knowledge and are ill-prepared to make good financial decisions. The OECD recommends, under the National Strategies for Financial Literacy, that in order to establish transparent coordination and governance mechanisms, relevant private and not-for-profit stakeholders have to be involved. Such stakeholders would include non-financial companies like employers. It is essential that corporations should offer their employees financial education, since employers have daily access to employees and can claim time from them. Such financial education should include financial literacy programs as recommended by the OECD, where a large variety of channels and means are used to reach a wide audience, such as targeting awareness of employees to important finance issues to rebuild financial resilience. This contribution argues that one of the strategies to build financial resilience during a pandemic should be that employers, like corporations, provide financial education to employees to not only enhance their financial knowledge and skills, but also change their behavior. The primary objective of this contribution is to investigate whether financial education can add to financial resilience of people during a pandemic. Now, the literature shows that financial education can lead to better financial knowledge and skills, and that can lead to behavioral changes in decisions about financial matters. But does a statutory mandate exist in South Africa for financial education to promote financial literacy? In the new democratic regime established in South Africa after the end of apartheid in 1994, the Broad-Based Black Economic Empowerment Act was enacted in 2003. According to Pearson, Stoop, and Kelly Lowe, the BBBEE Act and the Financial Charter were the main pillars of transformation in the financial sector in South Africa. However, no reference to financial education is made in the BBBEE Act. The Financial Charter came into effect on 1 January 2004. In this voluntary charter, the financial sector committed itself thereto that each financial institution would invest a percentage of profits in consumer education that will include programs to assist consumers in making better informed decisions about their finances. Financial institutions would also contribute to support financial literacy programs in communities. In the National Credit Act of 2005, the National Credit Regulator is responsible to implement education and information measures to increase the knowledge of consumers regarding credit and their rights as consumers. Then the Financial Sector Regulation Act changed the financial landscape, the financial regulation landscape in South Africa with the implementation of the Twin Peaks system of financial regulation in 2017. Through this act, a stronger focus is placed on financial education of consumers. The act determines that one of the objectives of the Financial Sector Conduct Authority is to protect customers by providing them with financial education programs and by promoting financial literacy and the ability to make sound financial decisions. In order to achieve its objectives, the functions of the FSCA include that it should formulate and implement strategies and programs for financial education for the general public. The FSCA may make conduct standards to ensure that financial education programs promoting financial literacy are appropriate. And these conduct standards may be made on the design, suitability, implementation, etc. of financial education programs or other initiatives promoting financial literacy. The FSCA may issue a written directive to a financial institution to take action specified in the directive if the financial education that the financial institution is providing is not done in accordance with the standards. But it is clear that there is no statutory obligation on employers to educate their employees. And I will argue that such financial education has to be voluntary by employers because of many other benefits to them. Now, academics use various definitions for financial literacy. Raymond regards financial literacy as consumers' competency to manage their income. Hung et al. Define financial literacy as consumers' ability to use their knowledge, skills, and attitudes to manage income effectively to improve their financial well-being for the future. Consumers with high levels of financial literacy are educated about concepts like cash flows and inflation and succeed to manage their income. Roberts and Struve, who did a study in South Africa in 2011, emphasized that consumers with a lack of formal education do not have access to credit and are dependent on family and social networks for credit, illustrating a possible link between financial education, financial literacy, and financial behavior. And it was found by Roodman and Antoni that consumers with high levels of financial literacy are informed about financial decision makers, have awareness of their personal financial issues and choices, and have learned the basic financial skills such as spending, budgeting, borrowing, and saving their income. This suggests that high levels of financial literacy aid people to be more financially resilient in difficult times, like a pandemic. To ensure that levels of financial literacy are improved and ultimately financial behavior of consumers changed, financial education that teaches consumers about financial concepts such as spending, budgeting, saving, borrowing, or debt management can be applied. In the literature, various studies show that there is a correlation between financial literacy and poor financial or financial illiteracy and poor financial decisions. Now, many authors point out that financial education can impact financial decisions and behavior, confirming that financial literacy is a crucial factor for a well-functioning economy. Various actors argue that people may derive many benefits from being financially educated, such as positively influencing financial behavior, increased savings, reduced debt, and an improved credit rating. And also things like learning to save for their children's education and their own retirement and having a balanced budget. Other advantages of financial education is that in dealing with financial institutions, individuals would know what questions to ask and would know to whom to complain when problems arise. Various institutions can provide financial education, for instance, schools, universities, and employers. A study by Clark, Lusardi, and Mitchell during April 2020, thus in the first months of the COVID pandemic, found that people who were financially more literate had a better grip on financial shocks and were more resilient and better equipped to deal with economic blows and plan for the future. From the foregoing, it is clear that financial literacy of individuals can be built through financial education to enable them to better withstand the negative effects of a pandemic. Now, what is the effect of a company who has a financial literacy program for their employees? PwC concluded or conducted its annual employee financial wellness survey in January 2020. The survey showed that the loyalty of an employee to an employer is inclined to be more when the employer cared for the financial well-being of employees. When employers are involved in the financial education of the employees, employees tend to become more loyal towards the employers. Various studies found that financial education by employers has a positive influence on employees' financial well-being and may change the financial attitudes of employees, ensuring them to be more self-assured when making financial decisions and helping them realizing their financial goals. An employer that implements a financial literacy program can reap the benefits of increased productivity of employees who experience greater job satisfaction. So in conclusion, if a company wants to adopt a financial wellness program, how should they go about and what should be included in the program? During a financial uncertain time, employees are mostly worried about how they would meet the essential financial obligations, and employers should begin thus by focusing on this critical aspect of the crisis. Since employers have daily contact with and access to the employers, they should provide employees with financial education content about how to open a bank account, the effect of interest rates, the limits of credit facilities, and products available for investment, insurance, and in retirement planning. As the world is caught up in a pandemic, employers should realize that their employees could run into very difficult and stressful financial circumstances because of the economic realities of the pandemic, and that their workforce would need sufficient financial education to build financial resilience. Employers would reap many benefits in offering such financial education. Thank you.
Thank you very much, Gerda, for such an informative session. I must say that listening to the first keynote address yesterday and the comments that came from the chair yesterday, that a keynote address is basically typified by the ability of persons who are not steeped in the subject to basically understand what you are referring to in your keynote address. I think that you passed that test. I am pretty much convinced that even people who are not steeped in financial regulation have been very much informed and could understand everything that you said. And thank you very much. It is quite an honor for us to have listened to you. And I'm sure I'm speaking on behalf of everyone on this platform when I say thank you very much for a very detailed talk that is so informative. Thanks a lot.
Thank you.
I now want to hand over to Dr. Helena Stewart, who's chairing the next session. Thank you.
He's there. I was talking to him. He's going to find you now. I just sent him your details. A white t-shirt. Okay.
Thank you very much. I had a question for Dr. Van Niekerk. I wanted just to find out, Dr. Van Niekerk, from your wonderful presentation. Do you think that the regulatory bodies that we have, the FSCA and the NCR, do you think that they have adopted adequate and sufficient measures, if any at all, in response to the COVID-19 pandemic to ensure that at least they can empower and equip financial consumers on how really to shoulder these contemporary challenges that have been posed by the COVID-19 pandemic? Thank you.
Yes, thank you for the question. I haven't done any research on that specifically, because it's actually the FSCA can only make directives for financial institutions, and my study was about corporations, but other speakers also spoke about financial education and referring to the FSCA, and I think that would be a very good topic for research, to find out what they've done for putting measures in place so that more financial education can come towards consumers, because consumers really need that. Many people don't understand what the effect would be of just borrowing more money. So I don't know what the answer to your question is, but I would really like to know, to find out more about that.
Thank you very much, Dr. Fanny.
Thank you very much. Yeah, thank you very much. I don't see any further questions in the chat box. I'm not sure if there are any questions on the forum. But in the absence of such questions, I would like to hand over now to my colleague, Dr. Helena Stewart, to take over the session that is supposed to take place now. Thank you.
It seems that we do not have Dr. Stewart currently in the meeting with us. In that regard, we will have Mr. Ncube taking over to chair this session. Over to you, Mr. Ncube.
Thank you very much, Mr. Mahau. Good afternoon once again, colleagues. We are now venturing into session 8 of our day 2. And the theme for this session is COVID-19, corruption, and corporate governance. It seems that we are 5 minutes behind schedule, but I think we'll make up for the time lost. First, we'll have a presentation by Prof. K.O. Odeku and Dr. M.D. Matotoka from the University of Limpopo. They'll be presenting a topic titled Combating Corporate Sector Corruption in South Africa, Existing Obstacles and Prospects. Over to you, Prof. and Doc. Thank you.
So thank you so much, and good afternoon to everyone. My presentation is with Professor Odeku, who unfortunately had to step out due to matters beyond his control. And secondly, I must also mention, colleagues, that I'm doing this presentation in the dark, and I'm using my cell phone, which is basically around 8%. So I do anticipate that I may not even finish the presentation. However, I'll be quick in the presentation just to talk to the key salient issues that we wanted to bring to this conference. So our paper is titled Combating Corporate Sector Corruption in South Africa, Existing Obstacles and Prospects. And the structure of the presentation would look into the introduction, where we'll have a definition of terms, the duties of directors, and the challenges of corruption in the corporate sector, and then we will provide our concluding remarks on the matter. Now, when one looks at the corporate sector in South Africa is recognized as one of the key economic drivers. However, it is often faced with accusations of corruption, which is viewed as one of the hindrances of corporate development in South Africa. Corruption impedes economic growth at various small, medium, and large companies. And such corruption often takes place in instances of bribery and kickbacks, especially where government employees are involved. We do know that in 2017, one of the reputable law firms, not auditing firms in South Africa, was made in various controversies, KPMG, where it was faced with various accusations such as ignoring conflict of interest while dealing with various 36 companies, and also providing tax advice to ensure that public funds extracted from South African fiscus were placed outside South African borders to avoid tax payments. It was also accused of compiling various SARS rogue reports, which were ultimately withdrawn. And these controversies that surrounded KPMG has resulted in the ethical conduct of officials being brought under question. And this further led the company to lose various clients, about 20 clients, including Barclays, the Auditor General, and SAFI. And the loss of these clients also has huge impact on the job losses that many South Africans that were employed there experience. So from this premise, we are of the view that the breakdown of levels of governance processes in the corporate sector, if are left unchallenged, may perpetuate corrupt activities and lack of accountability on the board of directors. But most importantly, the lack of accountability on the board of directors may enhance a view that there is a high risk of investment in South Africa. When one look at the concept of corporate governance, there are different definitions that have been provided by various scholars. For example, Khan argues that corporate governance is a term that describes processes, customs, and policies and laws that directs organizations and corporations in the way they act, administer, and control their operations. Other scholars also view corporate governance as a means of mechanisms that align the objectives and interests between the providers of finance and company managers so that the former have a degree of certainty against the risk that they are taking in making funds available to managers. From us, we are of the view that there is no uniform definition of corporate governance, except that it aims to foster accountability in the corporate sector. The Companies Act, it plays a vital role in codifying or rather providing the general duties of directors. But most importantly, there is a concept or definition titled beneficial interest, which is key to this discussion of today. Section 1 of the Companies Act defines beneficial interest as a right or entitlement of a person through ownership, agreement, relationship, or otherwise alone together with another person to receive or participate in any distribution in respect of the company's securities. Accordingly, having a beneficial interest in a share means that while a particular person may be recorded as a shareholder and is accordingly the registered owner of that share, the rights and benefits attaching to the share accrue and are exercised by a person who is not a registered owner of the share. Now, when one looks at that definition, we are of the view this is where corruption activities have seen in South Africa, especially in recent months, have been perpetuated because of beneficial interests that were not disclosed by various companies when dealing with various contracts with the state. We know that following the COVID-19 pandemic, there were a lot of allegations that the private sector was complicit in corrupt activities. Various companies were implicated, for example, in the abuse of temporary employee and employer relief that were meant for employees whose salaries were affected by COVID-19. And Corruption Watch states that companies claimed benefits on behalf of unknown employees or deceased people, and then poked such monies for themselves or used the benefits for their own purposes. We know that also about 75 companies were probed by the Special Investigative Unit relating to corrupt activities. And these corrupt activities came as a result of companies being used as shells or front to create layers of ownership. Most of these companies are front and therefore allows political office bearers to use them to secure state tenders, and political bearers unduly benefit from these front companies. We appreciate the Companies Amendment Bill that has been introduced now that somehow seeks to address the issue of true ownership, because our view is the companies that are currently faced with various investigations, they are fronts, and the actual beneficiaries often tend to be people in higher positions, wherein you are
Dr. Dennis, I don't know if the 8% is finally drained to zero. All right. I'd love to believe that we have lost Dr. Matotoka. We'll now move on to our next presentation of the session, which is titled "The COVID-19 Pandemic and Corporate Corruption. Is the Companies Act 71 of 2008 adequate?" This is from Prof. Ara Kasim from the University of South Africa. Prof, the floor is yours. Thank you.
Good afternoon. I just want to confirm that you are able to see my slides.
Yes, Prof, we're able to see it.
Yes, Prof.
Thank you very much. I'm very pleased to be able to talk to you today about the escalation of corporate corruption during the COVID-19 pandemic, and whether the Companies Act 71 of 2008 is adequate to counteract corporate corruption. Corruption Watch recorded a high level of corruption by companies during the COVID-19 pandemic, with most reports coming from Gauteng. Malpractices by companies included fraudulent deals between government officials and companies to provide medical equipment which they had no license to sell or distribute. Inflated prices by companies such as Dis-Chem to supply personal protective equipment, PPE. Irregular contract with companies to decontaminate schools in Gauteng during the COVID-19 lockdowns. And as we have just heard, the abuse of the temporary employer-employee relief scheme by many private companies claiming benefits on behalf of unknowing employees and even deceased people. It was also reported that companies that were not registered with the South African Health Products Regulatory Authority had provided PPE to frontline healthcare workers. The United Nations Convention Against Corruption, to which South Africa is a signatory, describes corruption as an insidious plague that has a wide range of corrosive effects on societies and a key element in economic underperformance. The preamble to the Prevention and Combating of Corrupt Activities recognizes that corruption endangers the security and stability of societies, undermines ethical values, jeopardizes sustainable development and the rule of law, and is equally destructive in the public and private spheres. The Constitutional Court has also stressed that corruption undermines the constitutional commitment to human dignity, the achievement of equality, and the advancement of human rights and freedoms. Several statutes form part of South Africa's legal framework governing corruption. South Africa has also signed a number of anti-corruption conventions. This paper focuses on the Companies Act. It highlights provisions that may be used to address corporate corruption and discusses whether the anti-corruption framework in the Companies Act is adequate to counteract corporate corruption. Corporate corruption is the misuse of formal power by a corporate representative for personal benefit or for the company's benefit. It may occur in a single company, between companies, or between a company and the state. For example, in connection with the award of government contracts, or a director bribing a public official for a certain favor. So there may be some overlap between corruption in the private and public sectors. Corporate corruption has generally taken the form of bribery, fraud in state procurement, collusion between a company insider and an external third party for the insider's benefit, and the misappropriation of corporate assets. The term corruption is not defined anywhere in the Companies Act, but it is referred to twice in Regulation 43.5 of the Companies Regulations, which sets out the function of the Social and Ethics Committee. One function of the Social and Ethics Committee is to monitor the company's activities with regard to social and economic development, including the company's standing in terms of the goals of the 10 principles of the UN Global Compact principles and the recommendations regarding corruption of the OECD. Another function is monitoring the company's activities in matters relating to good corporate citizenship, including the company's measures to reduce corruption. As corporate corruption in South Africa has reached distressing proportions, monitoring a company's anti-corruption activities is vital. Principle 10 of the UN Global Compact principle states that businesses should work against corruption in all its forms, including extortion and bribery. This principle requires companies to develop policies and concrete programs to address corruption internally and within their supply chains. The OECD recommendations on corruption prohibit enterprises from offering or demanding a bribe or other undue advantage to obtain or retain business. This document contained many specific anti-corruption recommendations. So the Social and Ethics Committee must bring to the attention of the board and shareholders any failure of the company to comply with the anti-corruption provisions of these documents so that appropriate corrective action may be taken. But beyond a reference to the word ethics in the name of the committee, currently the ethics role of the Social and Ethics Committee is not actually addressed in the Companies Act or the company's regulations. To enhance the effectiveness of the Social and Ethics Committee in dealing with corruption, in my view, the legislature should provide some clarity on the role of ethics. More emphasis must also be given by the legislature to the anti-corruption role of the Social and Ethics Committee. For example, this could be done by explicitly requiring companies to adopt suitable anti-corruption programs in line with the specific corruption risk faced by the companies. To move on to another anti-corruption provision of the Companies Act, which is Section 76, and this section partially codifies directors' fiduciary duties. It has the effect of prohibiting directors from accepting bribes and secret commissions. Secret commissions are objectionable since they undermine trust in the commercial world. When bribes are accepted by a fiduciary, loss and damage are caused to the principal whose interests have been betrayed. Section 76(2)A encapsulates the no profit rule and the corporate opportunity rule, in terms of which directors may not retain any profit made by them in their capacity as directors while performing their duties as directors, nor may they appropriate for themselves any corporate opportunities that belong to the company. Other relevant fiduciary duties in the context of corruption by directors are the duty to exercise their powers and perform their functions as directors in good faith and for a proper purpose and in the best interest of the company. Moving to another section, under Section 69(8)B of the Companies Act, a director convicted of corruption is automatically disqualified from holding office as a director. But the disqualification ends at the later of 5 years after the date of removal from office or the completion of the sentence imposed for the relevant offense or at the end of any extension. A director involved in a corrupt transaction may also be declared delinquent or placed under probation in terms of Section 162 of the Companies Act. The delinquency remedy is an innovative civil remedy that enables stakeholders to hold corrupt directors accountable. The Public Investment Corporation, PIC, a shareholder of the former VBS Mutual Bank, is an example of a company that successfully obtained a delinquency order against 2 of its own non-executive directors involved in corrupt transactions. The directors had been appointed to the VBS board as big shareholder representatives. BIC sought to have the directors declared delinquent following an investigation into the collapse of VBS that implicated the directors in corruption. The court declared the directors delinquent because they had taken bribes in millions of rands through the use of front companies in exchange for turning a blind eye to the looting of municipal stockpile and pension funds at VBS. Under Section 71 of the Companies Act, shareholders and the board may also remove from office directors who are involved in corrupt transactions. But in order for these provisions to be effective in combating corporate corruption, stakeholders must make more effective use of the remedies in the Companies Act in order to enforce the anti-corruption provisions. The Companies Act provides stakeholders with a number of remedies that may be used for this purpose. For example, if the company refuses to bring an action for breach of fiduciary duties against a director engaged in bribery or other corrupt activities, relevant stakeholders may use the derivative action in Section 165 of the Companies Act to require the company to commence legal proceedings against the miscreant director. Relevant stakeholders must also take steps at an early stage to declare delinquent those directors involved in corrupt transactions or to place them under probation. This recommendation applies particularly to directors of state-owned entities, since corruption in these entities has severe consequences for the public and the South African economy. The state, as the shareholder of state-owned entities, also has a responsibility to take steps against directors of state-owned entities involved in corrupt transactions. As the court in Ota versus Mieni emphasized, to serve on the board of a state-owned entity should not be a privilege of the politically connected, and the government has, as custodian of the common good, an obligation to ensure that suitably qualified persons with integrity are appointed in these positions. There are other remedies in the Companies Act which stakeholders may rely on to hold accountable directors involved in corrupt activities. For example, under Section 20, subsection 6, shareholders may claim damages from a person who fraudulently causes the company to do anything inconsistent with the Companies Act. Under Section 20, subsection 4, relevant stakeholders may apply to the High Court for an order to restrain the company from doing anything inconsistent with the Companies Act. Turning to whistleblowing, whistleblowing is regarded as an effective and inexpensive measure to curb corruption. It encourages transparency and high standards of corporate governance. Courts have said that whistleblowing is healthy for companies because managers must be alert to their actions being monitored and reported. Enabling whistleblowing in companies deters corruption and allows companies to manage corruption proactively and thus mitigate its potential impact. The protective measures given to whistleblowers in Section 159 of the Companies Act apply only if the whistleblower disclosed information in good faith. If the relevant requirements are satisfied, the whistleblower will acquire qualified privilege in respect of the disclosure and will be immune from any civil, criminal, or administrative liability for the disclosure. Despite the protection given to whistleblowers, the reporting rates in South African companies are low. The main reasons given for not reporting wrongdoing in companies are the fear of being victimized, believing that the company will not act on the disclosure, believing that the disclosure will not be anonymous, and fear of losing one's job. There have been many reports of whistleblowers who have suffered adverse professional or personal consequences, which discourages persons from making disclosures. For example, recently, the Chief Director of Financial Accounting of the Gauteng Department of Health, Babita Deokaran, who was a whistleblower in an inquiry into corruption relating to COVID-19 PPE, faced intimidation and fabricated misconduct charges and was shockingly gunned down outside her home in August 2021. She was a witness in the Special Investigation Unit investigation into corrupt COVID-19 PPE deals worth 332 million rand in the Gauteng Department of Health. Even though the approach of the Companies Act is to decriminalize company law, certain contraventions still attract criminal liability. For example, it is a criminal offense for a company to fail to maintain accurate and complete accounting records, or to publish misleading financial statements, or to knowingly provide misleading information to any person. These offenses could result in a fine or imprisonment of up to 10 years. These stringent penalties are designed to improve corporate accountability and may deter corporate corruption. In conclusion, in my view, the anti-corruption framework of the Companies Act is sufficiently comprehensive to counteract corporate corruption. Yet, the scale of corruption in South African companies remains high and increased substantially during the COVID-19 pandemic. Stakeholders must make better use of the remedies in the Companies Act to enforce its anti-corruption provisions. The Supreme Court of Appeal has said that corruption is a pervasive and insidious evil that eats away at the very fabric of society and lowers the moral tone of a nation. It must be rooted out of our society because if it is left unchecked or inadequately punished, it has a demoralizing effect on business standards and fair trading and on society in general. Thank you.
Thank you very much, Prof, for such an insightful and interesting presentation. We are well on time. And colleagues, this is a friendly reminder that you can be posting your questions in the chat. We'll move on now to our third presentation of the session, which is by Miss Lisa Jana, an LLD candidate at the Northwest University. The title reads as follows: An analysis of the reliance and use of corporate governance measures to combat private sector corruption in relation to government tenders in South Africa during the COVID-19 pandemic. Lisa, the floor is yours. Thank you.
Good afternoon, colleagues. Thank you very much, Professor Kasim. Thank you to all the attendees. My presentation reads as follows: an analysis of the reliance and use of corporate governance measures to combat private sector corruption in relation to government tenders in South Africa during the COVID-19 pandemic. If you can please move to the next screen. Thank you. The structure of my presentation is as follows. I will go through the introductory remarks and thereafter define the key terms. After that, I will proceed to speak about the corporate governance measures in South Africa to combat private sector corruption in relation to government tenders during the COVID-19 pandemic. In conclusion, I will just close with a few remarks. It's interesting that Professor Kasim has already spoken largely on its very similar aspects on what I am going to speak about. I will speak about the governance measures, the corporate governance measures to combat private sector corruption in relation to government tenders in South Africa during the COVID-19 pandemic. Thereafter, I will analyze the corporate governance measures which have been implemented to combat, or which are in place to combat private sector corruption in South Africa during the COVID-19 pandemic. I will also identify the challenges in combating private sector corruption in relation to government tenders in South Africa. Accordingly, my analysis is of relevance considering that the pandemic is ongoing as the COVID-19 virus is continuing to mutate. Thus, there is an urgent need to examine the measures to try and curb corruption and suggest possible corrective measures to combat private sector corruption in relation to government tenders in South Africa. If you can please go to the next slide. As I go through the definition of the key terms, I will speak about collusion. Collusion refers to secret agreements or cooperation by people within a company to cooperate to achieve an illegal purpose. And a contract refers to a legally binding agreement between or among its parties. Corporate governance refers to the rules, the practices, and processes whereby a company is directed and controlled. And corruption refers to the abuse of the position of authority by a person within a company in order to give or receive a benefit in an undue manner. And COVID-19 refers to the coronavirus disease, which is the disease that's new and is highly infectious and has been caused by the SARS-CoV-2 virus. Then procurement refers to the process of sourcing and purchasing goods and or services for a business enterprise. The purposes of the Prevention and Combating of Corruption Activities Act 12 of 2004, which I'll refer to as the PRECA. So the PRECA was enacted to strengthen measures to prevent and combat corruption. It was also enacted to provide for the offense of corruption and offenses relating to corrupt activities, and to provide for investigative measures in respect of corruption. Furthermore, it was enacted to provide for the establishment of a register of default tenders, of tender defaulters, in order to place restrictions on such people or entities from contracting with the state. And it also places a duty on people in authority to report corruption as they see it. You can please go to the next slide. So the offenses under the PRECA, there's a general offense of corruption, which is mentioned in section 3. And it refers to any person who accepts or agrees or offers to accept any gratification from any person, or gives any undue gratification to influence another person to abuse a position of authority in order to act in a manner that amounts to the illegal misuse of information or material so as to achieve an unjustified result. And if a person commits any of these offenses, they will be found guilty of the offense of corruption. Furthermore, section 12 states that any person who accepts, agrees, or offers to accept any gratification from any other person in order to improperly influence the execution or procurement of a contract, or gives any undue gratification to influence any other person to abuse a position of authority in order to improperly manipulate or fix a price or other monies stipulated in a contract, is guilty of the offense of corrupt activities relating to contracts. Can you please move to the next slide? Section 13 speaks to any person who accepts or offers to accept any gratification as an inducement to manipulate the awarding of a tender, or any person who gives or offers to give any gratification as an inducement to manipulate the awarding of a tender in relation to a contract for performing any work or service, will be guilty of the offense of corrupt activities which relate to procuring and withdrawal of tenders. Please, can you go to the next slide? Please, can you go to the next slide? Thank you. Furthermore, anyone who holds a position of authority, as defined in section 34, as a manager, secretary, or a director of a company, or a member of a closed corporation, an executive manager of a bank, of a financial institution, or a partner in a partnership, a chief executive officer, or any other person who is responsible for the overall management and control of the business or legally recognized entity who knows or should have known, reasonably known, or suspected that another person has committed an offense of corruption should report their suspicion to the Directorate for Priority Crime Investigation, and a failure to do so will be regarded as an offense in terms of the PRECA. Please, can you move to the next slide? Thank you. According to the Companies Act, there's a requirement for every listed public company and every other company which has in the previous 5 years scored above 500 points in terms of its public interest score, required to have a social and ethics committee. And the function of the social ethics committee is to monitor the company's activities for compliance with relevant legislation or prevailing codes of best practice with regard to matters relating to the OECD recommendations regarding corruption. And this is in order to curb corruption. And once incidences of corruption or matters of corruption are identified, there is a responsibility on the Social and Ethics Committee to bring those matters identified before the shareholders and also bring this to the attention of the board at the annual general meeting. Please, can you move to the next slide? Please, can you move to the next slide? Thank you. The King 4 report on corporate governance also speaks about it assists companies to create an ethical business culture, because the King 4 report is non-binding. Therefore, it assists, it does not mandate. However, because it has strong persuasive force in South Africa, it is recommended for companies to actually follow and abide by the King 4 report. Furthermore, the King 4 report emphasizes on ethical leadership, and it advocates the establishment of an ethical culture and responsible corporate citizenship. So for companies to create or to develop an anti-bribery and anti-corruption policy. Therefore, the prevention of corruption within the company is a board responsibility, which is critical for the good governance of the company. Please, can you move to the next slide? Furthermore, so these safeguards that have been put in place to guard against private sector corruption within the private sector in relation to dealing with the government, because everyone wants to deal with the government. The government is identified as the biggest business partner in South Africa, because based on the amount of business that it gives out. Everyone clamors for business with the government, but while doing it, it must be conducted ethically. Therefore, any failure to adhere to the PRECA will be met and with the requisite or with the corresponding penalties. For example, Section 26A, if a person is convicted in the High Court convicted and found guilty of committing corruption, they'll be liable to a fine of imprisonment and thereafter up to a maximum of life imprisonment. If they convicted in the magistrate's court, they are liable to a fine of imprisonment or a fine or imprisonment of 18 years. Please, can you move to the next slide? Another safeguard that has been placed by the PRECA to curb corruption is the establishment of a register of tender defaulters in terms of Section 29, whereby a person who is convicted by a court for committing corruption can be also endorsed on the register of tender defaulters. And if that person is a juristic person, the court may also issue an order that the particulars of that person, together with the particulars of any other natural person who could be, in this case, partners, managers, directors, or any other natural person who exercises control over that juristic person and was involved in the commission of corruption, be endorsed on the register of tender defaulters.
Ms. Chana, you have 4 minutes left.
Hello, can you hear me?
Yes, we can hear you, ma'am. You have 4 minutes left.
Sorry about that. Oh, thank you. Let me just finish up and round up. So the tender defaulters register is maintained by the National Treasury. However, the challenge is that after the person is supposed to be listed on this national register, there actually is no one on the register of tender defaulters at present. I actually looked, the last time I looked on the tender defaulters register was this morning, and there's no one there, which is a concern. If you can please move to the next slide. So it appears as if there's a penalty for failing to report. However, there's no reporting being made, or there's under-reporting of corrupt activities, because during this time, if you can just please move to the next slide. During this time of COVID, it has come out in the issue of, in the case of Masuku versus Special Investigations Unit and others, I've put the citation below, where it came out that there were a lot of companies involved in collusion in tendering for the state. However, these have not been met with the correct, it's been the government side combating the corruption. However, in terms of the corporate measures being taken, we do not see that. So that's a challenge. Therefore, there's a duty to report. And it could be that the under-reporting is caused because of protection, the lack of protection for whistleblowers. For example, if you can please go to the next slide. For example, you will note that there's the case of Babita Diokaran, which has been mentioned by Professor Kasim, who was shot in cold blood. And it is suspected that it's because she was a whistleblower. So these issues could contribute to the under-reporting by people for fear of their lives. And which is why there's no one on the tender register. So that's a challenge. So furthermore, the Protected Disclosures Act only provides protection for public, in the public sector. It provides only for employees, and you have to meet the definition of an employee. If you are not an employee of that particular employer, you're whistleblowing, then you are not protected by the Protected Disclosures Act. If you can please move to the next slide. Therefore, my recommendations and closing remarks are, there should be more robust enforcement of the PRECA. Like, as I said, there's no one on the tender defaulters register now, which means clearly there's more robust enforcement required. There's more protection required for persons who are obliged to make reports of suspicious activities. It shouldn't be very narrowly defined only to employers of that particular person. It should actually be extended to the officious bystander. Anyone who can see, because we are all affected by corruption in one way or another. Furthermore, a publicly available register of awarded tenders during the COVID-19 period should be enforced. And all national persons who are in control of such juristic entities and have been awarded tenders, together with the details of the closest losing bid that failed to get the tender, should also be gazetted or listed. Furthermore, there should be a ring fencing of funds by the state for COVID-19 related funds, procurement funds. And there's a need to strengthen compliance. All companies should have bribery policies, not just for the thresholds given in the Companies Act, but it should just be for all entities across the board. Every company should have a bribery policy. And there should be training to employees on ethical behavior, and especially to salespersons, client-facing staff who are exposed to the offers of corruption at times, or who may be the introducers. Furthermore, it also should extend even to the high-level persons such as the shareholders, directors. Everyone should be trained on ethical behavior. Thank you. If I should just go to the last slide. That is my presentation. Thank you, colleagues.
Thank you very much. Thank you very much, Ms. Jana, for that presentation. And thank you very much, Dr. Matotoka, for having partaken, even though load shedding disturbed your presentation. Thank you very much also, Prof. Kasim, for that presentation. I'll take this time to pose some questions and reiterate some of the comments which are in the chat. Firstly, there is a comment from Prof. Tsepo Mongalo to you, Prof. Kasim. He says, excellent presentation, Prof. The presentation should preferably be shared also with law enforcement authorities. And from Prof. Osode, it's actually a question to you, Prof. Kasim. The question reads, would it make sense to consider reform that could enable NGOs such as OUTA, Corruption Watch, etc., to become more active in enforcing anti-corruption provisions of the Companies Act, or to force the CIPC to do the same? I'll give this opportunity to Prof. Kasim to answer to that question. Over to you,
Thank you very much. Thank you first, Prof. Mangalo, for your comment and your suggestion. I'll look into how these suggestions may be shared with law enforcement authorities. Thank you, Professor Osodi. That is a very good question. It would be good, yes, to have reform to make it much easier for NGOs to enforce the anti-corruption provisions, but there is currently a provision in the Companies Act which does enable this to some extent. Section 157 of the Companies Act gives extended standing to persons to apply for remedies under the Companies Act if they can show that they are acting in the public interest, but they will need the leave of the court to do this. For example, in the OTA versus Myeni case, the reason how OTA managed to bring an action to declare Judy Myeni delinquent is that they did it under Section 157 and argued that they are acting in the public interest of major public entities, of society in general, of the South African economy, and so on. And the court accepted that ground and allowed them to then bring the delinquency action against Judy Myeni. So there is currently a section, but it would be good if more prominence were given to it, and perhaps if we did have stronger legislation allowing other parties to enforce these provisions. Thank you.
Thank you very much, Prof. I hope that answers your question, Prof. Osode. And then there's also a question from Prof. Chitimira. The question reads, what are your views on governmental efforts to curb corruption in South Africa? Are we doing enough? And is the setting up of commissions such as the Zondo Commission the best way to go? Over to you, Prof.
Thank you, Professor Chitimira. You raise a very good question and make an excellent point. Are we actually doing enough? I think governmental efforts such as setting up the Zondo Commission, it is a good start. It has allowed a lot of corruption to come out and a lot of things have been exposed. But on the other hand, it has dragged on for a very long time. It has been very costly, and we're yet to see the report, and we're yet to see what teeth the report does and what the commission actually has in terms of enforcing, taking action against those who are involved in corrupt action. So I think we'll have to wait and see how that works out. But it is a good start, but I do think that more needs to be done. And I think more needs to be done much sooner as well. So it does not drag out for such a long time, because things really are at an extremely high level in terms of corruption in South Africa. Thank you.
Thank you very much, Prof, for that response. I hope it answers the question to Prof. Chitimira. Colleagues, I would like to extend my heartfelt gratitude for having partaken in this session. We thank you very much for this thought-provoking and insightful session. Now we'll move on to session 9. And I'd love to give this time to the chair for session 9, Mr. S.R. Olcock. Thank you.
Thank you, colleagues. I'm chairing this session. My colleague has an engagement.
Huh? Not yet, when they call you.
All right. Thank you, colleagues. We welcome you to this session. My colleague is not able to be here from Juta. I will explain a little bit here of what we're trying to achieve here. The rationale for this session is to encourage colleagues to know the new developments in the area of corporate law, finance law, or financial markets law. So we use this as a platform to allow new authors or those with new books to talk about their books. And at the end, we might allow questions and comments. So in this regard, we are privileged to have Professor Farouk Kasim, who is going to be talking about the new book that has come out under Juta, Law of Corporate Finance. Over to you, Prof. Kasim. Prof. Kasim, yes, go ahead, say.
Good afternoon, everyone. It's not often that one gets the opportunity to listen to the author of a book describing various aspects and features of the book he has written. I'm going to spend a few minutes, 5 or 6, describing aspects of the law of corporate finance. The law of corporate finance is an indispensable resource for the judiciary, legal practitioners, accountants, auditors, corporate law experts, academics, and tertiary students. It runs into 538 pages with reference to some 400 cases and contains detailed discussions on some leading foreign jurisdictions, such as the USA, English law, Australian law, and New Zealand law. These discussions at the sort of level that we have written them are not to be found in any other book on the subject. Both authors of the law of corporate finance are experienced authors of books on corporate law. Famida has authored and co-authored 6 books on the subject, and I have authored and co-authored 7 books on the subject, including some chapters for 2 loose-leaf reference works on the subject. Without being immodest, our books have frequently been cited with approval in the courts, including the Supreme Court of Appeal and even the Constitutional Court. Contemporary company law, authored by us and 4 other academics, has quickly established itself as the leading book on company law. I am aware that copies of the book are available in the libraries of the Institute of Advanced Legal Studies in London, Harvard University in the USA, and law libraries in Canada and Australia. Both authors of the law of corporate finance have considerable experience as academics, lecturing company law to commerce students and to undergraduate and postgraduate LLB and LLM students. This experience has enabled us to expound arcane and complex company law theory, principles, and concepts in clear and lucid terms. This is an approach that is meant to be of assistance also to university lecturers teaching the subject of corporate finance. The law of corporate finance contains detailed discussions on the nature and classes of shares, share capital, debt instruments, hybrid securities, chapters on distribution, share buybacks, and financial assistance by a company for its shares. Public offers of securities in the prospectus has been given a comprehensive and critical treatment not to be found in other textbooks. The dominant topics of corporate finance in general receive an in-depth analysis. Where applicable, leading cases are analyzed and explained. A highlight of the book is that it includes a discussion of the legal remedies available to investors when the legal rules relating to corporate finance have been flouted. We have made a substantial effort to research, to analyze, and compare the equivalent provisions in foreign jurisdictions that have exerted a strong influence in molding our Companies Act. We do more than merely recite the provisions of the Companies Act. Instead, the reader will find detailed discussions and analyses of equivalent and relevant statutory and common law principles in England, Australia, New Zealand, Canada, and unusually and exceptionally also the USA. This provides the reader with valuable insight and guidance to the interpretation and the understanding of the corporate finance provisions of our Companies Act of 2008. A further unique and important feature of this book is that we have formulated practical and hypothetical examples to assist the reader to obtain a proper grasp of the legal principles relating to the subject. We also discuss its philosophical foundations and the practical application. These practical examples serve to highlight the defects and shortcomings of some of the provisions of the Companies Act. And all this is done in a user-friendly style. The law of corporate finance includes a discussion of the Companies Amendment Bill of 2018. The recent Companies Amendment Bill of 2021, published only a few weeks ago, contains some of these new provisions. But happily, they do not directly affect the contents of the law of corporate finance. This is because the new provisions of the new 2021 bill are focused very largely on the provisions relating to disclosure of executive remuneration and the Social and Ethics Committee, both of which fall outside the scope of the law of corporate finance. The proposed provisions of the 2021 Amendment Bill that do impact the field of corporate finance remain essentially the same as those contained in the 2018 Amendment Bill. And these provisions are discussed in the book on corporate finance. One final snippet of information, the most important one perhaps, is that the book is selling at 895 rands. It states the law as at January 2021. Famida and I both believe that there is much in this book that will provide useful guidance to the reader on a notoriously difficult subject. Thank you.
Thank you very much, Prof. You stayed in the time. We are grateful for that. Thank you very much. I'll take this opportunity, colleagues, to introduce the next speaker is Prof. Mongalo. He's going to be talking to us about the new journal we're having on this field: corporate law, commercial law, finance law. So over to you, Prof. Mongalo. Tell us more about this journal. Thank you.
Thank you very much, Professor Chitumira. And again, good afternoon, colleagues and everyone who's participating here. I'm trying to obviously follow the example of Professor Kasim in terms of staying within the time, although I think I have got quite a lot to say about this journal. Now, I'm speaking here about the Journal of Corporate and Commercial Law and Practice. My talk is going to be divided into 4 aspects, actually 5. The history of the journal, focus areas of the journal, including contributions published, accreditation status, views of the DHET panel that considered the accreditation application in 2018, and way forward and call for contributions. Starting with the history of the journal. The proposal for the establishment of the Corporate and Commercial Law Journal was actually made at the University of Wits in 2013. And preparatory work was undertaken between 2013 and 2014. And in late 2014, negotiations were already underway with the leadership of Wits and the publishers. And in 2015, a publication agreement was reached and signed with JUTA. In the last half of 2015 academic year, the first issue was published as issue number 1, although it came in the second half of the year. And the journal has been continuously published on a biannual basis since then. In 2018, after 3 continuous years of publication, the accreditation application was made in line with the guidelines of the Department of Higher Education and Training on the policy on publications. And the DHT panel responsible for reviewing the journal made positive findings about the journal, but reached a conclusion that the journal was not ready for accreditation then and recommended reapplication in 2022. Now, what about the focus areas of the journal, including contributions published thus far? Now, the contributions are actually published in this journal from legal academics, from legal practitioners, from policymakers and legal scholars, as well as law students, preferably those pursuing higher degrees. And the contributions that have been published and are also required for publication in the journal are those that are dealing with corporate and commercial law and practice, with specific emphasis on the application of constitutional law, foreign law, and public policy imperatives on the area of corporate and commercial law. And this was the initial view of the managing editors of the journal, because the intention was to try to help in the interpretation, improvement, and development of novel corporate and commercial law concepts in many arrays of legislative instruments which were introduced since 2008 or 1998 with the Competition Act, and then followed by the National Credit Act and the National Consumer Act and the New Companies Act. Now, the journal remains a forum for scholarship on corporate and commercial law and practice broadly construed. Now, insofar as the accreditation status is concerned, I briefly mentioned it, but I just wanted to say that the general accreditation was applied for in 2018, and the outcome was received in 2019. The DHET panel responsible for the accreditation made views regarding the readiness of the journal. And when the application was made, the intention by the editors was that they needed to assess the journal's readiness for accreditation application with other accreditation institutions such as the Norwegian list, the ISI, and Scopus, and others. Now, the DHET panel responsible for reviewing the application made the following findings. Many positive aspects of the journal, and it also suggested areas of improvement. Now, with regard to the many positive areas of the journal that have been identified by the panel, they have discovered that there is a high national or international disciplinary reputation or standing of the managing editors, who it was seen that they were experts in the fields of corporate and commercial law, and that the editorial advisory panel is diverse in terms of expertise in various aspects of corporate law and practice, and that the quality of articles accepted or published are of a high and appropriate standard, and that there was well-balanced coverage of both international and local corporate and commercial topics of both academic and practical nature. And they also made this positive finding that the publication of articles by authors from across the country and internationally were found across all the issues that have been published, and that it is suitable as a vehicle for publication of work by local graduate students, young staff in the discipline concerned. On the areas of improvement, as I am about to conclude, the panel found out that the editorial advisory board could be more diverse in terms of jurisdiction, where they viewed that a majority of international board members were at the time from the USA, and this has actually been addressed. And some clarity is needed in terms of the purpose, length, research, and educational values of the practice notes. One distinguishing feature about this journal is that it actually publishes practice notes, which are helpful in terms of practitioners getting information on the latest developments, not only in South Africa, but all over the world. And the journal, as the panel viewed it, can benefit from including book reviews. And I'm just thinking about the book that has just been summarized by Professor Kasim on the law of corporate finance. And the panel was saying that we need to have more of book reviews, as at the time we did not have any book review in the journal. And they also viewed that clear guidelines must be provided to deal with instances where editors or members of the editorial committee or advisory board publish in the journal. And finally, that the editors need to think seriously about the layout and design of the journal. Therefore, it's very clear that in their guidelines for our reapplication for accreditation in 2022, these are the aspects that we need to address. All, I can say, most of which have already been addressed, if not all. And therefore, we are ready for application for accreditation next year. And on the way forward, the journal will continue to be a forum of scholarship on corporate and commercial law and practice. And we appeal to those who are practicing or even researching in this area, and many of you are on this platform, should actually consider sending your contributions to this journal, as we are finalizing the first edition of 2021, which we are doing concurrently with the second edition. And therefore, we are looking forward to all the contributions from all of you on any area of scholarship on corporate and commercial law and practice, and also practice notes for those who are already in practice and would like to share on a practical aspect of corporate and commercial law. The person to contact in this area is, with regard to the journal articles, is Professor Dorothy Farisani at the University of South Africa. And with regard to practice notes and notes, it is Professor Caroline Ngube at the University of Cape Town, and also myself with regard to general queries regarding the journal. And the other editors that are on this platform, Professor Chitimira is one of them, Professor Kawadza is one of them, and also Professor Marumwa Khai at the University of Wits. They are all in the editorial committee. The editorial committee is quite diverse, covering a whole lot of academics from across the country. And the advisory team is also very diverse, covering the academics and also practitioners, not only from South Africa, but all over the world. Thank you very much.
Thank you, Prof. You did well as well. You stayed in your time. I don't want to waste much time. I'm going to leave this time to Professor Rihanna Kasim to tell us more about a new book, as you see it on the program. Over to you, Prof.
Thank you, Professor Chitimira, and thank you very much for the opportunity to talk about a book I authored that was published by Juta recently. The book is titled The Removal of Directors and Delinquency Orders under the South African Companies Act. The Companies Act 71 of 2008 introduced into South African law a provision contained in Section 71(3), which for the first time permits the board of directors to remove a fellow director from office. While the power of the shareholders to remove directors is retained, as discussed in this work, the novel power conferred by Section 71(3) shifts the balance of power between the board and the shareholders to the extent that the shareholders no longer enjoy the exclusive power to remove directors from office. From time to time, it may be necessary to remove a director from office. Reasons for this include poor performance, misconduct, breach of duties, unethical conduct, or involvement in a corporate scandal. The removal must be carried out lawfully with strict adherence to procedural requirements, and it is thus important to understand the conditions and procedures for the removal of a director from office. The failure to properly remove a director may have negative consequences for both the board and shareholders. The rationale of permitting directors to be removed by the board is to enhance the accountability of directors. While there is merit in conferring this removal power on the board, questions inevitably arise as to whether the concern about removal by the board will stifle the independence and the actions of a director in managing the company's affairs, and whether the power to remove might be abused. This book examines whether the provisions on the removal of directors by the board may be strengthened in order to guard more effectively against the potential abuse by the board of its power to remove a director. From a philosophical point of view, the book outlines the historical and philosophical underpinnings of the removal of directors. It examines the division of powers between directors and shareholders and analyzes the impact of the board's power to remove directors on the shareholders and on the board itself. The book also canvasses the fiduciary duties of the directors when removing a member from the board. This work also examined the removal of directors by the company's tribunal, as well as the thorny issue of the remedies that may be relied on by a director who has been removed from office by the shareholders, the board, or the company's tribunal. A further significant innovation relating to the directors of a company is contained in Section 162 of the Companies Act, which empowers a court to make an order declaring a director delinquent or placing him or her under probation on various grounds. The delinquency and probation remedies are analyzed in detail in this work. In addition, recent cases are discussed in this book, such as the case of Old Mutual versus Moyo and Ota versus Miyeni, in which Ota acted in the public interest and succeeded in applying to court to have Judy Miyeni declared a delinquent director for life. The book offers guidance on the interpretation and application of the procedures that may be used by directors to suspend or set aside an order of delinquency or probation. The Companies Amendment Bill of 2021 does not affect the content of this book. From a practical point of view, the book draws attention to pitfalls that must be avoided when removing a director from office and discusses nuances in removing directors that are often overlooked, such as removing directors who are also employees or shareholders who hold loaded voting rights. The book furthermore explores the complex removal of directors of state-owned companies and declaring delinquent directors of state-owned companies. A unique aspect of this work is that it also considers the removal process from the perspective of a director who has been unfairly removed by a hostile board and considers ways to guard against the abuse of the removal power. The analysis in this book on the removal of directors and delinquent directors involves a comparative study with the equivalent provisions in the United Kingdom, Australia, and the United States of America. Recommendations are respectfully made in this work to improve and enhance the law on the removal of directors and delinquent directors. Some of the statutory provisions in the Companies Act on the removal of directors and delinquency orders are unclear or ambiguous. I hope that this book will shed some light on these ambiguities and clarify them. This work is offered as a scholarly work for the subject specialist. The target audience includes legal academics, the judiciary, corporate law practitioners, company directors, company secretaries, and other professional persons who deal with companies. It is my hope that the book will serve to guide those who deal with companies on how to properly remove miscreant directors from office, and to do so in a way that will not result in unnecessary legal proceedings. I thoroughly enjoyed writing this book, mostly because I am passionate about the subject matter. As I discussed earlier, the subject matter of this book is important to me because the scale of corruption in South Africa has reached distressing proportions. It's imperative for steps to be taken by companies and stakeholders to mitigate these high levels of corruption and hold corrupt directors accountable. At times, it was challenging to simplify certain complex legal principles and concepts and to explain them in a way that is understandable to a more diverse group of readers. I hope I have achieved this in this book. Thank you.
Thank you, Prof. Again, you did well on time. We are grateful, really. Colleagues, the floor is open now. Those who want to pose some questions to the presenters, you are free to do so. I want to congratulate Prof. Kasim on their books. I also want to thank and congratulate Prof. Mongalo for this initiative of another journal in the area. Colleagues, let's engage. Thank you. Anyone? I don't see comments. I don't see questions. Yeah, but there are a lot of comments. I'm not going to read them that are coming. Thank you, colleagues. In the absence of questions, I would want us to, okay. Hello?
Prof, sorry?
Yes,
Yeah.
Prof, Odek, go ahead.
Yes, sir. Good afternoon. I was going to make a comment on the book presentation by Hello? I was going to make
Go ahead.
I was going to ask a question regarding the book presentation by the last presenter. I noted that Dudu Myeni's case was cited in the book, and I was wondering whether there is any form of way forward in terms of suggestion from the presenter that a company like Steinhoff and the directors of Steinhoff, they sort of have a similar issues with corruption, maladministration, or whatever you can call it in terms of the way they handle it. Why is it that we don't have anybody instituting action to declare them as a delinquent director? And secondly, when we talk about delinquent directors going to court, it's not an easy thing in terms of finances to get a lawyer to go on behalf of a litigant to go and, like in the case of Dudu Myeni, where the litigant, they have the wherewithal, they have the financial muscle. So what is going on? What are you going to suggest regarding Steinhoff and the way forward in terms of finances to enable somebody to go to court and institute an action against a herring delinquent director? Thank you.
To say, thank you very much for your question. It's a very interesting point. Yes, in the Ocha versus Myeni case, Ocha had the finances to bring the action against Dudu Myeni, and one wonders why the insiders in SAA didn't do it, because they would have had first-hand knowledge of the corruption, because Section 162 of the Companies Act gives a broad range of persons standing to bring a delinquency action, such as the directors, the shareholders, the company secretary, even a trade union can do it. So yes, one wonders if Ocha had not done it, whether anybody would have taken this action. But I do think what you make is a relevant point, that a lot of the time it is a cost issue. And it could be that the directors or the company secretary, for example, would not want to spend those legal costs going to court to bring an action against someone to declare them delinquent, when it will cost them a lot of money. But what is positive, and you will see this in the Dudu versus Myeni, in the Ocha versus Myeni case, is that the court made a cost order on an attorney-client basis against Dudu Myeni, which is much higher than your normal party costs, which means that OCHA would have recovered its costs at quite a high level and would have recovered some of those expenses that it incurred in bringing this action against Durimieni. So if a person is successful, they have that on their side, that they may get costs and maybe even on an attorney and client basis, which would be some comfort in bringing this action. But I do think that some sort of mechanism or funding or something of that sort would be very useful to encourage persons to bring these delinquency action, because without it, if OCHA had not taken the action, it's possible that Durimieni would never yet have been declared a delinquent director. I hope that answers your question.
Thank you very much.
Thank you, colleagues. Any other comments, questions?
Thank you, Prof. For the
I put in a, sorry, I typed in a question. I don't know whether I need to repeat it verbally, maybe. I thanked Professor Kassim for her interesting presentation. And then I also mentioned that, we can learn something about stamping out corporate corruption from Coca-Cola. Coca-Cola have this formula which is unique and which a lot of people have been trying to steal or replicate for many, many years. But they pay them so well that they don't think of stealing it and selling the formula. So from that perspective, Professor Kassim, in South Africa, do you feel or do you detect or do you observe that perhaps the corruption emanates from poor remuneration? Thank you.
Thank you very much for that question. It's again a very interesting point. I don't think that necessarily it is related to poor remuneration. I don't think that directors in large JSE listed companies, are paid so poorly, and yet you find, or in state-owned entities, for example, and yet you find, especially in state-owned entities, that directors are engaging in corruption. For example, in SAA, there's a large amount of corruption we have seen in there, but I don't think it's the case that they are not being paid well enough. True, maybe they're not being paid as well as they would be, as Coca-Cola would pay, but you often find that it's a lot of time they're being paid fairly well, and yet they still engage in corruption and maybe try to take bribes in certain places or engage in other underhand dealings which they should not. So perhaps it would make a difference if they were paid even more, but I don't think that's a good idea, because if you look at the Companies Amendment Bill of 2021, it now wants us to disclose the difference in salaries between the highest and the lowest paid employees to show what a big wage gap there is. And as we know, South Africa has a very big wage gap. So if we're going to pay them even more in an effort to avoid them engaging in corruption, it means that we make the wage gap even wider, which I don't think that we should be doing. If anything, we should be trying to narrow down that wage gap. So perhaps to some extent it is remuneration, but I think it also has other reasons why our directors, especially in state-owned entities, do engage in corruption. I hope that answers your question. Thank you.
Thank you, Prof. We're going to ask you to respond again. There's another question from Mr. Taura. Please be brief. Go ahead.
Thank you. Thank you, Prof. I just want to ask, for you have already explained about SAA directors and their delinquency and how they are declared delinquent. But I want to take you back to appointment of those directors. Like the sections in the Companies Act provide for appointment of directors, and then does it actually cover well on the appointment of directors in state-owned companies? Because from my understanding, the Companies Act generalizes the appointment of directors, and also you find the SA Act, which is the founding legislation for SAA, specifically state that Section 66 of the Companies Act is not applicable to
when appointing directors. So does the Companies Act cover or address the issue of appointment directors of state-owned companies adequately? Thank you.
Thank you very much for your question. The Companies Act, to some extent, yes, does deal with the appointment of state-owned entities in that the general provisions regarding state-owned entities would apply to it, and it does also specify the number of directors that state-owned entities must have, which is 3 directors. So in that regard, it does address it. But you'll also know that state-owned entities are generally governed by their own specific legislation. For example, there's a specific piece of legislation dealing with SAA and a specific piece of legislation dealing, say, for example, with the South African Broadcasting Corporation, the SABC. So in dealing with state-owned entities, both in appointing these directors and in removing them, we need to actually look at the specific legislation that governs them. And that may say, for example, additional requirement for the appointment, or whether they need specific qualification, or how exactly additional directors must be appointed, who approves them, and so on. And what's also very tricky is their removal. Often there's a conflict between the Companies Act and the specific legislation governing the specific state-owned entity. And this happened exactly in the case of SABC a few years ago when directors were removed. So you then need to read the 2 of them together and see how to resolve the conflict. So you can never just look at the Companies Act when looking at dealing with state-owned entities. You'll have to find the specific legislation that governs it and read it together with the Companies Act. I hope that clarifies that.
Public management.
Oh, yes, that's a very good point. Sorry, Professor Kasim, sitting next to me, also mentioned that the Public Finance Management Act also governs state-owned entities. If you look at that, you will see it sets out duties of directors, additional direct fiduciary duties of directors of state-owned entities, and that also deals with the appointment of directors of state-owned entities. So that also needs to be read together with the other 2 acts of legislation. Thank you.
Excellent. Thank you, colleagues. Yeah, in the interest of time, I think there are so many nice comments there, Prof. De Keuka, Pamelo. We thank you all for the session that was lively. At this time, I think I'll leave it to the next chair. I think the next chair is Prof. Odeku. Thank you.
Good afternoon, colleagues. And thank you very much, Professor Shetimira, for giving me this ample opportunity to anchor this session. And as I have read through the program, I can see that very topical issues are here under section 10. And the theme is corporate finance law and corporate insolvency. Very, very interesting. The first presenter on the list is Professor C. Marumaga of Wits University. And the paper title, Does a Trustee Claim to Set Aside an Impeachable Disposition Constitute a Debt or Right? Can we please have Professor Marumaga, please? I'm sorry if I have not pronounced the name very well. An apology.
Thank you very much, Chair. Are you able to see my presentation, my slides?
Yes, sir. Yes, sir. Yes, sir.
Thank you very much, Chair and colleagues. The paper that came out, it's quite different from the abstract that I gave. And I think if you are a proponent of research, I think that will be understandable. In actual fact, the paper that I wrote, I could see that there were about 3 papers that could actually be written. So I decided to go with a 3rd one that came out of it. And it's impeachable transaction defenses. Can ordinary course of business and intention to prefer be separated? I mean, initially I wanted to speak about the rights of trustees to be able to institute applications to the High Court to set aside impeachable transactions. But when I was doing the research, I saw that it was becoming more procedural as opposed to be linked to company law. So I was forced to come up with something that really spoke at least to corporate insolvency law, hence the title that I'm actually discussing now. Impeachable transactions, defenses, can ordinary course of business and intention to prefer be separated? Now, in this paper, I will be reflecting on how the law regulates transactions that are entered into by insolvent companies before they are liquidated, which have the effect of reducing the assets of such companies to the prejudice of other creditors. So in other words, I'm looking at the right of the trustees and the liquidators once they are appointed, trustees in terms of sequestration and liquidators in terms of liquidation, once they are actually appointed, to be able to go after the transactions that were entered into by the either insolvent person or the insolvent company before the liquidation or sequestration was granted, and to see as to whether they are able, if there were dispositions that were made before liquidation and sequestration, are they able to bring some of those assets that might have been taken out of the company's coffers or even the person's estate back into either the company or even the estate of a person. So as such, I will be reflecting on what liquidators can do to bring those assets which may have been taken unlawfully out of the coffers of the company or the person's estate, and in particular to zoom into the defenses, if any, which are available to ensure that those particular assets are brought back into the companies. But most importantly, what the paper focuses on, it is the defenses that are raised by the people who stood to benefit, or some of the companies that transacted with the insolvent company, to see whether there are any defenses that they could actually raise to make sure that these particular transactions cannot be impeached. And in particular, I mean, I deal with all of them in the paper, but in particular, I just want to zoom into the two of them. When you look at section 29 in particular, it talks about that when a transaction, or when the creditor who stood to benefit from the transaction itself can show that that transaction was actually carried out in the ordinary course of business, then that will be a defense for that transaction not to be impeached. Or when he can show that there was no intention to prefer any of the creditors, then should the liquidator or the trustee fail to show that, that can be a defense against some of these transactions. Now, here it is really important to make a point that when one looks at various cases, you look at some of the courts are of the view that when a creditor relies on ordinary course of business, the courts are of the view that the question of intention does not necessarily play a role. In other words, if it can be, or notwithstanding the fact that there was intention to prefer, if it can be shown that whatever transaction that took place before liquidation took place within the ordinary course of business, then that would be a viable defense. So what I'm trying to interrogate in this paper, it is whether this particular line, ordinary course of business, can actually stand on its own, independently of intention. Because one will look at when things happen in the course of business, but there might be an intention to prefer one creditor or the other. So can it be that notwithstanding the fact that there was intention to prefer, the mere fact that what occurred during the ordinary course of business, should that be able to stand? So later on, this is the point, the main point that is being interrogated in this paper. Impeachable transactions are those transactions that are entered into or on behalf of a natural or juristic person before his or her, or its sequestration, or the winding up which entail the disposition of that person's property, and which may be set aside or declared to be invalid after the commencement of sequestration or winding up. In other words, these are just transactions which, when they were entered into, the company or the person was contemplating insolvency. And perhaps maybe it might be that they were trying to shift them away from either the company or the person's estate in order to ensure that some of the creditors are being prejudiced, or one or two of the creditors are being benefited as opposed to others. So the legal framework for setting aside impeachable transactions is aimed at safeguarding the interests of creditors and to ensure equitable distribution of the assets of the insolvent persons among all the creditors. And to achieve this, the Insolvency Act creates a mechanism for the impeachment of certain categories of transactions entered into by the insolvent pre-sequestration transactions. And Section 32 of the Insolvency Act vests the trustee with, or the liquidator in terms of companies, with the right to institute legal proceedings to set aside such avoidable transactions, or for the recovery of compensation equal to the value of the property disposed of, or for the payment of company. In other words, there is a legislative framework which enables the trustee or the liquidator, upon being appointed, to zoom into transactions that entered, or that were entered into, or that took place before the company was liquidated or the person was sequestrated, to ensure that those particular transactions can be reversed in order to ensure that the creditors are not prejudiced, as it were. In terms of Section 304 of the Companies Act of 1973, as we know that the current Companies Act does not necessarily deal with insolvent companies. So the provisions of the old Companies Act, in as far as insolvent companies are concerned, is still applicable. So every disposition by a company of his property, which if made by an individual could, for any reason, be set aside in the event of his insolvency, may, if made by a company, be set aside in the event of the company being wound up and unable to pay its debts. And the provisions of the law relating to insolvency shall apply equally as they are applicable to that disposition. In other words, what the Companies Act does not necessarily deal with insolvency per se, even though it refers to it. In other words, it refers us back to the Insolvency Act. It says, look, we are going to make provision, or it does make provision for the setting aside of these avoidable transactions, but it says the details as to how this could be done, we need to go back to the Insolvency Act and just try to get to see as to how these things can be done. So impeachable transactions are dealt with in between Section 26 to Section 31 of the Insolvency Act. Section 26 deals with those transactions that are entered into and there is no value that is derived either by the person or by the company. And Section 29 deals with voidable preference, where one creditor is preferred as opposed to others or another one. And then Section 30 deals with undue preference, where there is a clear intention to prefer one creditor as opposed. And the difference between the two in Section 29 deals with the effect, when the effect, like the result is that one creditor was preferred, even though there might not necessarily have been an intention, as it were. But nonetheless, as far as undue preference is concerned, the issue of intention plays a critical role. Then Section 31 deals with collusive deals, fraud, where people come together before the company can be liquidated or the person can be sequestrated, and then they enter into transactions to remove assets and manage those assets from the company in order for the creditors, should the company be liquidated, to be prejudiced. Now, it is really important that these are important provisions, even though they are in the Insolvency Act. Nonetheless, courts rely on them from time to time in order to deal with insolvent companies. By the way, also the common law does make provision for the impeachable of some of the transactions that are entered into before the company was liquidated. And of course, there is this common law delictual remedy, Actio Opaulanum, which is also enables creditors to bring an action in order to impeach some of the transactions that were entered into. Now, seeking to impeach a transaction as a disposition without value or voidable preference or undue preference or a collusive dealing, it is fundamental that the transaction should have involved a disposition by the insolvent of his or her, or in the case of a company or a corporation, of its property. In other words, there should be a transaction that leads to a particular property being taken out, or the benefit relating to that property being taken out from the company. In other words, the company does not derive value from that particular property, and somebody else, the rights have been transferred to another person. So in other words, if the company or the person, if the company is liquidated or the person is sequestrated, you find that it will be impossible for creditors to be able to maximize their benefits as a group. So it is important now that we are dealing with the abandonment or the transfer of rights in the property. And if a transaction entered into before liquidation or before sequestration and has this particular event, the liquidator or the trustee might be interested in that particular transaction, and they may want to impeach it. An excluded disposition will be the one in compliance with a court order. I mean, if a court has ordered that a particular transaction should take place, even if it took place before the company was liquidated or the person was sequestrated, then that particular disposition will not be subjected to the provisions that I dealt with, and that either the trustee or the liquidator will not have jurisdiction to actually go after that particular transaction. A transaction that resulted from a judgment against an insolvent person or company is not a disposition by him or that particular company, but and thus cannot be regarded as invalid because it was done in line with the directive from the court. Now, I just want to rush because of time, just to look at some of the defenses that can be raised in terms of the Insolvency Act itself. I mean, there are issues of good faith. Was a transaction entered into in good faith? Did the person who, at the time when the transaction was entered into, who transacted with either the representative of the company or the insolvent themselves, did that person know that the insolvent was actually insolvent at the time, and that that particular transaction had the effect of prejudicing other creditors? So those are going to be the things that are going to be looked at. And of course, the person who benefited from the transaction must illustrate that there was value when of course the trustee is claiming that, look, I want to impeach this particular transaction because there was no value derived from this particular transaction. And if he is able to show that, look, I paid for this particular property and money was given to the company, then that can be some sort of a defense against Section 26 allegation. In relation to voidable disposition, Section 29, the person in whose favor the disposition was made must prove that the disposition was made in the ordinary course of business. In other words, if the company and the person, they have been in a particular relationship and the company has been selling or receiving some property from this person, and there's an established practice between the two of them, or in that particular sector, that's how business is conducted, and they can be able to demonstrate that indeed this has been done in the ordinary course of business, that will also offer some defense. And of course, I will deal with this a little bit later on, should I get the time to do so. The person must also prove that this disposition was intended was not intended to prefer one creditor or the other. So now, when the trustee or the liquidator comes after a particular transaction, then the person will say, look, because the trustee or the liquidator has the honors of proving that this particular transaction was intended to prefer one creditor as opposed to the other. So the creditor who stood to benefit from that transaction might argue in reverse, and that, look, there was no intention to prefer as it were. Now, of course, the issue of preference, then you use the objective test to see as to whether in real terms, did one creditor be preferred as opposed to the others. And preference might be established when one creditor is paid the whole or part of his claim, while another or others receive no payment or proportionally less, or the creditor is paid in advance while other creditors are not paid, and especially before liquidation. Now, to be assailable as a voidable preference, immediately after being completed, the transaction must lead to the insolvent estate, to the insolvent's liabilities exceeding his assets. So it is important that when that transaction takes place, the effect of it should be to diminish the assets either of the company or the assets found in the person's estate. So if they have that, because that is the test for insolvency, whether the assets are being exceeded by the liabilities. So the determination of whether a disposition of property was made in the ordinary course of business entails an objective test involving a consideration of all the circumstances under which it was made and a decision as to whether, given the circumstances, it would have occurred as between the solvent business persons. So in other words, the circumstances under which the transaction took place must be evaluated by the court in order to come to a conclusion whether or not this is a transaction that is subject to be, or that is able to be impeached, as it were. In terms of section 29, subsection 1, a transaction may be set aside unless a person in whose favor the disposition was made proves that the disposition was made in the ordinary course of business and that it was not intended thereby to prefer one creditor above another. So now when one looks, and this is the mainstay of the paper, when one looks at this particular provision, it uses the word "and." That means that you'd have to look at whether this particular transaction, in as far as section 29 is concerned, was done in the ordinary course of business, and whether it was intended to prefer one creditor or the other. But what we have seen, in as far as the cases are concerned, you find that the courts have been quite clear. While there might be others that differ, but the courts have been of the view that even though it appears that there was intention to prejudice or to prefer one creditor as opposed to the other, when it can be shown that a particular transaction took place.
Prof. Odeku, we have 3 minutes now. We must take in the time. Thank you.
Okay, we will take that into consideration. Thank you, sir.
Let me try to wrap up. Yes, but nonetheless, in conclusion, you find that there are differing opinions in relation to the relationship between the defense of ordinary course of business on the one hand and that of intention on the other. And there are some courts that are saying it does not matter whether there is intention to prefer, as long as it can be shown that in the ordinary course of business, the transaction happened as business would have happened should, or if the companies, both of them, were solvent, that would render a defense. But I came across a very interesting case, which when I read the facts of it, it made me question the entire scheme of section 29 and whether we are actually approaching it, or the courts are approaching it correctly. What the court said here was the phrase ordinary course of business seems to refer to the conduct of a business, which is apparently at least solvent. If the debtor knew at the time that he was insolvent, the impeachability would turn rather on the presence of an intention to prefer than on the manner in which the disposition was made. If he was unaware of his real financial position, the circumstances in which he came to make it would be decisive on the issue. The one condition relates to his motive and state of mind, and the other, the manner of the disposition. Whether these two can be kept separate, in other words, he can be separated in all the cases, as many decisions appear to require, is open to some doubt. Now, this was an arbitrary sort of holding in the case, but it was profound because it enjoins one to look carefully at the defenses and see whether when one
maybe Prof will conclude now.
Oh, by the way, in conclusion, what the argument of the paper is, you cannot have one remedy that would be operative when the other one is not. In other words, when you are dealing with ordinary course of business, the issue of intention, and you can take it further in as far as the reasons and motive and so forth, they will also play a part in some certain instances. And when that is the case, then courts must properly interpret the law and make sure that they take intention into account so that the creditors are not prejudiced. Thank you very much, sir.
Thank you very much, Prof, for that insightful paper. Very powerful, very passionate. I can feel you. But because of time and space, we will like to quickly take the second presenter. Colleagues, please keep sending your questions and comments to the chat room. Everything will be taken together after the all presenter must have finished. So we're going to take the second paper is Legal Perspective on the Protection of Depositors, a case for depositor preference in South Africa. Ms. C.J. Mahalo, Nelson Mandela University. Please, it's your turn now.
Thank you so much, Chair. It's actually Maholo, but thank you so much for the time. As already mentioned, no problem. As already mentioned, the topic of my presentation is Legal Perspective on the Protection of Depositors, a case for depositor preference in South Africa. Now, this topic was considered in the context of bank failures, and we obviously know that the issue of bank failures is not new. Various industry experts and academics around the world have grappled with this issue before in various ways and for various reasons. But what struck me as very interesting and important is the issue of depositor protection. And specifically in the case where a bank is in liquidation. The intention of the study is to consider the position of depositors that they occupy within the creditor hierarchy in order for them to satisfy their claim within the estate. In other words, how probable would they be able to get their deposits back? And we look at the current hierarchy and assess whether depositors would be able to get their deposits and whether they should be preferred or prioritized if the current hierarchy is not sufficient. Now, this table simply just indicates a number of banks which have been in distress before, and it highlights them over a period of 30 years. And what we see in this table is that there are various banks that have been in distress for various reasons, others which have ultimately been liquidated. And we can obviously see that a number of reasons led to these banks to be in distress. And they range from fraud, bad management, as well as liquidity problems. And given the current pandemic, it is not unfounded. I don't know why my screen is not moving. It's not unfounded to say that the pandemic could have been a threat to many banks because the economy was under threat. Many corporations were seen to have less profit, people lost their jobs. So it wouldn't have been unfounded to say that banks could have suffered under this period. However, we can be glad that they have remained resilient for the bank's benefit as well for us as depositors. The next fundamental question for us to ask is really, what do deposits mean to you and I? And deposits obviously mean different things for different people. But the general consensus could be that we use the bank to put our hard-earned money in order for it to be saved, to be stored safely, to take all our hard-earned savings, to put it in the bank for it to be safely stored. And then at a later stage, you decide that you're going to the bank and then you request your money back and you expect the bank to give it back. However, this is an old theory and it is very much simplistic because in reality, as soon as you deposit money in a bank, that money or those funds are considered unsecured loans which are made to the bank. And those funds cease to be yours, meaning that the bank has the discretion to use the money as it pleases and for it to fund its own operations and fulfill its role as an intermediary. The only thing you would have as a depositor is a personal right against that money, and the bank should obviously make sure that it's in a position whereby it can meet your demand or your request. So we can clearly see that deposits within a bank is very risky. And that's why it's one of the reasons why we will consider this topic, because as unsecured loans, a deposit will not stack up desirably against preferred creditors, for example. This picture seeks to illustrate a path a bank will take in the event in which it would fail. And this is just a high level explanation of these two paths. Now, the first path is the resolution path. So what would typically happen is that if a bank is under distress, what would happen is that it will be closed temporarily, and then it would probably be reopened under statutory management, and customers would get a portion of their money to a certain limit, and the rest of the money would then be used to either rescue the bank or lead to it being restructured. Possibly at the end, you could get your money back, or you would not get your money back, or you could just remain with equity in the bank, right? That's just a very high level overview of what resolution would be. The other path that could be taken is a worst case scenario whereby customers would be locked out for a very long time without access to their money. And if you're lucky, after many months, customers could get their portion of their money back. And unfortunately, they could maybe, stand the risk of actually not getting back their money. Now, we have seen over the years that the government has, during the past bank failure experiences, they have been willing to support problem banks with taxpayers' money. They would take public funds and use it to support problem banks. And that is obviously a problem because it could have a negative impact on the broader economy. However, one can appreciate the fact that for them to take this step is in effort to preserve financial stability, and most significantly, and for our purposes in terms of this presentation, to ensure that depositors recoup as much of their deposits as possible. Now, I've just put up a simple example of a timeline of banks which received support from the government, where they actually experienced some form of distress. And this is just an example. The list goes on and on. In 1990, we see Alpha Bank, which had a 150 million rand cash injection in order to protect depositors. Also, in 1991, we see Pretoria Bank. Now, the South African Reserve Bank, in this instance, was able to repay all the depositors. In the same year, Cape Investment Bank, they received a 5 million rand compensation, and it was made available to the depositors. Moving along to 1997, the Islamic Bank Limited, the Reserve Bank was able to compensate 80% of the primary depositors. In 2002, the Bank of England also was able to receive some form of funding and support from the Reserve Bank through the National Treasury. But I just want to jump to the last one, whereby in 2018, we heard of VBS Mutual Bank, which we are obviously aware of what happened. Now, while VBS Mutual Bank was undergoing curatorship, it was discovered that it has no prospect of being successful. So when it was undergoing the liquidation proceedings, the National Treasury through the Reserve Bank issued a guarantee to repay all the retail depositors up to 100,000 rand per depositor. And it was estimated that 97% of retail depositors would receive their money. This slide simply tries to illustrate how the Reserve Bank has been willing to prioritize the interest of depositors to be able to make sure that they get their money back. So this will then support some of the recommendations within this presentation as it will become evident as I move along. With a bank during its liquidation process, we obviously have to look at how depositors rank within the hierarchy. But it's very important for us to just highlight a few things. The fact that the main objective of insolvency law is to provide for the liquidation of the insolvent estate and to secure the orderly and equitable fair distribution of the debtors' assets among the creditors in accordance with the order of preference provided by the Insolvency Act. And once it has been established that the debtor, and in this instance, the bank, is unable to meet its obligation, then this will have an effect of creating what we call a concursus creditorum. And this basically means that the rights of creditors as a general body are preferred over the interest of single creditors, meaning that if a bank would fail, depositors can't jump the queue and expect to be paid before other creditors. So they would also have to queue in concursus creditorium as regards to the repayment of their deposit. Another important principle under insolvency law is the fact that is the principle of the pari passu rule. And this means that there should be an equal and ratable distribution of assets of the insolvent estate among creditors who are similarly situated in the creditor hierarchy. And I will explain this to become a bit clearer. So I want us to look at the current hierarchy and to see where depositors would fit in. So firstly, secured creditors would be paid out. Then you would have liquidation costs, preferred creditors, security under general notarial bonds, and then lastly, concurrent creditors, which obviously includes depositors, because remember, depositors have given an unsecured loan to the bank. So they will rank as unsecured creditors with all other creditors. And what we can note with this group is that in our law, we don't make a distinction between junior and senior creditors, which means that all creditors, unsecured creditors, will rank equally. And depositors do not get preference even within this class. And most importantly, following up to the principle of the pari passu rule is that within this class of concurrent creditors, we can't prefer depositors over the other creditors. We would have to rank equally within this class. I've put up pictures of depositors from VBS Mutual Bank, just to give you an illustration of retail depositors and the fact that as ordinary citizens, we put our money in the bank with a hopeful expectation that our funds would be safe. And when we speak of retail depositors, we're speaking about people who are less financially sophisticated. So your burial societies, your stockpiles, your savings clubs, your pensioners, your SMEs stand to lose their deposits in an unfortunate event of a bank failure. Fortunately, we have the Financial Sector Laws Amendment Bill, which has introduced several changes that could actually be to our favor as depositors. Authorities have been considering introducing a deposit insurance scheme, and this has been dealt with in many research papers, whereby a certain limit will be held and depositors will be paid out. And this is obviously in efforts to achieve a high degree of confidence that depositors will have access to their deposits. But also it introduces what we call a depositor preference in legislation. And this would mean that we would prefer depositors who are insured in the hierarchy. And also it, as already mentioned, there will be changes to the hierarchy, or rather proposed changes to the hierarchy. As I've mentioned, that will give preference for claims of covered depositors above other unsecured creditors. Now, the last statement obviously says that they will be preferred, and obviously this is just a recommendation. But the pari passu principle is not absolute. Even though it says that within the same class, all creditors must rank equally. The pari passu rule is not absolute and can be, and one can deviate from that principle. However, it can only be done if it is in furtherance of principles of fairness, equality, and in this instance, in terms of bank, in order to preserve financial stability. And you'll see how in this hierarchy, there would be that deviation from this principle. This is the proposed hierarchy, the proposed, or rather amended, creditor hierarchy. And I'll just jump straight to the depositors. So we have secured creditors, preferred creditors, and then because we would have a deposit insurance scheme, all the depositors who are preferably retail depositors, they would be then covered and they will rank as preferred, and they will be able to will be protected and be able to get their money. And then what follows after is unsecured creditors, and that includes all other depositors. All other depositors would include wholesale depositors, because those are, for example, corporate and investors who are more sophisticated and who are able to assess the risk of an institution. So in this instance, we would prefer retail depositors and SMEs because they are less financially sophisticated.
We have a minute more, probably we can wrap up.
Sorry?
We have a minute more, probably you can draw conclusions. Yeah.
Okay. Yeah. This slide just shows that there are countries that have introduced depositor preference and have amended their creditor hierarchy. However, this obviously depends on each jurisdiction and how its layout is. In conclusion, I've obviously mentioned that retail depositors are the ones who are less financially sophisticated and they stand the risk of losing their money. So the fact that they rank as unsecured creditors is obviously concerning, and it justifies the debate that they should be given a certain degree of protection and preference, and that we can obviously deviate from the pari passu rule as long as it's in furtherance of preserving financial stability. And this presentation seeks to commend these proposed changes, that we somehow prioritize the interest of depositors and make sure that they reap, or rather they recoup the funds in an event that a bank would fail. I think I'll just leave it there.
Oh, thank you very much. Very, very interesting paper. I just want to say that I listened to you and I was wondering, I was telling myself whether I have any money to deposit. And if I don't have any money to deposit, that means if a bank fails, I lose nothing. So the colleagues keep sending in your comments and questions to the chat room. We are now going to take the, thank you. We are going to take the third presentation. It's paper is titled Corporate Regulation and Climate Change in the 21st Century, an appraisal of the prospects and challenges in Namibia, South Africa, and Zimbabwe. Very good. Dr. Warikanda and Ms. Shakalela, University of Namibia. Please.
Prof. Odeku.
Yes. Yes, sir.
There's a paper that comes before Prof. Kawaza.
Okay.
Yes. It's my paper actually.
What is the title?
The title is the interrelationship between the effective enforcement of debt relief measures and the promotion of financial education in South Africa.
Oh, kindly go ahead. The program I have, I'm reading from it now.
All right.
Probably that means your program is the latest. Kindly go ahead. Please.
Thank you. Thank you very much, Prof. Thank you very much. Good afternoon once again, colleagues. I hope not to be long. I'm going to be short on this presentation. I'm talking through the interrelationship between the effective enforcement of debt relief measures and the promotion of financial education in South Africa. I'll be providing some definition of key terms, the introductory remarks, and then deal with the gist of the paper and then the concluding remarks. And then financial education, I'm running with the definition that has been adopted by the OECD, where they define financial education as the process by which financial consumers can improve their understanding of financial products, the financial concepts and the risks that are involved, by ensuring that they have information, objective advice on how they can develop their skills and the confidence, so they can be more aware of the risks and the opportunities that are there for them to make informed financial decisions and choices to improve their financial well-being. And then the term debt relief is not statutorily defined in any piece of legislation in South Africa. But sometime last year, we penned a paper with Prof. Titimira where we tried to define it and say that It entails basically the reorganization of a person's outstanding debt so as to provide some form of relief to that person in relation to the payment of their debt. And then debt relief measures, they are statutorily regulated in South Africa. But now consumer indebtedness, over indebtedness amongst financial consumers and the use of credit remains too high among the financial consumers in South Africa. So this presentation then seeks to explore the interrelationship between the effective enforcement of debt relief measures and the promotion of financial education in South Africa. This is done to investigate how we can best promote financial education to ensure that we equip the debtors to manage their debts and their financial obligations in a more responsible manner. And then in the end, I will offer some concluding remarks and recommendations. Currently, there are 4 statutory debt relief measures that are available to over-indebted persons in South Africa. We have sequestration proceedings in terms of the Insolvency Act, sections 3 up until section 12 of the Insolvency Act. They talk about sequestration proceedings. We also have administration orders, which are provided under section 74 of the Magistrates Courts Act. We have debt review under the National Credit Act. We also have now the fairly new debt relief measure, which is not yet in use, which has not yet been fully utilized, which is debt intervention. So debt relief measures, they could go a long way in assisting to ensure that we slow and we discourage or prevent over-indebtedness amongst financial consumers in South Africa, particularly the low-income earners who are really struggling to make the ends meet because of limited disposable income. But now the challenge is that the debt relief measures that we have in South Africa, the access requirements, the criteria that has to be met for one to utilize these debt relief measures, they are quite difficult for the low-income earners to really qualify and utilize these debt relief measures. For instance, under sequestration proceedings, consumers need to prove advantage to creditors, and that is difficult for low-income earners really to prove because they have no assets, and most of them, they have limited income to be able to prove the advantage to creditors. And then the administration order under the Magistrates Courts Act provides that in order for one to qualify, their debts must not exceed 50,000 rands. And it is very much probable for one to be a low-income earner and have debts which exceed 50,000 rands. But it means that in that regard, they will not be able to utilize administration order for debt relief. Debt review, similarly, it applies only within the scope of debts as defined under the National Credit Act. It does not cover other forms of debts. For instance, the school fees, the clothing accounts, municipal bills, those debts are not covered in the for debt review. And also debt intervention has followed the same approach as debt review. It results under the NCA, and like the debt intervention, it has also brought the requirement for 50,000 rands, that if your debts exceed 50,000 rands, you cannot utilize debt intervention. So these are some of the challenges that we have regarding the debt relief measures in South Africa. The challenge is that South Africa is characterized by low levels of financial education among financial consumers. That is a reality that we have. And the problems relating to low levels of financial education, they usually come from poor planning, the lack of financial planning, the lack of relevant knowledge and understanding of various financial products that are at the disposal of financial consumers. Now, there is no legislation that speaks expressly to the provision or the promotion of financial education for financial consumers. This issue has been exhausted throughout this conference. And then the NCA, the CPA and the FSR Act, as we have been presenting, they make only partial regulation of financial education. So all these acts, they have not been consistently applied. So financial education, that relates to how we can best assist consumers on how to access debt relief measures, which are so already difficult to access. It is quite important, especially now during the time of COVID-19, so that we can ensure that we reintegrate the financial consumers, the low-income earners, into the financial sector and the economic activities, especially now during the COVID-19 and even post the pandemic. But without fostering financial education, debt relief measures cannot really offer full rehabilitation to debtors because they would not know really how to manage their debts. We can't say we have provided them relief without equipping them and capacitating them with the knowledge on how to best manage their debts and on how to best make sound and prudent financial choices and decisions. So despite the objective of debt relief measures, which is to get debtors out of their debts, the challenge still remains that without financial education, most debtors are going to abuse debt relief measures, if I can put it that way, because they would engage irresponsibly or in borrowing and on the use of credit, knowing that they may be provided debt relief measures. So we need financial education to ensure that we curb and we combat this conduct of engaging in excessive borrowing on the part of financial consumers. So this disadvantage is likely to take place, especially due to the fact that our debt relief measures in South Africa, they do not make provision for financial education. Of course, the recent debt intervention in terms of the NCA makes provision for offering financial consumers some form of training and financial and counseling. But at present, that debt relief measure is not yet in use. And the NCA, the NCR and the National Consumer Tribunal do not have the capacity, and they have not developed the regulations on how financial literacy programs and counseling will be carried out to assist debt intervention applicants. So access to debt relief measures, as I've been saying, it is difficult for most debtors in South Africa. But the regulatory bodies, the NCR and the National Consumer Tribunal, they have not adopted adequate measures to promote financial education in such a way that they can prevent or curb over indebtedness and to help financial consumers to really extract themselves out of their debts. So in conclusion, I would like to submit that the South African regulatory framework of debt relief measures has its shortcomings, especially in terms of accessing debt relief measures in a seamless manner. So apart from debt intervention, in terms of the financial literacy program that has been mentioned for debt intervention, there is no any other debt relief measure which makes provision for financial education on how debtors can manage their debts. So financial education that relates to access to debt relief measures is important, but it must be coupled with financial education. Financial education must be coupled with the debt relief measures. We cannot only provide access to debt relief measures without providing financial education, without providing measures on how to capacitate the financial consumers so that they do not engage irresponsibly in terms of the use of credit and excessive borrowing. Thank you very much, Chair.
Oh, thank you very much. Thank you very much. Very interesting paper. And also, thank you very much for drawing my attention to that program mistake. As a matter of fact, I've been able to retrieve the current and proper program. I think the next presenter will be, the title of the paper is Pandemics and Corporate Control Systems, the case for ethical capitalism through the business judgment role. Professor Kawansa, Edutainment University. Thank you very much. It's your turn, Prof.
Is Kawasa here?
Kawasa.
Goodness, we moved
Professor.
to this session.
Hello.
Prof Odeko, I don't think Prof Kawaza is with us in this session. I do not see him in this session. We can proceed.
Okay, we can proceed. Then at this point in time, we are going to be taking questions, and then we have the presenters. They are ready for your questions and comments to respond accordingly. Please, questions to Prof. Maru Maga, Ms. Mahalo, and Mr. Nangao, the three presenters. They are awaiting your questions and comments on the paper presented. I don't know, or whether the questions were written on the chat platform. Let me see. Please, colleagues, you can ask questions. Colleagues.
Prof. Odeko, I don't see any questions coming from the questions.
Oh, you are not, no question is coming.
Probably presentations were excellent.
Very, very powerful presentations. Very, very powerful. Hey, no wonder there are no questions. I was just going to comment on the legal perspective on the protection of depositors. Very interesting, but I was looking at how do we quantify the money to be given depositors? Like I have on 1 million and someone is having 200,000. I'm just asking this hypothetically. And at the end of the day, because during your presentation, you mentioned 95% were given, 97% were given 100,000. Am I going to be limited to 100,000 like the person who is having 200,000? Or is there any legislation or any law that gives me the opportunity to seek further remedy so as to get a refund for the whole deposit I have in the bank?
Thanks, Chair. The bill proposes that the Act will cover the deposits. So all the qualifying deposits would be covered up to 100,000 Rand per depositor per bank. And when I say depositors in this instance, I'm speaking about retail depositors. So this excludes your wholesale depositors, your large institutions, your investors, and your corporations. Those are excluded. And they would then cover up retail depositors, because people like you and I probably have, I don't want to say insignificant amounts, but not a million.
That is true. You are right. You are right. You can say it. It's very insignificant.
So 100,000 Rand is seen to be sufficient enough to cover a depositor. I mean, in my account, I don't think I even have 100,000 Rand, but worst case scenario is that I would be covered to that limit. And it is estimated that to fully cover everyone, I mean, approximately 98% of depositors in SA would actually be covered or be able to get their money back. And then your wholesale depositors will then rank under unsecured creditors. And the reason why there's that debate between separating wholesale and retail is that with us as retail depositors, we don't possess the skill to assess a risk of a financial institution, as opposed to a wholesale depositor who would be able to have the skill to actually assess the risk of a bank and see, whether this bank is viable and how it's operating, the capital adequacy requirements, are they met? So they have that skill. So that's why they would then, well, the argument is that they would then be put as unsecured creditors because they would have been able to see that.
Yes. Oh, thank you very much. And can I proceed? Because I still have another question for Mr. Manga.
Yes, Prof. Go ahead.
I can proceed. Okay. I was looking at this the title interrelationship between effective enforcement of debt relief measures and the promotion of financial education. The first part is fine because we have an enforcement mechanism whereby you can go for, there are legislation to make sure that you are able to enforce and collect debt. But when you're looking at financial education, like you rightly said during your presentation, that there seems not to be any legislation compelling financial education. If there are no financial education in South Africa, then what are, you mentioned so many things, but I'm looking at it in terms of how do I discipline myself in order to not to run into debt? Because whenever I run into debt, the law will kick in. I have to face, I have to pay up, or there will be action instituted against me to recover the money. But I'm looking at financial education. What sort of education? Is it moral education? Is it when you don't spend more than you earn? Or how is it will it unfold? Thank you.
Thank you very much, Prof. Odeku, for your wonderful question. Financial education, most financial consumers, as I've been indicating, they engage recklessly in the use of credit. Although we have the NCA, which speaks to the prevention of reckless credit, but we still have most consumers who engage in reckless credit, and some not only in reckless credit, but they rely too much on the use of credit without the necessary and the adequate knowledge on how really to manage and to use that credit effectively. So, and that often leads to these financial consumers being overly indebted and struggling to extract themselves from their debts. And the debt relief measures that we have are not quite effective. So in this regard, financial education in form of capacitating the financial consumers on how to use the little they have without resorting to too much use of credit will be, I think, sort of an antidote to cure the over-indebtedness, since access to debt relief measures is already so much difficult, especially for these low-income earners. Thank you, Prof.
Thank you very much, sir. On that note, if we don't have any comments or question, can we kindly call it a day?
Thank you very much, Prof. Odeku. We are now going to session 11 that is going to be chaired by Dr. Avira. Dr. John. Dr. John Navira, over to you, session 11. We can see that your microphone is open, but we can't hear you, Dr. John.
Yes, sorry. I don't know why when I've got headphones in there, the microphone switches off. Okay, good day. In this session 11, I've got 4 speakers. Dr. J. Mudzamiri and Professor Osodi are the first ones to speak on the fitness of South Africa's business rescue model for purpose in the midst of the COVID-19 pandemic. And they're both from University of Fort Hare. The second, O. Taura, LM candidate, Northwest University, the responses of public companies to corporate social responsibilities, challenges during the COVID-19 pandemic. The third one is from Dr. F. Hamadziripi and Professor H. Tich Timira from Northwest University, a comparative analysis of company directors' accountability and the statutory duty of care, skill, and diligence in South Africa and Zimbabwe. Without further ado, I'm going to call upon Dr. J. Hamadziribi and Professor Osodi of the University of Fort Hare to make their presentation. They have 15 minutes in which to do so. Thank you.
Good evening, everyone. I'm not sure if I'm audible, and also can you, oh yes, I can now see that my video is on.
Audible.
Oh, okay, thank you very much. And also this, the slide that I'm trying to share, are they visible to everyone?
Not yet, sir.
Oh, okay. Okay, thank you very much. My name is Justice Mzamiri, and on behalf of Prof. Osode, this is a paper that we are still working on, and it's quite far from being finished. And Prof. Osode, my co-author, is my doctoral supervisor. So we are trying to finalize and go through this paper that I'm going to present on today. So the title of our paper is The Fitness of South Africa's Business Rescue Model for Purposes in the Midst of the COVID-19 pandemic. Without wasting much of your time, I'll go straight to the structure or the anatomy of my presentation today. The first thing that I'm going to do is to introduce the subject. When I'm introducing, of course, I will also look at the context, the background, and the procedure. Then the second thing, I'll look at the nature, functional purposes, and the functional purposes of business rescue. Then the third, I'll look at some identified weaknesses that we have already identified in the business rescue regime. Then lastly, I'll deal with the concluding remarks. Having said so, remarkably, I think we can see that we are deep in the COVID-19 pandemic, and this pandemic has resulted in serious negative consequences that include businesses and broader national economies on the global scale to crumble. And South Africa is not unique to these crumbling of the economy, including its businesses at large. Of course, we have identified COVID-19 as a vice measure, and we have included quite a number of some other vice measures that can be attributed, like riots, lootings, if you still remember the lootings that happened in Durban and parts of Johannesburg, and some other public health emergencies that has called the government for national lockdown. After giving this introduction, I want to now go to the issue of, I'm not sure what's happening with my slides now. Can you bear with me a bit? Okay, yes. So the issues that I'm going to look at on the issue of business rescue. So we've got two extremes where a financially distressed company either go for liquidation or business rescue. And in this presentation, we are rooting to a larger extent for business rescue. There are a lot of stakeholders that are company stakeholders that include employees, directors, customers, and shareholders. This is just an anatomy of a company that you see when I'm going to explain further when we are going to the deeper parts or the substantive parts of this presentation. Having said so, even though we have said that a lot of companies and a lot of economies have collapsed or crumbled, there is still need for what we call business rescue. My understanding is that there were quite a number of presentations on business rescue. So there is, I assume that my audience today have a fair understanding of what business rescue is. If the Companies Act, particularly on Section 7K, it has one of its objectives to efficiently rescue and recover financially distressed companies. In doing so, it ought to have or to balance certain rights and interests of all relevant stakeholders. It is important to note that business rescue is one of the most innovative aspects that have been adopted in the Act. And it should be noted that under Section 129, a company board of directors can apply or can voluntarily initiate business rescue, or secondly, any affected person. I'm going to deal with the other issues like financially distressed further down when I'm dealing with the potential weaknesses that we have identified in the COVID-19 era, pandemic era. It is important again to note that under Section 128(1), it defines business rescue as proceedings to facilitate the rehabilitation of a company that is financially distressed. You must take note of the word, of the term or the concept of financially distressed, because I'm also, like I promised, I'm going to deal with it further down. Accordingly, one of the pivotal roles of business rescue is to avoid liquidation of the company and its dire effects on affected persons, since business rescue procedure gives more rights to affected persons, for example, employees, creditors, shareholders, if we compare that procedure to the liquidation of companies. One of the key case law that we have, the Ogden Square Properties and others, held that the term business rescue means rehabilitation that could result in the realization of either of the two objectives. The first objective being to retain the company to solvency, and the second objective being providing better deal for shareholders and creditors than what they would have if company was to be liquidated. We have got three elements of business rescue as provided under 2008 Act. One, temporary supervision of a company. Second, temporary moratorium of rights of claimants. Then the third, the development and implementation, if approved, of a plan to rescue the company through rescuing. The court's determination is mainly on if there are three elements that are satisfied. The first one is financially distressed.
Sorry,
Then
you've got 6 minutes left.
Sorry?
You've got 6 minutes left.
Oh,
Okay, thank you very much. And second, if failed to pay any amount in terms of obligation. The third, if it is just and equitable to do so for financial reasons. Now, I am now going to the definition of financially distressed and point out what we thought or what we found as weaknesses, especially on that definition. The first thing is that financially distressed is defined, or some characteristics that defines financially distressed company is that when a company appears to be reasonably unlikely that company will be able to pay all its debt as they become due and payable within immediately ensuing 6 months. Or if it appears to be reasonably likely that the company will become insolvent within immediately ensuing 6 months. So we are arguing that the criteria that is being used by courts in granting business rescue in order in terms of 131.4, which inter alia is that court should be satisfied that the company is financially distressed and that there should be reasonable prospects of company to be rescued are onerous, overly onerous, and probably inappropriate during COVID-19. After considering a business rescue, so the second weakness is that after considering a business rescue application, court may make an order placing a company under supervision and commencing business rescue if the court is satisfied that there is a reasonable prospect of rescuing a company. We consider this, again, a weakness, especially in COVID-19 era. I'm going to talk about the possible reforms in the conclusion. A case that deals with reasonable prospect, again, is the Ogden Square Properties case that I spoke about above. Then the third weakness that we spotted is that labor courts lack jurisdiction on business rescue matters, thus forcing the retrenched employees and their unions or representative to seek legal recourse through a strict time-bound and costly procedure of High Court. There is a case, the NUMSA case, that confirmed that labor courts do not have such jurisdiction. Now I'm concluding. The concluding remarks, we are suggesting overally that there should be a law reform that ensures some tinkering with the current business rescue provisions to the extent that there will be a distinction of triggering factors in normal situations versus vis major circumstances. Accordingly, the amended provisions can only be applicable only in vis major circumstances. Now I'm going to the specific reforms that we came up with. The specific reform, the first one is that we think that the current provisions should be tinkered with, especially on the time frames to qualify companies to be in the scope of what we call financial distress when we are talking about those 6 months. The reason being is that the periods should be flexible to include companies who have the prospect of failing to pay their debts and becoming insolvent at any time between 1 month and 2 years, considering what we are having now, that some of the financial distress is not being caused by incompetencies, but because of COVID-19. So it also ensures that companies that face devastating effects of COVID-19 are catered for. Then the second reform that we advocate for is that the test for reasonable prospect of rescuing a company as held in courts should be revised in the COVID-19 era. The reason being factors like riots, government lockdown, COVID-19, especially now where everything is indefinite.
1 minute remaining.
1 minute, okay, thank you. I'm now concluding. And since companies like hospitality, those that fall in hospitality industry are not even operating. So we think that such a yardstick will still be quite too high. And also there is need to ensure that those companies, the too big to fail companies and other companies that may appear to have a reasonable prospect of being rescued should also be roped in. Then the last thing is the issue of the jurisdiction of labor court. We think that those people who are retrenched, that is tied to business rescue plan, they should have a choice to choose between either labor court or high court. Reason being, labor courts are not only convenient as specialized courts, but they are also cheaper. Having said so, thank you very much for listening to this presentation.
Dr. Hamad Ziripi, thank you very much for that enlightening discussion that clarifies that labor issues regarding to retrenchment and business rescue may approach the labor or the High Court. Thank you very much. Much appreciated.
Okay, thank you.
At this juncture, without much ado, I'd like to call upon Mr. Otsaura to present his paper on the responses of public companies to corporate social responsibility challenges during the COVID-19 pandemic in South Africa. Mr. Tsaura, the floor is yours. Thank you.
Thank you, Doc. Thank you. Let me just thank everybody for the insightful presentations which have been presented before me. I'm going to present my topic. My paper, the topic reads, the responses of public companies to corporate social responsibility challenges during the COVID-19 pandemic in South Africa. I'll go straight to the structure of the presentation. It will have the introductory remarks, the definition of the key terms, where I'm going to define 3 important terms which I picked up, and then the body, which is going to include corporate social responsibility challenges in South Africa. And lastly, the concluding remarks. It's a work in progress paper where I'm hoping to submit, and the first point which I'm going to discuss is the responses of public companies to corporate social responsibility challenges during COVID-19 pandemic in South Africa. I also identify the responses by public companies to corporate social responsibility challenges in South Africa. Also, I'll look at how corporate social responsibility challenges in public companies specifically could be enhanced through adoption of innovative technology to combat the spread of COVID-19 in South Africa. Accordingly, responses such as providing quarantine services and vaccination facilities, education awareness to the public about COVID-19, assisting with personal protective equipment to the vulnerable and health sector, promoting education sector through free access to online services, books, learning programs and bursaries, scholarship to students will also be looked after. Let me go to definition of key terms. I have defined corporate social responsibility as it has been defined by Jonker and Marco DeWitt as the extent to which and the way in which an organization is consciously responsible for and accounts for its actions or non-actions and the impacts of on its stakeholders. Public companies are defined also as a company which may or may not be listed on the stock exchange designated by limited or LTD, and which may, subject to its memorandum of incorporation, offer its shares for public subscription. COVID-19 is defined as a novel virus with similar viruses identified and named as SARS-CoV-2 with a cluster of pneumonia cases that originated in Wuhan, China. Corporate social responsibility, responses of public companies to corporate social responsibility challenges in South Africa. We start with the statutory regulation governing corporate social responsibility in South Africa. We look at the Companies Act and the BBE Act, which specifically deals with corporate social responsibility. Here, the paper will be looking at the robustness of these regulations in governing or in providing corporate social responsibility innovatives or measures which can be followed by public companies. Provisions of the BB Act are far-fetched to properly address challenges of corporate social responsibility posed by COVID-19 in South Africa. The BB Act has been made to address the challenges for corporate social responsibilities which have been caused by the apartheid system. So it does not actually address or cover issues such as challenges caused by COVID-19. The Companies Act also provides for corporate social responsibility through the requirement of having a social and ethical committee in public companies in South Africa. But also there is no actual or structural guidance on how those public companies will have to apply or will work to promote corporate social responsibility. Secondly, the challenge which has been caused by COVID-19 in regard with corporate social responsibility they provide facilities to quarantine patients who have contracted COVID-19 or those who have been in contact with people who have COVID-19. There's been a lack or no adequate facilities to accommodate patients who contracted COVID-19. COVID-19 just came and it was not prepared. Even the government or the clinics, they did not have enough facilities to accommodate people who were contacted with the virus. So the public companies have intervened, responded swiftly to address those issues by offering facilities for accommodating COVID-19 patients and quarantine places. Next slide, please. Thirdly, public companies provided financial assistance through government reliefs. When the government announced the lockdown, most people and most companies were not ready. They did not have anything saved or prepared for the virus or for the time of lockdown. So most people were financially distressed. At the end, public companies had to intervene. They have to divert the monies which they have put for the corporate social responsibilities on a long-term basis, and then they had to make them available for the assistance in the relief funds which have been programmed and given to the community. That was the best response which I have noticed from the public companies. Next slide, please. The fourth response, which were done by the public companies, it was the public companies adapt to new operating strategies. Right, when the companies were closed due to lockdown, companies had to operate, but the laws of social distancing and all the PPE requirements were not available or readily available, and they were not in place. The companies had not put anything in place for that. So they had to quickly adapt and adjust to the operating strategies. How did they do that? They then adapt to online operations. Those which were able to operate online, they keep on, they advance actually in teaching their employees how to use, to operate online. And then they also started to provide online services, delivering services and all those things, purchasing and selling. They had to do it online. So they had to adjust, all public companies adjusted to new operating strategies, which actually advanced the provision of services, because there was a lockdown, especially the first lockdown was a hard lockdown, which brought everything to out. So the companies have quickly adjusted and adapt to operating new strategies. Next slide. The fifth response which public companies had provided is the donation of food and to poor communities. Like I already mentioned, that when the lockdown regulations were imposed on us or in South Africa, no one was ready, no one was prepared for it. So most people fell into lockdown without any food, without any money or any reserves. So the companies, public companies, intervened by providing food, by providing donations to the communities, and especially the informal and those poor, low-income earning group, which mostly suffered due to loss of, to lack of food and lack of access again to food and any money or income generating. Next slide, please. The sixth response, which has been provided by public companies, was the free online education resource, which has been provided to schools and to educational department, or I can say educational sector, because the educational sector was mostly hit because they had no access, they have been stopped, everything has been closed.
Sorry, you've got 2 minutes left.
Oh, thank you. And then the public companies had to intervene, swiftly provide for online services, provide online channels, provide online education to make sure that the community is not going to suffer with that lockdown. And next, please. Okay, lastly, public companies engage in humanitarian activities, which they divert all their resources, which were meant for long-term corporate social responsibilities to serve the human needs. And on my concluding remarks, I provide that the provisions of the Companies Act, the BBE Act, and public companies regulations on corporate social responsibility should be strongly enforced and monitored in public companies to make sure that they will be ready for any action or any incident similar to COVID-19. If it appears then again, then they won't suffer, the community won't suffer. Public companies must increase engagement with the government increase engagement with the stakeholders in aiding mostly to the poor and informal settlement, to be prepared and ready always for any issues such as COVID-19 or pandemics if they appear again. The public companies must also consider taking innovative steps in technological advancement, such as tracking and tracing for COVID-19 infections, to make sure that there won't be any more spread of such issues. Like right now, most of the public companies, they've initiated those technological tracking devices on the entrances of their gates and everywhere, to make sure anyone with similar symptoms of COVID-19 will be detected and will get help. Next slide, please. Thank you.
Dr. Navira, over to you.
Sorry, my microphone again. No, thank you, Mr. Tsaura, for that insightful presentation. COVID-19 really came out of the blue for everyone and took everyone unawares. And it's amazing that everybody rallied to help everyone. And this is what your presentation is telling us. It's truly remarkable. As chair, I'll also take the opportunity to suggest that you also look at Carroll's pyramid of corporate social responsibility, just as an addition. Thank you very much. Now, if we can move on. We can move on to the next presenter, Dr. F. Hamad Ziripi and Professor H.T. Timira, to present their paper on a comparative analysis of company directors' accountability and the statutory duty of care, skill, and diligence in South Africa and Zimbabwe. Over to you, gentlemen.
Thank you, colleagues. Thank you, those who have stayed to this afternoon. I'm going to hand over to Dr. Hamad Ziripi to quickly present our findings. Thank you.
Thank you so much, Prof. Good afternoon, colleagues. As you can see, the title of our presentation is a comparative analysis of company directors' accountability and the statutory duty of care, skill, and diligence in South Africa and Zimbabwe. Here is the structure of our presentation. We'll start by an introduction, which will be followed by a look at the duty of directors to act with skill, care, and diligence, after which we'll consider whether whether directors have acted with whether they've acted with the requisite skill, care, and diligence, whether that test is objective or subjective. Thereafter, we'll consider the difference between partial codification of this duty and a total codification of the duty in question. Then after that, we'll look at the duty of directors to act with care, skill, and diligence, together with the business judgment rule. Then we'll offer some concluding remarks. This presentation provides a comparative analysis of the accountability of company directors and the duty of care, skill, and diligence in South Africa and Zimbabwe. We have chosen South Africa for several reasons. Both Zimbabwe and South Africa share some similarities in this context. For example, Zimbabwe has recently partially codified the duty of directors to act with the requisite skill, care, and diligence in the Companies and Other Business Entities Act number 4 of 2019, which we shall call or refer to as the COB Act, which only came into effect on 13 February last year. So this act is just under 2 years old. On the other hand, South Africa partially codified the duty of company directors to act with care, skill, and diligence under the Companies Act number 71 of 2008, which came into effect on 1 May 2011, meaning it has been around for about a decade. Furthermore, most of the judgments in South Africa have highly influenced, or they've helped shape corporate governance in Zimbabwe, to the extent that it has been held that a court may not ignore judgments from South Africa's superior courts. Although foreign judgments are not binding on Zimbabwean courts, it is clear that they have very persuasive value. Consequently, South Africa, due to the longevity of the current act, which is about 10 years, it has developed better academic literature and jurisprudence on the statutory duties of company directors for almost a decade. This is why South Africa has been chosen for comparative analysis. The presentation discusses the gaps and flaws in the relevant company laws of South Africa and Zimbabwe in order to recommend some possible measures that could be adopted to enhance the application of the director's duty to act with the requisite skill, care, and diligence, and to promote the accountability of directors in both jurisdictions. We'll now look at the duty of skill, care, and diligence. In Zimbabwe, before the COB Act was enacted, the duty of directors to act with care, skill, and diligence was regulated by the common law. The repealed Companies Act, now 47 of 1951, did not contain any provisions on the director's duty to act with care, skill, and diligence. Similarly, in South Africa, before the current Companies Act was enacted, the director's duty to act with care, skill, and diligence was regulated by the common law. Some of the reasons for the codification of the director's duties in both jurisdictions include the need to enhance corporate governance standards, the need to balance the duties and responsibilities of directors and shareholders, and also the need to promote the accountability of company directors. This is evident from Section 7 of the Companies Act of South Africa, and also the memorandum to the COB Bill of 2018. As one goes through the COB Act, one of the notable cause for concern is Zimbabwe's fusion of the duty of care, skill, and diligence with the fiduciary duty to act in good faith and in the best interests of the company. This is so because the director's duty of care, skill, and diligence is not the same as the director's fiduciary duty to act in good faith in the best interests of a company. Here are the reasons why we say that these two duties are not the same. Firstly, the fiduciary duty to act in the best interest of the company emanated from Roman Dutch law, while the duty of care, skill, and diligence developed from English law. So these are duties that emanate from different legal systems. Secondly, the fiduciary duty is based on a breach of trust, while the director's duty of care requires a delict in the form of negligence. Therefore, fusing these two duties could result in confusion and legal uncertainty. However, South Africa has managed to separate these duties as can be evident from section 76, subsection 3, paragraphs A to C of the Companies Act. We now move to consider whether the test is objective or subjective. In South Africa, there seems to be two schools of thought that have developed in response to the question whether the director's duty to act with the requisite care, skill, and diligence adopts an objective or subjective test. On one hand, the director's duty to act with care, skill, and diligence is determined objectively. That is, directors are expected to objectively exercise their duty. However, on the other hand, some academics believe that the test where the company director is complied with this duty is partially objective and partially subjective. In Zimbabwe, the test to determine whether the director has acted with the requisite care, skill, and diligence seems to be an objective one, whereby the directors are expected to act as reasonable persons. This is evident from the Zimbabwe Corporate Governance Code, paragraph 63. We now move on to look at partial codification versus total codification of the duty of directors to act with the requisite skill, care, and diligence. Partial codification of the common law generally refers to a systematic and authoritative statement of the leading legal principles on a given subject, whether the rules are found in statutes or in common law. A complete codification of the law usually refers to a process of collecting and restatement of the law in a statute undertaken usually to abolish the common law. The Companies Act partially codified the director's duty to act with care, skill, and diligence. This is evident from section 158. On the other hand, the COB Act partially codified the same duty as evident from section 197, subsection 2, paragraph A, subparagraph I. Here are some of the advantages of partial codification as has been adopted by both jurisdictions with respect to the duty to act with care, skill, and diligence. First one, partial codification of the director's duty of care, skill, and diligence in both jurisdictions. We are arguing that it enhances legal certainty and accessibility of the law. Partial codification of the common law on the director's duty of care, skill, and diligence does not replace all the jurisprudence developed through case law. The common law will continue to apply in those instances that are not covered by the statutes, and the courts should always consult established common law principles in complex cases. For example, section 54, subsection 3 of the COB Act of Zimbabwe requires directors to make a proper inquiry. However, the phrase proper inquiry is not defined in the COB Act. Therefore, courts could always consult common law to find out or to determine what a proper or what constitutes a proper inquiry in the context of acting in the best, acting with the requisite care, skill, and diligence. Partial codification also preserves the common law to the extent that it does not conflict with the statutory provision. I'll look at some of the disadvantages of partial codification. Firstly, partial codification could mean the application of the director's duty of care, skill, and diligence could now be derived from both the legislation and the common law, which could result in confusion. I'll move on to consider the interlink or the linkage between the duty to act with care, skill, and diligence, and the business judgment rule. The reason why we are discussing the business judgment rule under this subject is that the wording of this duty in the COB Act seems also to combine the business judgment rule or to attach that rule to the duty of care, skill, and diligence. It is right that the business judgment rule is an American concept or a legal transplant developed as a common law rule by American judges of the Delaware states. The COB Act merely incorporates the business judgment rule to the director's duty to act with care, skill, and diligence. On the other hand, the Companies Act of South Africa treats the business judgment rule as a rebuttable presumption that a director acts in the best interest of a company if certain preconditions are met or if they've been complied with. Notably, both the Companies Act and the COB Act do not define the business judgment rule. We argue that the business judgment rule could blur the distinction between the director's fiduciary duty and the duty of care, skill, and diligence. The South African version of the business judgment rule is too broad and open to abuse by company directors because directors are not statutorily obliged to act or to exercise their duties independently so that they enjoy this rule or the protections of the business judgment rule. We'll now move on to the concluding remarks. Both South Africa and Zimbabwe should be applauded for partial codification as opposed to complete codification of the director's duty of care, skill, and diligence, since partial codification is flexible enough to cater for the dynamic nature of contemporary business environments. Some of the recommendations that we offer, the first one, Zimbabwe should consider amending section 54, subsection 1 of the COB Act to avoid the potential confusion that could result from the fusion of the director's duty of care, skill, and diligence with the fiduciary duty to act in good faith in the best interest of the company. We've already said these two duties, they emanate from different legal systems, and the requirements that are considered could require, could result in confusion and legal uncertainty. The second recommendation is that the Companies Act and the COB Act should be amended to refine the business judgment rule by providing a definition of what the rule entails and prescribing some of the circumstances or further guidance regarding when the business judgment rule should be invoked. The third recommendation is that both the Companies Act and the COB Act should be amended to enact provisions that oblige directors to act independently for them to enjoy the protections of the business judgment rule. Thank you.
Dr. Hamadziripia and Professor Chitimira, thank you very much for your incisive presentation. At this stage, I now open the floor so that questions may be made. I have not seen any questions in the chat, so I open it out to the floor. Thank you. Looks like these presentations were so good.
There's a hand from Prof. Marmohan. Go ahead, say. Thank you.
No, thank you very much. Mine it's a comment, and it can be interpreted as a question as well. I just want to engage the first speaker who spoke on a business rescue. And there are 2 points that really struck me. The first one was the jurisdictional issue, that perhaps maybe these issues should be dealt with by the labor court, which I agree with, but the reasoning was based more on costs as opposed to perhaps what I think would be the most obvious thing would be the expertise of the court. On that point, before I go to the second one, I think on that point, the presenters need to be very careful that the fees at the litigation fees are not determined by the court themselves, but by the legal representatives involved. So the extent to which the fees will largely be in relation to the kind of attorneys or advocates used in the case, because not everyone charges as per the tariff. So it might not necessarily be accurate that the labor court will be less expensive than the high court, because the labor court has the status of the high court. But I think perhaps maybe the argument would have been that given the fact that perhaps maybe the issues could be dealt with, at least when they start at the CCMA, perhaps at that level, there might be a case to make that the fees might be a little bit less. But again, it depends again on the attorney. So I think when they are writing the paper, they must look into that factor quite carefully, because what might come out might not necessarily be accurate. And again, it is really important to really understand that the labor court will have jurisdiction, because at least the Labor Relations Act in section 210, it is quite explicit that in relation to labor matters, the Labor Relations Act will have precedent. And of course, when one looks at the retrenchment provisions in the Business Rescue Chapter 6 of the Companies Act, those provisions are subject to section 189, the retrenchment sections of the Labor Relations Act. So it is on that basis that the labor court will be the most ideal forum to deal with business rescue issues where employment issues are at play, in particular retrenchment. So I think that is a point that perhaps they might consider when writing their paper. Another issue that I wanted to raise, now I was thinking about these things, they just escape my mind now. A question rather then will be, in their presentation, they are saying that perhaps the legal framework as it was inadequate, especially last year when we experienced the pandemic. And of course, the test that is provided for in Chapter 6 of the Companies Act, which is financial distress and reasonable prospect, it is a little bit onerous and thus inappropriate to deal with business rescue proceedings or procedures under COVID-19. What I want to ask is, what makes the test one onerous? But again, if it is onerous, what can make, or what particular test are they proposing which is less onerous? And what will be the effect of that, having regard to what business rescue seeks to achieve? I think that would be the question I would want to pose to the presenters. Thank you.
Thank you, Prof. Dr. Mudzamiri, over to you.
Okay, thank you very much for the first comment and the question. Okay, for the first comment, yes, I do agree with you 100%. And I think the last point, when we talked about the costs, we also talked about the labor courts and being specialized courts with expertise. And thank you also for the issue of the CCMA. We will definitely consider that. Then the second, the question, I am sorry a bit because I didn't get it. Can you?
No problem. I can rephrase it. In your presentation, the argument that you made, at least as I understood it, and I stand to be corrected, was that you are saying that perhaps the legal framework is inadequate in a sense that Business Rescue could not cope with the pandemic last year because the test that is proposed in the Business Rescue provisions on Chapter 6 of the Companies Act, the test is onerous. In other words, the distress test and the reasonable prospect test, it is a little bit onerous. So what I wanted to understand is if that test is indeed, or if at all is onerous, do you have an alternative test that you can propose or that you are proposing in your paper? And how, or what is that test and how will it be, or how will it work? Basically, that's what I'm asking. If you have an alternative, what is the alternative and how will that alternative work, having regard to the purpose of Business Rescue generally?
Okay, thank you very much. Yeah, thank you very much for that question. Okay, especially for the financially distressed test, we are not proposing for a totally different test, but we are proposing that the timelines that are given, that is the 6-month timeline, is quite inflexible. That is the first thing. So we proposed a period of at least 1 month or to 2 years when we see that the company might be insolvent or might be unable to pay its debts. That is the first thing. Then on the second, let me go to on the reasonable prospect of rescuing the company. We were thinking that I mentioned about 2 points. The first point being that because now companies are in an indefinite period of COVID-19, where prospects of being rescued might not be very clear because of issues like government lockdowns and COVID-19, because those companies might not be operational. So we thought, or we proposed that we should tinker around on the provisions to ensure that if a company, we can refer it to as a too big to fail, or other companies that might not have reasonable prospects in terms of the current test, should also be rescued in order for them, or should also fall under the broader term of financially or financial distress, to ensure that we do not have a lot of liquidation that will carry on. I'm not sure if I've answered you by these two or three points that I just made.
No, thank you very much. I think we don't have to monopolize the space, but thank you very much for that.
Oh, okay, you're welcome.
Dr. John, over to you.
Once again, sorry, Dr. Mzamiri, you raise an interesting point when you suggest that you want to extend the period to maybe 2 years. But you see, the World Bank's ease of doing business, I know it's been discredited recently, but they frown upon protracted insolvencies. The quicker it is done, the better it is for the country's rating. Thank you.
Okay, thank you.
I don't know, are there any other questions from the floor?
If there are no questions, Chair, may I just follow up on the important point that you have just raised?
Please, Prof.
And I think it is really important that we deal with that one, not necessarily for the presenter, but generally for the jurisprudence of business rescue, because one has to really have regard to the fact that there must be certainty in business. And the fact is, in South Africa, what judicial management has been criticized for, business rescue is going that direction. In other words, business rescue is not as effective as people thought it would be. It has actually become a very nice concept, one, to build academic careers, but most importantly, to create business for business rescue practitioners who continue to, excuse me for my language, to milk the system while companies are not saved at the rate which it was envisaged. So it will be problematic. I'm not sure if there were amendments recently. My understanding is the period of business rescue is 3 months. But if it was extended, then it will be problematic to even extend it further by even a day, because it can be extended. Currently, the Act does provide that if there is reason to believe that the practitioner needs extra time to actually rescue the company, then he can apply for an extension and he can be given an extension. But to take it to beyond 6 months to even a year, it might be creating a safe haven for at least scrupulous business rescue practitioners who are conducting this rescue procedures only to lead to liquidation. And we see more and more business rescue proceedings being a conduit to litigation, while companies are losing out, and at the ultimate end, the creditors are losing out should the process end up in liquidation. So I think perhaps maybe the authors, they would have to think carefully. I understand the sentiment behind it, but one has to balance it with where we are, at least in terms of the success rate of business rescue in South Africa. Thank you very much.
Okay, thank you.
Thank you, Prof. Any other questions from the floor or comments? If there's nothing, then I'll pass on the floor to the conference team. Thank you.
Thank you very much, Dr. Navira. The next session, which is the last session of this conference and of the day, it's session 12 that is going to be chaired by Prof. Patrick Osode. Prof. Osode, over to you, Prof.
Hi, colleagues. Good evening. Can I just confirm that I can be heard?
Loudly, so thank you very much, Prof.
Okay. Thanks to Prof. Chitimira and his team for the invite to chair this, what I consider to be the most special session of an extraordinary conference indeed. The session is obviously special because it's the last one, the final session of the conference. And I see that one of the presenters at least will be doing a vote of thanks. So it's not just all going to be academic presentations. We have 3 speakers doing presentations, and then we'll take a 4th speaker who will do a vote of thanks. And then, of course, I get to declare the conference closed, which I also think makes the session special from my side. I see that all the speakers are in. I noticed earlier that the first speaker was not in, but I see now Ms. J.A. Olufemi Babalola. Are you in?
Yes, I'm here.
Okay, hi. So colleagues, without further ado, I know it's the final session. We do want to get to close. She'll be presenting on a topic that has to do with corporate governance in Nigeria. I'm just trying to call up the topic here. So it's changing tactics in the wake of a pandemic, an examination of the legal framework for corporate governance in Nigeria. Ms. J.A. Olufemi Babalola, you've got the floor now. I'll start counting now. I'll let you know when you have 5 minutes left, And then also when you have 2 minutes left, I'll alert you.
All right. All right. Thank you very much, sir. Okay, please, I'd like to share my screen. So please, can you see my screen?
Not yet, not yet, not yet.
Okay. So can you see my screen now?
We cannot see your screen now, but you should still be able to share. You should be able to
Okay,
share.
okay. All right, sir, let me just proceed. Good evening, everybody. My name is Jojolola Olufemi Babalola, and I'm speaking from Nigeria University of Ibadan. I'll be presenting the paper written by my colleague in person of Okpeyemi Gbadegeshi and I. And I'd like to say, first of all, that thank you very much for inviting us over to present our paper. I'm sorry, I'm trying to share my screen, but it's like I'm unable to at the moment. I'll proceed to state the topic of this presentation. And the topic is changing tactics in the wake of a pandemic and examination of the legal framework for corporate governance in Nigeria. And I'll proceed to look at the structure of the presentation, look at the focus of the paper, and then I'll look at the concluding remarks. And then right now I would commence with the introduction to the paper. COVID-19, a pandemic that broke out in 2019 affected both human persons and artificial persons created by the law, that is the companies. So as a result of the alarming spread of the virus, lockdown protocols were initiated by countries all around the world and included Nigeria. And that was done in line with the WHO recommendations. So as a result of the lockdown in Nigeria, companies and businesses found it difficult to meet with their legal obligations as well as their societal expectations. Then it also posed huge challenges to the companies, their boards and stakeholders on how to navigate the difficult and the dynamic time. So the focus of this paper, therefore, would be to examine the impact of COVID-19 on corporate governance and ease of doing business in Nigeria, then the strength and limitations of corporate governance legal framework in cushioning the effect of COVID-19 on corporate governance and ease of doing business in Nigeria. And we also made some innovative, we made suggestions on some innovative strategies to cope with the pandemic and beyond. Moving straight to consider the impact of COVID-19 on corporate governance and ease of doing business in Nigeria. Corporate governance actually began as health crisis, but later it became financial and economic crisis. And then its financial and economic implication became imminent with the non-pharmaceutical interventions that had to be implemented. And one of such intervention was the strict health protocols that were to be observed, as well as partial and in some cases, total lockdown protocols that were adopted. In Nigeria, while some businesses experienced serious collapse due to low demand for their products, and a few others experienced unprecedented growth in their business as a result of the pandemic. Furthermore, on the impact of the pandemic on corporate governance in Nigeria and ease of doing business is the fact that normal day-to-day running of business were affected. Some people couldn't go to their workplace, and some people had to lock down their workplaces. And then the companies also had to divert funds to providing aids and relief support for the public, so as to assist the government. Then directors of companies were not only confronted with reviewing plan to keep the companies alive, but they were also faced with the challenge of meeting stakeholders' expectations. And we saw that in disruptions of annual general meetings. In Nigeria, there were a lot of annual general meetings that were canceled because of the restrictions on gatherings and assemblies. And then most companies could not fulfill the requirements of Section 237, subsection 1 of CAMA 2020 that mandates companies to have their annual general meeting within a particular period of time. Then the challenge also posed the challenge that the COVID-19 brought also posed it attacked kind of, let me say, it challenged the shareholder-centric approach of corporate governance as recognized by CAMA 2020. Because CAMA 2020, the corporate governance approach that CAMA 2020 actually recognized is the shareholder-centric approach, wherein there has to be focus on the interest of the shareholders. So there was a challenge as to that shareholder-centric approach. And of course, there was recognition of the importance of other stakeholders of the company. And of course, it also posed questions as to which of these stakeholders ought to be safeguarded the most during and after the pandemic. So these are some of the impacts that COVID-19 had on ease of doing business in Nigeria. And since effective corporate governance involves appropriate response to corporate concerns in assurance of the investors that their investments is productive, that their investment is protected, and that their investment is preserved, we now decided to examine the law to see whether the law actually made provisions for aids that would enable companies to enjoy some stability during and post COVID-19. And so specifically, we looked at the provision of CAMA, that is the principal legislation governing the companies in Nigeria, and the provision of the Nigerian Code of Corporate Governance. And we looked at the strengths and limitations of this law. And I will state the strength of the laws that we observed. We observed that CAMA 2020 introduced electronic filings. It also introduced electronic signature. It introduced the transfer of shares through electronic means. And so this is actually an improvement on the law as opposed to the way the former CAMA 1990 was. And also the Nigerian Code of Corporate Governance also agrees with this, the use of technology to aid running of businesses. Then section 240, subsection 1, also introduced virtual meeting. That is also an improvement and a strength to the law. Introduced virtual meeting. And of course, we can say that this is in line with the current advocacy for social distancing. However, the downside to this is the fact that this virtual meeting is only for private companies. So the law is silent as to whether public companies in Nigeria can hold virtual meetings. Then we looked at the provision of the Nigerian Code of Corporate Governance 2018. And of course, in section principle 26 of that code, directors of the companies were encouraged to come up with strategies for addressing and managing the impacts of serious diseases on the company's employees and their families. So it looks to us that that particular code is actually forward-looking because it was made in 2018. So I'll just proceed to look at some of the limitations that we observed. The CAMA 2020 did not make provision for electronic voting. And so that means that companies are still led to vote at annual general, shareholders and investors are left to vote at annual general meetings by show of hands. Maybe they have to be physically present. So we don't consider this to be good enough. Then we looked at the provision of the Indian Companies Act of 2013, and it became a point of interest to us because we saw in section 108 and section 173, subsection 2 of the Indian Companies Act of 2013, that the acts actually provided for electronic voting and electronic attendance at annual general meetings. So we thought that Nigerian law should have also considered that. However, I would like to say that the Indian position appears to be in line with the current realities, and of course can be said to be a more viable alternative to the physical gathering. Then another limitation that we observe in the corporate governance, the laws, the soft law and the hard law, is the fact that there are conflicts over whose interest directors should act. While CAMA 2020 actually focused on the interest of the shareholders majorly, the Nigerian Code of Corporate Governance 2018 recognized that they should be focused on the interest of all stakeholders. And so we feel that this could be a kind of distraction for companies and all of that, as much as they are also coping with the COVID-19 crisis. We have thought that at least the law should have been able to harmonize this so that the company will have clear direction as to in whose interest they should, the directors will have clear direction as to in whose interest they should act. So we made suggestions on innovative strategies that companies could adopt in order to cope with the particular challenge that has been posed to them by COVID-19, and of course for
5 minutes
for the future also.
Ms. Olufemi, you have 5 minutes
sir.
left.
Okay, sir. And so the innovative strategies, we suggested that there should be express provision for virtual meetings for all companies. So the provision of virtual meetings should not be limited to private companies alone. And then we also said that there is need for exemption clauses so that these companies may be absolved from penalties during public emergency periods and in the event of their inability to render their statutory required obligations as a result of supervening circumstances. And we also suggest that companies will need to explore compulsory basic ICT training for all employees. So that means ICT training or ICT knowledge should not be limited to the ICT department of companies alone. Employees should at least have basic knowledge of ICTs that will be sufficient to run the business in case of any eventualities. Then we also noted that the director should come up with effective strategies for communication, accountability, and disclosure. And this will help to douse unwanted agitations and, of course, to improve investors' concerns and on uncertainties. And it is essential to look into this because of the fact that during the period of pandemic and crisis, investors' concerns become heightened. Also, they want to know what is happening to their investment, whether the crisis had affected the company this way or that way. So it's essential that the directors come up with strategies to properly communicate. And for instance, companies could consider interpreting their report in local languages so that other person that does not understand the language of operation of the company can at least be properly be communicated to. So I'll be proceeding to just look at the conclusion. In conclusion, I will say that corporate governance is actually evolving, and we can see that already. And COVID-19 has made it imperative to change the strategies. So in Nigeria, the legal framework for effective corporate governance appears to be sufficient. However, a few gaps are surfaced as a result of the heat and the pressure that have been created by COVID-19. And so the responsibility should also not be left alone from the angle of law. The companies should also come up with strategies that would identify and understand the risk simultaneously in line with the company's financial, strategic, and operational objectives. So thank you very much for listening to our paper.
Thank you very much, Ms. Olufemi Babalola. You actually finished within time. Thank you very much. Colleagues, we'll proceed to our next presenter. I see she is in, Ms. Mopipi. Can you take the floor now?
Thank you, Prof. Can you hear me? Can you just kindly confirm that you can hear?
Yeah, we can.
Okay, thank you, Prof. The title of my presentation today is COVID-19 and the Digital Divide in South Africa, Why Corporate Social Responsibility Projects Must Be Aimed at ICT Infrastructure. So my paper really looks at corporate governance from a socioeconomic perspective. I'll just outline my presentation. I'm going to start off with some introductory remarks and then outline the purpose of my presentation, and then just highlight some key concepts that inform my presentation. I will then proceed to look at the role of corporations in society and the concept of corporate social responsibility, as well as corporate social responsibility in the context of South Africa. And then I will go on to outline why I decided to focus on ICTs for my presentation, and then I will proceed to some concluding remarks. On an introductory level, I just want to start off my presentation by saying that I am a believer that crises lead us to question. And when we ask certain questions, we are able to inspire certain change, systemic change. And the images that you see before you portray some key examples of crises that led to revolutionary change. Firstly, on the left, you'll see the depiction of World War II. The effects of World War II led to the formation of the United Nations and Bretton Woods institutions. And similarly, on the right, the 2008 global financial crisis caused major economies to form the G20. And in this regard, I submit that COVID-19 is no different, even within the context of corporate participation in the socioeconomic development of states. And really that is what my presentation is centered on. I believe that the COVID-19 crisis has highlighted some key opportunities for African states, and particularly within the context of my paper, South Africa, to really take advantage of the opportunity that has been presented by the pandemic. The purpose of my paper, which is very much a work in progress, is to add to the literature on CSR as a developmental tool in Africa, and particularly in South Africa, and to critically analyze the existing body of literature on the conceptualization of CSR and its growing relevance as a key corporate governance tool. We'll also seek to reconceptualize the role of corporations in society and how that relates in terms of the possibility of regulating and incentivizing CSR for targeted impact in the South African perspective, and in particular as it relates to ICT infrastructure. I will then proceed to my next slide. The key concepts within my presentation, corporate governance. Within this regard, I've used the G20 OECD principles as a guideline of what corporate governance entails, a set of relationships between a company's management, its board, its shareholders, and other stakeholders. And the concept of corporate social responsibility, though it's not a fixed concept, there has been some acknowledgement or a common theme that entails that it refers to a business's responsibility towards society or community while engaging in socially benefiting activities. The next concept is information and communications technologies, which are a diverse set of technological tools and resources that are used to transmit, store, create, share, or exchange information. These may include inter alia, internet, and live broadcasting technologies. The digital divide, therefore, in the context of my paper, will refer to the uneven access to or the distribution of ICTs. What is the role of corporations in society? And this has been a subject of much debate within prominent scholars in the field, and this has largely been informed by various theories of corporate governance. The main theories that have been highlighted here, although my paper goes into further detail, I'll just highlight the two main theories. Firstly is the shareholder primacy theory, which really refers to the role of a corporation in society being one of profit maximization and ultimately seeks to advance the interests of shareholders. And then the stakeholder primacy theory really looks at the corporation as being responsible for considering all its stakeholders as opposed to just its shareholders. I will just note that there is a growing acknowledgement of the corporation as an actor in socioeconomic development goals. So there's a more stakeholder-centric approach that has been taken within this field. And some authors have even gone as far as saying that shareholder primacy is quite archaic in the context of our societies today. The concept of corporate social responsibility will then be explored. This concept usually really becomes prevalent when in the context of corporate governance discourse, when stakeholder protection is a topic. And through the stakeholder approach, there has been some extensive literature on CSR that acknowledges the relationship between corporations and society, as well as the duty of corporations to act in society's best interest. I will align myself with the notion that the stakeholder approach does not seek to take away from the profit-making function or objective of corporations, but rather seeks to highlight that it should not be its sole purpose. I will also submit that CSR is a sign of a good corporate citizen, as it has been linked to maintenance of good corporate image, the maintenance or making corporations more resilient, and even profit gains, which really strikes at the debate that stakeholder-centric approach is non-capitalist. Then CSR within the South African perspective is CSR in South Africa is most commonly referred to as corporate social investment. It's not regulated except with the exceptions of the JSE requirements. It's highlighted by the King Codes, which are a form of soft law in South Africa, and provide guidelines for corporate conduct. When one looks at Section 1 of the Companies Act of 2008, it describes a for-profit company as a company that is incorporated for the purpose of financial gain for its shareholders. So one at face value would say that this definition is in line with the shareholder-centric notion, and leads one to conclude that CSI becomes an option only to the extent that it is within shareholder interests, within the South African perspective, that is. So why ICTs? I believe COVID-19 is just a form of salt to an already existing wound, not just in the South African perspective, but in Africa as a whole. So the advent of the coronavirus really exacerbated existing inequalities, and this is particularly relevant for South Africa as one of the most unequal countries in the world. And this inequality has really struck at the heart of various facets of its economy, including in relation to access to digital technologies. And this therefore makes it quite an issue that has really been exacerbated by the pandemic. And digital inclusivity is something that has been part of current local, regional, and global agendas. A few that will be mentioned will be the G20, the African Union, and even the Smart Africa Alliance, which seeks to accelerate sustainable socioeconomic development on the continent, and achieving this through particularly through affordable access to broadband and the usage of ICTs. So this is not a new issue. However, it has been highlighted by the acceleration of the fourth industrial revolution during the COVID-19 pandemic. So when you look at some of the figures here, these are some examples from the General Household Survey, the current General Household Survey produced by Statistics South Africa. You see there that there is a considerable divide or unequal access in terms of the different provinces to internet, with Limpopo having the least access to internet, with just over 40% of the general population in Limpopo having access to internet of any sort. And you can also see that internet access at home is relatively low. And this is particularly significant because internet access at home makes use of fiber technology, which is a more efficient and convenient way of getting access to internet. Let me proceed to my next slide.
Ms. Mapipi, 5 minutes left.
Thank you very much, Prof. So why is ICT development important? According to a World Bank study, there is a relationship between a country or a state's GDP and the amount of internet access within that particular state. And in the context of developing countries, it has been noted that every 10% increase in internet access leads to 1.38% GDP growth. So this therefore means that states by increasing internet access or digital inclusivity as a whole will be able to concomitantly increase their GDP. And South Africa is no exception in this regard. ICT infrastructure also encourages investment. I believe Dr. Kondo in his presentation yesterday highlighted the importance of sustainable investment in the African context. This is particularly relevant in this regard. And furthermore, the development of ICT infrastructure leads to development of other infrastructure. So it's a really key developmental tool within the African context. I will then proceed with my concluding remarks. I believe that the time for action is now. The Department of Communications and Digital Technologies have already produced a national digital and future skills strategy that is aimed at providing access to the necessary infrastructure for that enables digital skills and making sure that it is operational, secure, and sustainable. My proposition in this regard is to introduce a policy that is aimed at involving corporations in ICT infrastructure development. And the reason for this is because I believe corporations play a vital role in the economy of any nation. And in the African perspective in particular, there are not enough resources in the government to deal with all social problems on its own. And the government relies on contributions from companies in order to eliminate social issues. And one would then ask, what is in it for the companies? What is in it for the corporation? And how would the corporation remain sustainable when embarking on such a focused initiative? I propose in this regard that some form of taxation incentive, either in the form of credits or deductions, will be able to increase corporation participation in line with the particular CSR initiative for that particular period, which in this context would be ICT infrastructure. And this will enable an acceleration of change by shortening the distribution chain. What I mean by this is that the contributions that corporations already make through taxation that then goes on to the government's budget, where there are subsequent negotiations as to where to allocate the budget, you may find that such contributions are not necessarily targeted towards this initiative. And therefore, by enabling corporations to play a more active role on a practical and on the field, rather, it will allow us to cut that chain a bit shorter for a more direct impact by corporations in society. I will just finish off by saying that I believe that the COVID-19 crisis has presented South Africa and Africa in general with an opportunity to create a more resilient, attractive economy through ICT development, and particularly by involving corporations in this regard. Thank you very much.
Thank you very much, Ms. Popipi. Excellent presentation, I must say. Thank you very much. And also, again, also finishing within time. Colleagues, we have one more academic presentation, and that will be done by Mr. Albert Puja, who will be talking to business financing and factoring. Colleagues, can I ask that you begin to put together your questions? Those who would prefer to do so can place their questions on the chat platform, but we'll take questions for these presenters after Mr. Puja's had his time on stage. Mr. Puja, you're on.
Thank you, Prof. And thank you everyone for taking time to attend the conference. So my presentation is on sustaining access to finance for Africa's SMEs during and post the COVID-19 crisis, factoring to the rescue. So my topic is a bit, will I say, a drift or a move away from the discussions we've been having so far regarding corporate governance and corporate social responsibility. So it's dealing more on finance, as the chair of the session mentioned. So my paper leans more towards the theme of the conference that deals with financial education. So more or less, I'm going to be focusing on financial education that benefits small and medium-sized enterprises. So the next other issue that is covered in my paper is it reflects on how the COVID-19 crisis has amplified the issue of a credit gap in the continent, and then also how this is having a ripple effect on the African Continental Free Trade Area Agreement. I'm going to be pointing to the inadequacies of the common sources of financing for SMEs during this COVID period. And then I also identify certain environments that have been created by the COVID-19 crisis that points to the fact that we need to look to other alternatives that at the moment are not so popular, but we need to actually find ways to make them popular and adopt them. Then I'm also going to be making a case for factoring, a form of asset-based financing, as one of the financing alternatives that can be used to sustain financing to Africa's SMEs during this COVID-19 crisis in the aftermath, and it also has the potential of supporting our continental trade agreements. And then I'll also argue that my argument is a bit different from what scholars have been arguing recently. So there has been so much force and focus on the need for African countries to actually have specific laws for factoring. Or maybe because of my interest in fintech in recent times, I'm taking a different perspective. I'm saying that yes, laws are good, but there is a need for us to focus on a digital technology. So I'll be looking at online factoring platforms, as well as how we can have more factoring companies in Nigeria delivering their service, more factoring companies in Africa delivering their services through fintech. And then again, I'm going to now end up by highlighting some key considerations that should guide the adoption of digital technologies. In terms of the background that is guiding the study, again, we understand that businesses do not exist in a vacuum, right? There is definitely an environment under which a business would undertake its objectives, carry out its business operations and all of that. So again, there's usually the internal aspect of the business environment, and then there's the external aspects. So again, part of the external aspects that has far-reaching impacts on businesses is crisis. And crisis can come in different forms. It can be natural, can be health, like the COVID-19 situation that we have. It can be economic, it can be financial, and what have you. So again, we understand that COVID-19 is one of the, what will I say, one of the worst crisis that has hit mankind. And even in comparison to the 2007-2008 global financial crisis, the assessment is that COVID is actually way worse, especially in terms of its economic impact. And this has been attributed to the non-pharmaceutical interventions, the likes of lockdowns, social distancing issues, travel bans, and all of that had to be imposed in order to stop the spread of the virus. So if this happens in the business environment, it will definitely impact businesses. But the argument that we are making is that you would see a situation where SMEs are more hit more than larger firms. And why is this? So there are three reasons for this. One is that they are small, or their size. And this is attributable to they have lesser resources, less capital resources, human resources, and what have you. And then also the newness. So small SMEs most times are new. And a certain scholar said, if you're new, you're more likely to fall prey to a crisis than the older firm. And then also they have lower resilience to issues. So research has already confirmed that one of the offshoots of the COVID-19 crisis is the fact that SMEs are suffering from a shortage of finance from both internal and external sources. And the argument that I'm pushing forward in my paper is that crises such as the COVID-19 crisis have a way of exposing the inadequacies or limitations of certain forms and sources of corporate finance. So the argument is that there are some sources that are, more available, right, and more accessible than others. So if we have this knowledge, the question then is, what can policymakers do to make these more accessible and available options to be there? And then how can SMEs themselves position themselves to actually benefit from the sources? So again, we know that the credit gap is very wide. Again, before even the COVID-19 crisis, the COVID gap, according to IFC for Africa's SMEs, was around 331 billion. And this is because most SMEs are either unserved or underserved by banks and then also the public capital markets. So there is definitely a credit gap. And then the question then is, COVID has come and it has made the issue worse. So, and this is coming at a time when we are trying to implement, or we're already trading under the Continental Trade Agreement. And the effect is that if SMEs are unable to survive past this COVID-19 crisis, they will not be able to contribute to the Continental Agreement. So what are the peculiar financing challenges that we've seen with COVID? Number one is that you see banks and other non-banking financial institutions drawing their credit facilities to businesses in general, particularly SMEs. And these are for various reasons. The fact is the market is volatile at this stage, so it is better they don't lend more. So they are monitoring the market before they be putting out their resources out there. And then even if they want to lend, there will be a need for them to probably upscale their lending conditions in terms of interest rates and also collateral requirements and all of that. We know about the Basel III after the global financial crisis in 2017 to 2018. What it did was to actually make the cost of banking services to be higher than what it was. But again, that was because regulators were trying to create a more resilient financial system. So, and another, will I say, downside to bank financing is the fact that as opposed to asset-based financing, banks usually lend on the basis of traditional debt finance. So what are the differences? So in traditional debt finance, you focus on the creditworthiness of the borrower. And as we know, most SMEs are not creditworthy. So, but with asset-based financing, you're focusing on a particular asset, maybe receivables, a car or whatever. So, but the general, let's say, consensus in literature is the fact that asset-based financing is more friendly, more flexible than traditional debt finance. And factoring, before I even go to that discussion, is actually a form of asset-based financing. So again, we know the fact that another reason why there's shortage of financing is the fact that commercial activities have slowed down. There is a slowdown in commercial activities. Customers are not buying as much as they were doing during the COVID period. And it was because of the non-pharmaceutical interventions. But now again, we're having pharmaceutical interventions in the form of vaccines and what have you. And then another thing is that you'd see that the COVID crisis has also impacted, let's say, fresh investments in the capital markets. So for those of us that are familiar with business angels, private equity, venture capitalists, and all of that, you need to create a certain level of personal relationship with them before they'll be able to finance you. But what has happened with COVID is that all these, let's say, avenues for us to create those relationships were affected or impacted. So that didn't happen. So these are the various ways in which COVID has impacted or intensified the issue of financing. So again, another key aspect of a crisis generally, and we saw this with the global financial crisis, the last global financial crisis, is the fact that it increases the appetite for open account transaction or trade credits. So more or less, I want to take delivery of goods or services, but I don't want to pay immediately. I want to pay after a while. So it is a good strategy for businesses that are selling because again, you can increase your sales, right, and then be competitive. But the problem is that for SMEs in particular, if you're a supplier and you're SME and you're engaging in open account transaction, it's going to impact you in various ways. So one is cash flow. So if I give you an extended payment period of 30 days or 60 days, before you pay me, what money am I going to use to be able to undertake paying rents, salaries, and then also paying to my own supplier? So those are some of the issues. Then there's also the risk of non-payment. It's possible that I will extend you credits on open account transaction. And then when it's now time for you to pay, you will not actually be able to pay. And then definitely you need to do bookkeeping and ledgering and all of that. So these are the issues. So looking at this issue, we now understand the fact that we need to find an alternative that can substitute traditional financing, especially from banks and other sources, and then also look at the increasing appetite for open account transaction. Record has it that we actually have 90% of trade occurring on open accounts. And this is where factoring comes in. So again, not to take too much of our time, factoring is more or less assigning your accounts receivable. So if I do open account transaction, right, as opposed to me waiting till the customer pays me, I can sell it to a financial institution called the factor, and then the factor will give me immediate cash. And the factor is also based on practice required to perform other functions like maintaining ledger, collecting the receivables, and then also credit risk protection. So you also enjoy a form of, will I say, credit insurance and all of that. So this is the process flow, but I don't want to take too much time looking at that. So there are different forms of factoring arrangements. You have notification, non-notification, but I think I would like to draw a distinction between recourse and non-recourse factoring. So this is where the issue of credit risk comes in. So if you do recourse factoring, it means if by the payment due date, the customer does not pay, the factor can actually come back to you. But in non-recourse factoring, it's actually full credit risk protection, so they can never come back to you. So how is factoring useful in a time of crisis? So looking at previous crises, we've actually seen the fact that factoring sustained financing to smaller businesses. Literature has traced it to both the Great Depression and then also the global financial crisis of 2017-2008. And then also it's like a very good substitute for bank financing. And again, as I think I've mentioned in the definition, you'd see that it facilitates open account transactions. So it means it's useful for both domestic trade and international trade. So the pillars of a good factoring system is the fact that you need to have a factoring law, right? Again, you mustn't have a law before you can practice factoring. So again, you can use your common law system or your civil law system to practice factoring, but it's advisable that you should have a specific factoring law. There are some international instruments that have been developed over the years to support international factoring transactions. And then there's also the tax aspect to it. You can have value-added tax, stamp duties, registration costs, and all of that. But to have a more flexible environment, you would usually see scholars saying that you shouldn't make these, will I say, taxes and costs apply to factoring transactions. There's a regulatory framework and then also the institutional framework, focusing on issues like credit registries, again, for examining the creditworthiness of the customer, credit insurance in the case of non-recourse factoring, and then also factoring associations. We don't have so much, but Egypt has one. I think Egypt is the only country that actually has factoring association. So in terms of the current state of factoring in Africa, well, we've been growing very well, but it's not widespread. So you have South Africa as the leading market. I think South Africa, not I think, statistics show that South Africa accounts for 80% of factoring. We have other countries that are also doing well, Egypt, Morocco, Tunisia, but it's not widespread. So, but if it is good for crisis management, then definitely we need to find a way to improve it in the continent. So as I have earlier mentioned, there are certain, will I say, obstacles to the growth of factoring in most African countries. Some of the identified reasons are lack of awareness about it, absence of factoring laws, huge transaction costs, absence of facilitative institution, which I mentioned, even, let's say, credit insurance, credit bureaus, and what have you. And then you also have excessive capital requirements for fresh or incoming factoring companies. So these are some of, let's say, the challenges that have been identified as to why factoring has not boomed or grown so much as an alternative source of finance in the continent. So this is where, will I see, the novelty of my arguments comes in. So what literature has said so much or focused on so much is the fact that we need to have specific factoring laws. And
Mr.
then yes?
You have 2 minutes left, eh?
Okay, yes. So this is what literature has been saying, right? So, but again, we need to have specific factoring laws and all of that. But when you look further into literature, you see the fact that having specific factoring laws is not all that you need to grow the factoring market, right? Clapper speaks to the fact that you don't need it, even if you don't have it, you might have a law, right? But it doesn't mean that your factoring market would succeed. What is needed the most is the fact that you need to have credit information system. Another research also points to the fact that factoring can still boom in places where the legal system is weak. So based on that, and looking at the COVID-19 situation, I'm saying my argument is that we need to move towards, will I say, digital technologies to grow factoring in the continent. And there are 3 of these technologies I'm looking at. Okay, 2 basically. So one is online factoring platforms, fintech factoring companies, and then also, will I say, SMEs moving more towards digitalization as well. So in terms of how the online factoring platform works, the government is actually going to administer the platform. So it functions in the form of, will I say, reverse factoring, right? You have a platform where you link customers, SMEs, and financial institutions. So you have one that is actually operational in Mexico. I can't speak much to that because I don't have so much time. So the next strategy is the fact that we need to promote more factoring companies in the continent, providing their services through fintech. So there are 2 ways they can do this. There's a direct way in which the factoring firm simply just engages with the customer, or a peer-to-peer arrangement. And then last is that SMEs also on their part need to definitely improve marketing to secure high credit worth customers, keep proper records, and then move to online digital platform. But definitely, it's not all perfect.
Mr. Puja, please round up. Your time is up.
Okay. So in a nutshell, the argument is we definitely need to employ digital technologies in order to grow factoring in the continent, but there are also other legal requirements or considerations. One is the issue of data protection, cybersecurity, anti-money laundering, and then as well as the issue of fraud. But in a nutshell, what I'm saying more or less, we need to employ technology, and blockchain technology will actually go a long way in improving the climate for, will I say, digital factoring practice in the continent. Thank you so much, Prof. I think I should stop here. Thank you.
Okay. Thank you, Mr. Puja. Colleagues, that's our last academic presentation. We have a few minutes, I think about 10 minutes for questions. The floor is open, colleagues, for questions and comments that you might wish to address to any of the three speakers. Thank you. I don't see any questions on the chat. So colleagues, you can take, if you want to speak, please unmute yourself.
Thank you, Chair. Thank you, Professor. I just want to comment, Ms. Mapipi, can you hear me? I think you did very well on a last session. It's not very easy to present for an ALB student. I think I'm not the only one. She did very well. Thank you very much for a nice presentation.
Thank you very much, Prof. I think there's a question in the chat that has been addressed to me. I'm not sure. It's
okay, I see a question for you. So what role do you think ICASA can play in addressing issues related to digital divide and enhancing the development of ICT by corporations in SA? Yes, please go ahead.
Okay, thank you, Prof. I believe that as an organ of state, ICASA can play a very active role in terms of the practical impact that is made by corporations. In this regard, I believe that ICASA is better positioned in terms of the current infrastructure and would therefore, I mean, in terms of the current infrastructure and the state of communications technologies in South Africa, it would therefore be able to work hand in hand with corporations by highlighting the key areas that need this targeted impact by the corporations. And since this is a work in progress, I really think that I appreciate the question, and will also consider that perspective further when I'm finalizing the paper. Thank you very much, Prof.
Thanks, Ms. Mopipi. Colleagues, we still got a few more minutes for comments and questions. If there are no more, okay, there's a question for Mr. Puja. Can you elaborate more on the online platform?
Okay, so again, the online platform that I spoke to, there are two of it. So there is the one that a factoring company can privately run, but the one I'm more focused on is the one that should be administered by the government. So again, as I said, you have one operating in Mexico at the moment. So what typically happens is it's a digital platform that links three key participants of a typical factoring transaction together. So you have customers that usually buy goods or services from SMEs on open accounts as one participant. You have SMEs, right, that sell to these customers. And then you have financial institutions, or I see factoring firms that are willing to purchase the accounts receivable. So, but my argument more or less is if we want to improve the structure, especially in the African continent, we can add other stakeholders. We can add credit registries, we can add credit insurance, and then we can also maybe add like a guarantee scheme. Poland actually did that, yes, at the height of the COVID situation. Part of the, let's say, policy responses that they put in place was to actually have a guarantee scheme for factoring firms, so that when you're doing non-recourse factoring, so to say, and you're unable to collect your money from the customer, the government can support you as a factoring firm so that you don't, how let's say, go out of business. So that is how they can actually work. Thank you so much for the question.
All right, colleagues, I think we are out of time now. We should proceed now to the vote of thanks. Mr. Menelisi Ngube, I believe will do the vote of thanks. Mr. Ngube?
Thank you, Prof. Yes, we hand it over now. Before the vote of thanks, we had categories that we remember. I advertised that this year we're going to try and acknowledge the best papers, best newcomer, overall best. So we just want to acknowledge that at this time, then we do a vote of thanks. Yeah.
Prof. Chitimera, can I hand over back to you then? Thanks, colleagues. Back hand to Prof. Chitimera. Thank you.
Thank you, Prof.
Thank you, colleagues. And we want to congratulate everyone who has stayed up until this far. It has been a long 2 days of serious academic engagement, and we want to believe that everyone benefited from this conference, hoping for more to come. We have done an analysis of all the papers that have been presented. We should actually say it was very difficult to come up with the best in the 3 categories that have been mentioned. But there has to be a winner at the end of the day. So we have selected 3 per category, and I'm going to announce now, starting with the newcomer. In the newcomer category, we are starting with Miss A.N. Jonas. She got 3rd position in that category. I think she is in the University of the Western Cape with Dr. Kondo there. Then number 2, we had Miss C.N. Kasangarare from Leicester University in the United Kingdom. On position 1, it's none other than, I think, the breath of fresh air in this conference. One, Mrs. Mopipi. She did really well, especially for an LLB student. So she takes the gong in this category as our first position in the newcomer category. I would go to the emerging scholar segment. And in this regard, we have Dr. Nyaude. She takes the 3rd position there. Then we have